ತಗೊಳ್ಳಿ ಎಲ್ಲಾ ಬೆಂಗಳೂರು ಇರೋದೆಲ್ಲ ಸಿಗುತ್ತೆ
ಸರ್ ಅದೇನ್
ನಿಮ್ಗೂ ಸಿಗುತ್ತೆ
ಏನ್ ಮೆನ್ಷನ್
ಪೆಂಡಿಂಗ್ ಅಲ್ವಾ ಪೆಂಡಿಂಗ್ ಗೋಲ್ಡ್ ಬೇಡ ಬರುತ್ತೆ
ಮೆನ್ಷನ್ ಮಾಡಿ
ಮೆನ್ಷನ್ ಬೇಡ ಗೋಲ್ಡ್ ಬೇಡ
ಬರುತ್ತಾ ಥ್ಯಾಂಕ್ ಯು
ಯಾವ್ದು ತಂದಿಲ್ಲ ಸತೀಶ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಹೇಳ್ತೀನಿ ಕಾರ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಕೊಡು ನಾನು ಅವರು ಅಲ್ಲಿ ಎತ್ಕೊಳಕ್ ಬರ್ಕೋತೀನಿ ಹಾ ಸರಿ ಸರಿ ಕೊಡಪ್ಪ ಒಂದು ಟ್ರೇ ಇತ್ತಲ್ಲ ಅದೊಂದು ಒಂದು ಮೆಮೊ ಇಟ್ಕೊಂಡ್ಬಿಡೋಣ ಟ್ರೈನ್ ಅಲ್ಲಿ ಇಟ್ಬಿಟ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ ಎಲ್ಲ ಅದಕ್ಕೆ 33 ಅಲ್ವಾ ಸತೀಶ್ 33 ಆಮೇಲೆ ಪರವಾಗಿಲ್ಲ ಆಮೇಲೆ ಅದು ಕೊಟ್ಬಿಟ್ಟು
hardships kindly. Your one demolition, my lord, tomorrow is the last day. Tomorrow they are going to demolish my building, my lord, for deviation. Therefore, my request for 230, my lord, fresh matter, my lord. I have not, 2023 is the confirmation order. It was never served upon me. Now, my lord, on 5/3, they have served on 356 notice to me, asking the tenants to vacate. I have sold the property in there 2022. I have obtained the plan in 19.
230.
ಅಲ್ಲ BBMP roaster ಬರೀ demolition.
Lord,
230
this is with respect.
230. That is it, sir. Yes, much.
Lord, no confidence meeting is scheduled to be held on Monday for the petitioner, my lord. I am the president. It may be taken up tomorrow. Please, read.
Yeah, I told them to serve a copy to me.
One extra copy.
Kortin, please.
As directed.
No confidence motion. The notice issued is not there.
So when do you want?
Not there. That's today or tomorrow.
Tomorrow, just give an extra copy to the.
Yes, sir. I will give it.
Do ಇನ್ನೊಂದಿದೆ ನೋಡಿ government. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಇನ್ನೊಂದಿದೆ.
As directed.
May I please your worship? Lord, one matter had come up for orders yesterday, my lord. It was listed in list 2. Unfortunately, my lord, I thought 92 matters were there. I came immediately after 91, 91st. Your lordship may kindly post it during next week, my lord. The matter is question of demolition. Illegal construction is admitted. Nothing in this.
For
Date-
writ of mandamus, my lord.
a date may kindly be.
Of mandamus, my lord,
Parade.
also is required to be issued. Notice
Correct.
ordered, my lord.
Correct.
Respondent appeared, my lord, here for
25th.
disposal file.
25th.
Serve it on the
25th.
during the course of the
My lord,
My lord, this pending case, my lord.
pending case.
Kumar, please,
Serve the other side so that they know it's coming.
please, my lord.
Course of the day, due to the court of.
Please. Please.
for writ of mandamus, my lord.
Tomorrow.
Your lordships,
For tomorrow, my lord, it is for,
Pending matters,
Yes,
you
yes.
serve it on the other court.
Please.
And during the course of the day, give to the court.
served on the other side, your lordships.
Direct cases. Fresh matter. Serve ಮಾಡಿದ್ದೀನಿ other side ಗೆ.
ನಾಳೆಗೆ ಹಾಕು.
Adjournments, list 1, page number 1, 1 to 4, page number 2, 5 to 12, page number 3, 13 to 19, page number 4, 20 to 25,
Say number 24, please, my lord.
24.
24. NOC ವಕಾಲತಿ ಹೀಗೆ ಬಂದಿದೆ, please. ಮಂಗಳವಾರ please, ma'am.
You appear for the petition.
Petitioner, please. I have 10 NOC ಬಂದಿದೆ.
Just inform the other side.
Please, please.
Realist
ಮಂಗಳವಾರಕ್ಕೆ please, ಮಂಗಳವಾರಕ್ಕೆ.
on.
25th.
Yes.
ಮಚ್ಚು please.
Page number 5, 26 to 28. Page number 6, 29 to 32. Page number 7, 33 and 34. Page number 8, 35 and 36. Page number 9, 37 to 40. Page number 10, 41 to 44. Page number 11, 40.
For
41.
petitioners minutes.
At request. Relist the matter. Week after next date could you, but construction has stopped. Construction has stopped.
It's actually old building, my lords.
Let us,
It is as it is.
week after next date could.
Interim order may be extended, my lords.
Model earlier grant is extended till the.
8th of April. Page number 11, 45 to 47. Page number 12, 48 to 50. List to 2. Page number 1, 1 to 4.
Serial number 1. In serial number 1, for the respondent, I want to file my statement of objection. I already informed the petitioner counsel also.
At request, relist the matter.
I
on
appear
date.
for petitioner, my lord. I appear for petitioner.
Relist the matter on date. could.
10 days.
2nd of April.
Yes.
Please.
Please note, 2nd of April, my lord.
Page number 2, 5 to, page number 2, serial number 5 to 8. Page number 3.
my lord,
Right.
pass this number to serial number 8, my lords. I'm for the petitioner.
the simple matter for direction to the panchayat. They filed their statement of objections. I want to file rejoinder, my lords. Couple of weeks, my lords. I've informed the council for respondents.
That request relist week after next.
Grateful.
Page number 3, 9 to, serial number 9 to 14, page number 4, 15 to 19, page number.
Serial number 18. I'm representing the petitioner. For 2 weeks, I already informed to the other side.
List after 2 weeks at request.
Page number 5, 20 to 22.
At request relist the matter.
Page number 6, 24 and 25. Page number 7, 26 to 30. Page number 8, 31.
Last year kindly fresh matter public auction tomorrow.
Yes. List 1, fresh matter, serial number 1.
My lords, as
Shankar Reddy.
submission, my lords. My lords, this writ petition number 12345/2023. That is only with respect to release of the death benefit.
Huh?
Death benefits. It's a writ of mandamus, my lords. So, not
Serve
in-
old matter.
old matter, my lord,
Serve
2020.
serve it on the other side
Okay,
and during the course of the day, give it to the court officer.
okay, okay.
Date will be assigned.
Yes.
List 2, serial number 5, my lords, a request for a week's accommodation. Heard for quite some time. We were asked to inspect the site as such.
Inform the other
I'll
side.
inform Mr.
Relist the
Sorry.
matter on.
Second half.
Public.
For petitioner.
List 1, fresh matter, serial number 1, Shankar Reddy. Pattegoda.
As per annexure A, petitioner purchased property during 1956.
Take out notice, take out notice.
Ida. List 2, serial number 5.
This one number 1 is private.
why people should take plan? This-
Yes, sir.
Now suppose
Yeah.
you have a provision which says like that, why people should take plan? Why demolish?
It's apparent to them that
Huh?
if there is a provision, we won't take it. But
So
in
where
the
is that,
act,
huh?
in the act, it is.
The application is at page number 33, my lords.
30?
Hmm.
Then counsel for the petitioner submits. Application has been made under section 240 subclause 8 of the BPMP Act. And petitioner is awaiting necessary action from the respondent BPMP. Also, petitioner further submits that no further construction would be put up till the issue is resolved.
I
Necessary
will not
affi-
even occupy, my lord. That also may. I will not even occupy the premises.
Till the issue is resolved, necessary affidavit to that effect to be filed within 1 week. In light of the same, there would be stay of
Annexure A, my lords. Order passed by the commissioner.
and then which is the 248-3 order,
Annexure A and Annexure B, my lords. 248.3 is Annexure B.
annexure D,
Annexure D, my lords.
annexure A and annexure D. Relist after 4 weeks. Date code after 4 weeks.
15th of April.
Now meanwhile, you look into that 240 subclause 8, whatever you want to do, you do.
Yes, my lords.
Yes. 5. B.S. Basavaraju. Serial number 5, B.S. Basavaraju.
I am the purchaser of the property.
No, but there is an alternative remedy, isn't it, against this order?
Already the Honorable Court passed the order, my lord.
No, I'm saying, huh?
Honorable Court already passed the order
What?
to verify and to issue the digital form 3, my lords.
Correct, huh? Now they've given one detailed,
Endorsement.
they're saying there is no identity, isn't it?
My lords, the property was purchased through the auction from held by the Tashildar, my lord.
No, now you go to the endorsement. Go
This
to
one,
the
my lord.
endorsement, page
68.
correct. If you look at 67,
Yes, my lord.
they've given A to E. Isn't it? So the grounds are not properly surveyed nor identified by ADLR. Survey must be conducted in presence of Tahsildar, Madikeri, etc. They're saying identity is not,
That's what, my lords.
uh,
The same was purchased through the auction held from the Tashildar.
government,
Iti
auction,
Madappa.
government auction.
Also, government auction, we have purchased the property.
Government or municipal authority?
Government auction, Tashildar conducted the auction. From the Tashildar, A.T. Madappa purchased the property.
Sales certificate do you have?
Yes, my lord, I purchased. What is two sale deeds, my lord? One is A.T. Madappa purchased from the auction and from the Tashildar, from A.T. Madappa I purchased. They have issued the form 3, my lord.
Government look into it.
Yes.
They have already issued the
But
old form 3, my lord. Manual form 3.
Endorsement says that, my lord, the sale, the boundary shown in the sale deed and also whatever the photograph produced by the parties, it doesn't tally with
Tally.
each other.
So you get instruction.
Yes,
If it can be resolved, then let us.
yes, I'll secure instruction.
AG is directed to accept notice for respondents 1 to 4. Madikeri Municipal Council,
Anusuya Devi.
emergent notice to 6 and 7. Petitioners at liberty to take out notice by way of hand summons, as well as serve the standing council if any for 5 and 6. This is the matter. Week after next.
6. Jagdish DC.
Preparing for petitioner. Petitioner is a trust matter, is called, see, they were a trust,
Yes.
not
Now the lease,
a temple.
correct, lease was
Lease.
for 5 years only,
Initially for a period of 5 years, that has expired. The trust has, petition has filed an application for renewal.
correct?
Application is pending. Endorsement is also
Jagdish.
issued.
Jagdish, one question.
Please.
2011,
Notice only.
isn't it?
Yes, ma'am.
2011,
Please, did.
plus 5 years, 2016.
Yes.
How many years? Now you're almost 10 years after that.
Petitioner has made number of representations. They have issued an endorsement. stating
Anyhow,
that,
you look into it.
Alla,
Temple,
temple is in existence. That
No, no,
can-
correct. That's up to the BBMP and the God. I'm not going to come in the way. You want to give, you give it.
but,
They're asking for renewal, you find out.
Yes, sir.
but
Lease has expired 10 years back.
Now they
It's
are
up to
new.
you. You want to renew it, renew it.
they are
You
new
take a
rules.
decision.
They are
What is the rules now relating to renewal of
lease.
BBMP property you see? And then you see what is to be done.
There are new rules 2024 property estate management rules. My lord.
According to which, what is the procedure?
There are many restrictions, my lord. If the government approval is to be taken for more than 10 years.
Okay, you follow it.
I will
Now
just
they want,
take instructions as far as
Ah.
their case is concerned. I will take.
so you process it
It's a
as
process.
long as it is not prohibited. Suppose they say there cannot be renewal, you have to public notice, whatever procedure, you follow that procedure. If it is prohibited, then you take your step.
Yes.
Pawan Kumar accepts notice for respondents 1, 2, 3. Relist the matter week after next
Yes, ma'am. Week after next, date means.
in the orders list.
Yes.
Orders list.
Till such time, let the BBMP officials or some private person, let them not disturb the usual puja and other. It will
Nobody-
give- it's a
nobody-
wrong signal to the general public.
Nobody will do anything for a temple. Forget about that.
ಆದ್ರೂ ಕೆಲವರು
Huh?
ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ದಾರೆ ಸಮ್ ಆಫ್ ದಿ
ಏನಾಗಲ್ಲ ಯಾರು ದೇವಸ್ಥಾನ
ಅಲ್ಲ ಅದನ್ನ ಸ್ವಲ್ಪ ಇಂಟ್ರಿ ಮಾಡಿ ಅದೇ ನಾನು ಕೇಳೋದು
God does not need any interim protection.
ಅದು ಆಸ್
Yes,
ಯೂಶುವಲ್
next.
ಪೂಜಾ ಅಂಡ್ ಅದರ್
No.
ಫಂಕ್ಷನ್ಸ್ ಲೆಟ್ ದೆಮ್ ಗೋ ಆನ್ ಇನ್ ದಿ ಟೆಂಪಲ್
Who is going to do anything?
ಅಲ್ಲ ಯಾರು some people but 15 days back they troubled the petition on the ground that lease has expired.
Then let us see.
ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ದೇವಸ್ಥಾನ ಇದೆ ಅಂದ್ಬಿಟ್ಟು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ದಾರೆ
ಯಾರು ಏನು ಮಾಡಲ್ಲ ನೋಡಿ.
ಅಲ್ಲ ಅದು ತಮಗೂ ನಮ್ಗೆ ಗೊತ್ತು ಬಟ್ ಅಲ್ಲಿ ಕೆಲವು ಸರಿ ಆತರ ಆಗಿದೆ
No,
ಇದೊಂದು
what-
ಆತರ ಇನ್ಸಿಡೆಂಟ್
Is anybody going to demolish it? Is a notice given for demolition? No.
ಕೊಟ್ಟಿಲ್ಲ
So let them consider it week after next date. Yes.
till such time let them not disturb the puja and other functions that is the prayer. Let it go on as usual.
No, how it can
ಅಲ್ಲ
go on?
ಡಿವೋಟಿಸ್ ಗೆ ಇದಾಗತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ
ಅಲ್ಲ, you have to close down. 2011, 2015 expire ಆಯ್ತಾ? 10 ವರ್ಷ ಸುಮ್ನಿದ್ದೀರಾ?
ಇಲ್ಲ
You-
ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ತಾನೆ ಇದೀವಿ
Then you wait.
ಕೊಟ್ಟಿದ್ದಾರೆ
Correct. There is no apprehension.
ಕನ್ಸಿಡರ್ಡ್ ಗೌರ್ಮೆಂಟ್ ಮೇಲೆ ಪ್ರಕಾರ we have to wait ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ
Correct. Then let them come and say, then I'll consider. If there's a prohibition, I'm not going to give protection. Let them come and say. Yes.
7th, R. Shashikumar.
Pass on.
8, Shankar Reddy.
The respondent number 2 putting unauthorized construction without obtaining sanction plan and license. And even a portion of petitioner's property also trespassed and complaint as per annexure A complaint.
Take out notice. PDO,
And
Kurali Chikkanahalli, Gram Panchayat. MS Devraj for first respondent, emergent notice to second respondent. List a week after next in orders list. Date.
3rd of April. 9, Mahesh BJ.
Like initially for 2016.
Just 1 minute, just. Is a Hindi bill. Hindi bill, thanks for the interim order for spot inspection article. Pawan Kumar. This is number 9, right? We used to earlier pass in the previous roster, in case there's a difference in the measurement.
Yes, sir.
Like here you go to annexure B. Go to annexure B.
8 data, 3rd of April.
Now, if you look at the
ಇಲ್ಲಿ.
page 12, if you look at the as per return file, as per report of revenue inspector, tenanted 15562, here it says 28980. So last time we used to order for spot inspection in their presence,
In the.
and then let a report come. And then Mahesh will undertake to file in terms of the measurement.
Measurements.
You must
In
do
fact,
it in terms of.
50% I already deposited 68 lakhs. 1 crore 28 lakhs is the demand. Because they came for locking the premises, so we had no other option. 28 lakhs was paid
So
on.
correct, let them measure it in.
Yes, my lord. At our presence, let them do.
And then whatever follows, you must
Yes, yes.
fall in line.
Yes.
It is petitioner has challenged the revised demand notice at annexure A. Peruse the show cause notice for the revision of demand. It is seen that in terms of the inspection, there are discrepancies as regards the area and occupation of the tenant between the details declared while filing the return vis-a-vis the report of the revenue inspector. Accordingly, the respondent BBMP to measure, to inspect and measure the premises under different categorization in the presence of the petitioner. Petitioner to be present at the site on
Any date, maybe. Date and time, maybe.
date and time
6th. Okay, 6th.
at 11:30 AM.
Yes.
After such inspection, report to be filed within one vara on 7th of April.
Let them not precipitate till then.
Pawan Kumar accepts notice for the respondents. For the respondents. Respondents not to take any precipitative action pursuant to annexure
Annexure
A.
A, my lord.
A till the next date.
Serial number
May
10.
I make one submission? 13304 of 24 was filed, which is pending before this honorable court with respect to, that was demand only with respect to 1617. That matter may also be tagged along with this. WP
List
13304.
along with WP number
13304 of 24.
Applying for the
10.
petition. Preliminary hearing. We are innocent advocate.
yes, who appears for
For the
BBMP?
petitioner, my lord.
Notice is to be served.
Ah.
Notice to
Sir,
be ordered.
Counsel Pawan Kumar accepts notice for the respondents. You find out
Yes, sir. Copies. may be
huh,
served, I will.
copies to be served on counsel for the respondent.
My lord, copy is served, madam.
Their KAT appeal was dismissed for delay. In 2019, KAT order is passed. It was dismissed on the ground of delay, that they challenged that 321 notice with delay of 1.5 years, whatever. Subsequently, they have challenged this, and it is lying in the cold storage,
My lord,
lying in cold storage for 5 years.
my lord, we are the NOC advocate, my lord.
Huh? No, that's okay. So you find out week after next.
My lord,
in
we have
orders
a
list.
small submission to make, my lord, making a fair submission. In the meanwhile, 11927 was filed by one of the neighbors in this very honorable court, wherein they have got directions to take steps accordingly. That is to say that the petitioner here has been placed in a position of disadvantage. Now, my lord, subsequent
1927 of
2024, my lord.
2024.
Yes, my lord.
Ah.
So subsequently, 8 weeks time was given in that regard. And due to some technical issues, the previous council could not engage, and that's why we have come on record. And subsequent to that, they have given this notice to the petitioner. The memo has been filed in the filing counter this morning. And if my lord can appreciate this, we would like to present this before the court hall as well. So they have given a show cause notice to the petitioner. So we pray that this be stayed, my lord, in the meanwhile.
Not after 5 years. But why this petition was not moved for 5 years?
There was a miscommunication between the advocate and the petitioner. We have the reasons we have been kept in abeyance regarding that, my lord, but this honorable court was generous and grateful enough to recall and.
I am not generous. No, but what are you going to do? Are you going to remove some of the deviation? Are you going to regularize some of your deviation?
Yes, my lord.
Huh?
Please, my lord. Time may be given for the same, my lord. My lord, sanction plan here, my lord, if you appreciate the fact that the sanction plan, ground floor has been sanctioned 103.75 and first floor 103.75, my lord. However, second floor, there's only be allowed to construct 50% of the built up area. And this has caused the major deviation in this case, my lord. If my lord, you permit to amend the sanction plan, my lord, it would be time may pay for the
I
same.
cannot permit the order for amendment of sanction. Modified. Let us see. I'll have it next week. You
My lord,
find-
direction may be given, my
Let
lord.
them give a copy of that memo and all, we'll just find.
If the FAR is limited, how you can amend the sanction plan? Let's assume that the FAR is 1.5. You can't amend the sanction plan beyond that. You'll have to do only within the.
My lord, there is no additional extra floors built in the premises, it's real property, my lord. And the neighboring property in the same area is
No,
also having the.
correct. Now you try to rectify whatever is possible.
Yes.
You appear.
My lord,
before them,
direction may be given.
You appear, no, you ask your client and then you appear before the BBMP. If you are going to rectify, they will take note of it. Next week we'll have it.
Yes, Mr.
My lord, if this honorable court may permit to refer the matter to the KAT tribunal and
No, counsel, not so easily.
much obliged.
You try to rectify whatever is possible. They will see whatever is possible. If you are willing to rectify it, I'll fix a date, you go before them and you see whatever is possible, you rectify it.
Much
Whatever is not possible, we'll see. Learned counsel for the petitioner submits that they would appear before the
AW.
AW and explore possibility of removal of deviated portions. Full stop. In light of the memo, the order passed under 356 subclause 1, same would be kept in abeyance till the next date. Petitioner to appear before
Monday, 24th, before the assistant concerned at AW.
concerned AWE on date and time put. List after 3 weeks.
Much obliged.
A date may be given after 3 weeks, otherwise.
Date put.
21st of April. 11.
Much
Veena
obliged.
Kumari M.
Here for the respondent. My lord, already we have given the copies of the petition they have asked. Only this.
It requires some written stand by them. Let them examine it.
Much of it.
My lord, so there is already decision given by this court, my lord, as per Annexure D. Way back to 18 itself, there is a direction to the corporation. They might have filed a contempt petition as against the
Because
order.
it is time bound limit, my
Second
lord.
petition is being filed before this court, my lord. Annexure D, my lord, page 25. For the same relief, they filed it. The same was allowed on 10th July 2018. The BBM has not considered. They have to have been filed a contempt petition as against the corporation.
Here we would have filed it because we cannot file after 1 year, my lord.
So you
That's why
take
we
a
have-
stand in writing.
Then I will subsequently dispose of with observation to consider the presenting given by the petitioners.
My lord,
That may, I don't know if it's permissible, so you.
That is the
take a
reason I'm
stand.
making submission.
Huh?
That is the reason I make a submission so far Annexure D is concerned.
Annexure E.
D.
D, my
Page number 25, my lords. Operative portion, page 31.
So it's not yet considered.
not yet considered, my lord. We
What
could
was
not
your request?
Request, my lord, a portion of the land has
Extra-
been utilized.
Extra area.
Yes, the portion of the land, it has been utilized by the BBMP for formation of a conservancy, my lord. That land they had to compensate, my lord, with an amount or with an alternative land, my lord. So we have made a representation in 2015 itself, my lord, and also in 2016, 15 December, my lord.
Shall we dispose it of fixing a time limit?
My lord,
Or
they
we-
will,
Or we'll keep it pending and you take a decision on that. We'll keep it open. You take a decision.
Instead of it, my lord, it's better to dispose of it, the direction to the concerned officer take
My lord,
decision
what will happen,
in
my
a
lord?
compound manner.
Again, my lord, they will not consider within a time, my lord. Again, I should file a contempt petition, my lord. Because they have not considered within a time, my lord, I could not file a contempt petition because 1 year was expired, my lord. Hence, I have filed a second petition giving another notice, my lord.
Lord Counsel Shri N.R. Jagadishwara appears for the respondent BBMP. Pending further consideration, noticing that this is a second round of litigation. As on an earlier occasion, petitioner had approached this court in WP 27345 of 2016. The respondent BBMP to take steps for consideration of the representations. Relist the matter after 2 weeks. Relist the date code in the preliminary hearing list. Now, Jagdishwar, all the BBMP councils must come up with some system of regulating this. Every third petition is on without plan. Forget about deviation, without plan. Deviation also stage by stage, there must be some inspection. One of your colleagues was mentioning we don't have enough engineers to inspect. So that must be done at the cost of the landowner. You can have outsourced engineers at least that after laying foundation as per your law at every stage that you inspect it at their cost. You can have a engineer.
I'll bring it to the notice of the chief commissioner, my lords.
You work out something.
Please.
Because some permanent solution we'll see. At
Yes,
least
yes.
with respect to buildings that
In
are
fact, by
considered-
virtue of the recent amended act, my lord, the under 356, there is a direction to the concerned engineer. If any latches on the part of the concerned engineer, they have to take action, even apex court judgment, recent judgment. We're bound to take action with them. But we are at it, but thing is, my lord, there is, of course, there is a shortage of hands in the.
Correct. So
engineers.
you give one proposal, which we will take note of. You give one proposal at least, like direction may be passed in these terms. At the cost of the owner,
Owners.
you can employ, I will permit as a commissioner of the court or otherwise, at their cost. You engage somebody
Please.
as a outsource, recover cost from him.
Please, my lord.
Or let his architect give certificate after every stage, plinth, foundation, etc. as per. So you give one draft.
Please, my lord.
In an appropriate matter, you can pass some.
Please. Date of good, sir.
3rd of April. Serial number 12. Sharif.
Query for the petitioner.
Tips 12, I received the file only yesterday evening, my lords.
Yes.
Kindly grant me a week's time. I undertake to appear for the BBMP.
Already it's been a month since they have been.
Yesterday evening, they gave me the file, your lordships.
Learned counsel so and so undertakes to appear for the respondent BBMP office to show the name of so and so as representing BBMP and to strike out and to delete the name of learned counsel BS Karthikeyan. Now they are seeking for Khata on the basis of sale deed.
Yes, Your Honor.
So I'll fix a date in preliminary hearing list. You get preliminary instruction. If it's only on the basis of a registered document, then you can take some time and
Yes.
relist the matter in preliminary hearing list on
3rd of April.
3rd of April. So it's a registered
It
instrument.
may be on 4th,
Huh?
Your Honor.
4th.
Please.
4th of April.
Yes.
It's much obliged.
Grateful, my lords.
13. Right now, why?
For the
Open.
record number 2 minutes.
Query for the petitioner, my lords. I may request a password of 230.
Pass over.
In this matter, last time my lordship have said that a provisional order is passed, but in this, so that we can give them an opportunity to file a reply.
Yes.
But it is not the case. Even demolition order is also passed, my lordship. So objection is supposed to be filed in this. I pray for 2 weeks time to file an objection.
There's some urgency in the matter, my lords. Senior will address arguments.
Just wait. If you're getting relief, why you want your senior?
Well, it's,
So now you're saying that they were served with.
So what has happened is, my
248,
lordship, the petitioner who has come before the court is the owner. They have entered into a lease agreement with respondent number 4, Gale India Gas Limited. They are putting up construction there in terms of the lease deed,
The fourth respondent.
both respondent.
Ah.
So all the notices are served to the
Second respondent.
second respondent.
Ah.
So all the notices are served to the second respondents only.
Ah.
Petitioner's grievance is that no notice is served to the owner. We have served it to the respondent number 2. Our contention is that as per section 248, the notice may be served to the owner or builder of the building. So as per the lease deed,
240?
248.
Ah.
It says that provisional only. See, 248 subsection 2 man.
Yes.
The zonal commissioner shall serve a copy of the provisional order made under subsection
Owner
1
or builder?
on the builder of the building. So we have served to respondent number 2. As per the lease deed, they are putting up construction over the property. So their grievances, it has to be served to the owner. Our grievances that what we are saying that it is served to the builder of the building. So in regard to that, I will
The
file.
builder has not challenged.
Builder has
I-
not challenged.
I appear for the respond number 2. I'll make my submission minutes. If my lords comes to page number 19, that's the layout plan given by the BBMP, executive engineer itself. That has been sanctioned by them at page number 19.
No building permission is obtained.
I'll just make my submission.
That layout plan is given, but building permission is not given. Manager. It has to be obtained by the town planning member.
No, man, it's given by the BBMP itself. The seal may be seen in the page number 19 of the writ petition.
Road infrastructure. The sign is of the executive engineer road infrastructure, but the plan has to be obtained from the town planning department.
It's their department. The BBMP has given the plan.
As per the rules, sir.
Please, ma'am.
Huh?
As per the rules, town planning people has to give, my lordship. Assistant director of town planning or joint director of town planning has to give. He's not the competent authority who has signed it. That is also one of the questions which is to be answered in the statement of objection.
My submission is this, my lords. They have issued 2
Let us
notices.
see. No, correct. So we'll have to hear the matter.
My
But you
submission
can't
is-
go on construction. You'll have to wait till it's
Construction is
resolved.
not-
Only the submission is this, minutes. Their contention is that we have encroached the road. The property belongs to HMT. The entire property belongs to HMT. In this regard, there was a PL filed before the
That I've seen. Now that is closed, no doubt.
submission is this, my lords. Let them come tomorrow and earmark that what is the encroachment I have done. I'll not touch the encroachment, and in the rest of the property, I'll construct it's just a canopy. I'm not constructing anything. Any day it can be taken off.
Where is the notice?
As notice is at C, my lords. Annexure C.
Annexure E.
There are 2 notices, my lords. One is annexure E and one annexure C.
So which is the last of the notice?
Last notice is annexure E. First, they say that I have not taken.
Correct. Read the relevant paragraphs.
Paragraph number 1, my lords.
Yes.
Last line says that ರಸ್ತೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ವಿತರಣಾ ಘಟಕವನ್ನು ನಿರ್ಮಿಸುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. This is the violation they are saying. Let them come tomorrow and show where is the violation. If there is a violation, I'll leave that land and construct in the other property. It's a large extent.
That can be done.
That is
Our
our
ground is,
submission.
our ground is that is no permission for building is also granted.
I'm not
Although they are relying on that layout plan.
which the
But,
BBP has given.
but my instruction is that no competent authority has given them permission to build anything.
So that is the procedure
That
that
is-
you are following in all matters.
In all matters, town planning people only give the plan, my lords. He's the executive engineer road infrastructure, but in what in what circumstances he has signed, that is to be found out.
Okay, let them give it now. Let them give fresh one, you consider it.
Then in this
And
matter,
we have-
demolish,
We have to
demolish,
file in the
Ju-
petition.
Just
demolition order, everything is passed, my lords.
correct what I'm saying.
There is nothing to demolish.
Just what I'm saying. Now, it's still at the initial stage, isn't it?
I have not seen the photo.
Now, how much construction has taken?
No construction,
Okay, just wait. So,
plain land.
so what you do, now, according to you, it is not, permission is not granted by the competent authority. Let them make it. You consider it, and there ends the matter.
I have in fact given them the application also in the year 2024. Till now, they have not considered that.
So let them,
As
you
far as
you
it-
take instruction.
Road encroachment is also concerned.
Correct. So
Is
insofar as road encroachment, they will leave apart that.
If
Let
there's
them-
an encroachment.
No, that now, I don't know how it's going to be decided. if there's an encroachment or not. I'll ask him to appear before you. You listen to him and see if it could be demarcated. If there's an issue, let him take a call whether he's going to leave open some portion and remaining portion is going to get a plan. Insofar the second part of getting a plan, he will apply to whichever authority you say is the competent authority. And there it could end. So I'll fix a date, let him appear before
Yes,
you.
that can.
And we'll.
Lords, if
The
I may,
petitioner,
Lords, if I may just
second
request,
respondent. Please, so appear before the first respondent. On, date, you give it.
Next week, any day.
On 27th. He lists the matter in the first week of April.
Let him appear before the executive engineer, my lord.
The second respondent to appear before the
Concerned executive engineer.
concerned executive engineer BBMP. Relist the matter
Lords, may
of April.
one submission, my lord.
Yes.
Certain documents we wish to place on record, if it may be passed to a subject to your lordship's convenience.
No, let us see, but let them appear if it's going to be sorted out. There ends the matter.
This
The
is a- this is a
contention-
private fight. It will not be sorted out because of simple reason, Manoj. There is a private person involved. So he is not allowing the BBMP to either grant the permission or to come and demarcate. We are all saying that, okay, come to the property, only show that where is the road. If they say that here is the road, let them show where is the road.
I will instruct.
They are not doing it. They don't want to come to the property. They don't want to inspect the property. Sitting in their office, they are issuing the notice saying that there's a road.
Will only delay the matter further,
And
my
there
lords.
was a joint
Right,
inspection
okay.
conducted by the BDA and BBMP, where the BBMP has only given a report that it's a private property belonging to the HMT, there is no road.
Okay, pass over. Let's see what
Obliged.
they're going to place. Pass over.
Fourteen.
Yes,
Serial
I
number 14,
appear on
Raja
behalf of the respondent. Copy of the writ petition has not been served upon you, my lords.
Petitioner to serve copies of the petition and the respondent list week after next.
Obliged.
Yes, next.
15.
Respondent. For petition, man. Writ of mandamus, man. Only weeks accommodation. ಯಾಕಂದ್ರೆ ಖಾತಾ ಮಾಡ್ಕೋಸ್ಕರ. As per the annexure C ಪ್ರಕಾರವಾದ man.
Khata on the basis of
Sale deed, my lord.
relist the matter in the preliminary.
And also one submission was. Kindly see the annexure C ನಲ್ಲಿ executive officer order ಅಲ್ಲಿ subject outcome ಮತ್ತು suit ಅಂತ order
Then
ಆಗಿದೆ.
you file your statement.
Yes, Manoj.
Statement of, in light of proceedings, in light of proceedings at annexure C, respondent to file statement of objections, list the matter week after next date hood.
8th of April. 16. Ajit Shetty.
Yes,
Also in this matter, my instruction is when notices were served to the security guard. The confirmation order and the provisional orders are pasted, my lordship. So if they are saying that it's not served to them, liberty may be given to reinitiate it or to take fresh action, my lordship.
reinitiate or to reinitiate from 248(1).
Yes, sir. I leave it to my lordship. Anything is.
No. Now suppose we were to set it aside, it will reinitiate from 313 notice or what stage? Now you
Because
have
there is a
some.
sanction, there is a sanction plan, my lordship.
Ah,
So
so then 248(1).
One.
If you find that there is a
If there is a deviation, something we can initiate fresh action.
248(1).
One and
Please. In fact, Manoj, we have made a statement
Ah,
that there are a few deviations. Page
Ah.
7 of my petition.
ah.
Manoj, we have made a statement that there are a few deviations, Manoj, which are within compoundable limits. Of
Hmm.
course, that is a separate remedy, Manoj. We have put on notice, Manoj, we'll seek appropriate remedy.
if that they can remove that deviation or they can get it
We can seek
modified.
regularization and it comes well within the FAR is what I'm doing.
The proceedings under 248 weeks.
Yes, sir.
One C.
The petitioner has sought for setting aside of the order at annexure D, which is a demolition order passed under section 356 subclass 2 of the BBMP Act 2020. In the case of the petitioner, that the order for demolition ought to have been preceded by proceedings under 248, and petitioner has no notice of any of such proceedings. And accordingly, it is submitted that the order of demolition requires to be set aside, as also other proceedings conducted under 248 without notice to the petitioner. Counsel for the respondent, Sri Pawan Kumar, submits that notices as regards proceedings under 248 have been served on the security guard. Taking note of the consequences that follow from order under 248(3), it is appropriate that the respondent BBMP is to redo the proceedings under 248 with notice to the petitioner, as is permissible under law. Accordingly, the order at annexure D is set aside, as also all proceedings under 248 instituted hitherto as referred to in the demolition order are set aside. Namely, provisional order passed under 248(1) and 248(2). Other details is the third, second paragraph, provisional order, as well as order of confirmation under 248(3), so and so, are set aside. The respondent BPMP is at liberty to recommence proceedings under 248 as per settled procedure. All contentions are kept open. Accordingly, petition is disposed.
Great. So great.
Arjun. 18, Sangamesh RB. Serial number 18, Sangamesh.
This is covered by judgment.
PG is directed to accept notice.
My lords may kindly dispose it off because
1 to 4. 1 to 5. City Municipal Council, Jagalur.
well, in those petitions, Mahesh Uppin has appeared in those petitions.
18.
21, 18 also. Uppin.
I have
Accept.
Yes, madam.
So and so
Right.
accepts notice
Yes,
for respondent number 6.
6, madam.
6.
18 and 21 both.
Have a look at this and come back. We'll have it on, when do you want, if they're saying it's covered.
There's serial number 21 as well, my lord.
Ah.
It's same matter, my lord. It's covered by judgment.
We'll dispose
They
it
have
off.
appeared in all the other matters.
We'll
also.
dispose it off.
Yes, ma'am.
So what
The
is
only
the
thing is,
order
must
passed?
let them follow the procedure of law in case.
So
they
what is
want
the,
to-
just take me through the operative portion.
Yes. please.
Paragraph 3, is it?
Paragraph number 2, my lords.
Huh?
2.
Read.
Sorry, 3, my lords. Learned counsel to the petitioners argue contending that authorities
No,
cannot.
you're reading at para
3, my lords, page 25.
25.
Page 20.
Ah.
Learned counsel for the petitioners argue contending that the authorities cannot, without due process, demolish any standing structures in the corresponding properties. Sri Uppin, standing counsel for the 6th respondent, states that with the state highway authorities division under the Department of Public Works, Government of Karnataka, calling for information about the sanction granted for construction along with subject road, certain notices have been issued. These notices are issued only to secure details of the plan that the concerned authorities could assert. The details as furnished and verified from the records are to be made out to the state highway authorities, who will have to take appropriate decision in the case if it proposes to widen the subject road. Sri so-and-so submits that therefore there is no cause for the petitioners as against the 6th respondent, Mr. Spurti V. So-and-so, who appears for the first to fifth respondent is heard in the light of these circumstances, this court must opine that if there is to be any coercive measures for demolition, the authority which proposes to undertake such demolition must issue notice as would be required in law before acting. Notice this
So-
paragraph is crucial.
No, just one. So what is the direction?
Notice the
State
fourth-
Highway Authority must call for information from them.
Notice what the local authority says is that the sixth respondent is saying, notice I have challenged the notice issued by the sixth respondent.
Annexure,
Notice in this petition annexure, Lords, I have only stated that direct the respondents not to demolish or dispose the petition of measure. Lords, my anticipation is on the basis of a paper publication where Lords, the local authorities say that Lords kindly come to page number 15 of the writ petition.
page,
15 Lords, 15.
yes.
That is the paper notification where they say Jagaluru Mukhya Raste Agalikarana Shata Siddha. It's where a statement is given that notes they are going to widen the road. Now, on the basis of this threat of dispossession and demolition, Lords, I filed this writ petition seeking for a direction, Lords. Respondent authorities.
Otherwise, we can, the page 57.
Yes, my lords, even that is fine. In
No,
fact,
just
I had filed it to seek for orders, my lords, as per the
Page 57,
57. If those directions are issued, my lords, that should suffice.
A, B, and C.
Yes, my lords. A, B, C, D.
A, B, C, D. Will we dispose of? In terms of that,
In terms of those directions, it can be disposed.
the petitioner has sought for issuance of a writ to direct the respondents by restraining them from interfering with the peaceful possession of the scheduled property and with the further direction not to demolish or dispossess the petitioner without following due process of law for the purported purpose of widening the Chellakere Davangere main road. In the case of the petitioner, that they apprehend action by the respondents for the purpose of the road widening as is evidenced by the media report at annexure D.
D, my lords. It's page 15.
Learned counsel appearing for the respondent submits that they would undertake action only in accordance with law. Peruse the order passed in WP 13698-13700 of 2019 as well as WP 26656 of 24. Full stop. In identical circumstances, that the directions passed in WP 13698-13700 of 2019 could be passed in the present matter also. Full stop. The observations at this court in WP 13698 and connect of 2019 and connected matters at para 6 to 8, 6 to 9 reads as follows.
Yes.
In the present matter also, the aforesaid directions are reiterated and the respondents to follow the procedure
As per the set.
extracted above at para 6 of para 6 in WP 13698 of 2019. Para 6 to 9. Accordingly, petition is disposed of.
Lords, those paragraphs may be extracted in this for easy reference.
Yes, yes.
It may be extracted in
Yes,
this
yes.
order.
Yes.
21 also, my lords.
But office objections, you must comply. Agidya? You comply with the office objections also.
I will comply, my lords, right now.
Ah.
I'll right now comply it.
The same order.
It's the same order.
But you must comply it to the
I will comply right.
same order. Identical order.
Yes, my lords. One submission, my lords. In the cause title, there is a small mistake, my lords. I may be permitted to correct that also. The respondent authorities, my lords, 2, 3, 4, my lords, I have to mention as Davangere instead of Chitradurga.
Just one. Idರಲ್ಲಿ same media report at annexure D. Same order. Now, what you want to correct?
Lords, in the cause title, respondent 2, 3, 4, I have mentioned Chitradurga instead of Davangere. I have to mention it as Davangere.
Petitioner is permitted to amend the description of respondent 2 and 3.
2 and 3.
Necessary amendment to be carried out forthwith. Office objections to be complied with forthwith.
I'll do it.
Order sheet and per. One same order.
19, can Ramakrishna.
I am for the petitioner, my lord.
Take it from the paper.
I am for the petitioner, my lord. Petitioner is the absolute owner in possession enjoyment of scheduled properties, 4 items.
You have to
Under-
comply with the office objections.
So I will comply right now. This is a small correction.
Now, what are you seeking?
He is the absolute owner in possession enjoyment of scheduled properties at annexure A, that is registered gift deed, produced at annexure A, my lord. Page number 15.
Just 1 minute. PDO ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಗೊಂತೀರಾ? 2 to Bangalore, Chief Executive Officer, Bangalore Rural. MS Devraj accepts notice for respondents 2 to 4. AGA accepts notice for the first respondent. Yes.
So he is absolute owner, registered gift deed. It is produced on annexure A. On the basis of registered gift deed, PDO, respondent 4, has issued 4 khatas, which are produced at annexure CDEF, my lord. Page number 25 to 32. He has issued 4 khatas in respect to scheduled properties. Respondent 4 has issued khatas. He himself has issued a letter at annexure P to respondent number 3, recommended for cancellation of khatas, saying that the khatas are illegal. He only has issued khatas. He says now it
Which
is on
page?
page number 55. Sorry. Annexure P.
On what ground?
Without mentioning any ground, simply says it is unlawful. Petitioner respondent for himself has issued notice, issued khatas. Now he himself says that all are unlawful. It's the panchayat members and the president, all are under political pressure. There is political differences between these two parties. Due to political vengeance, they wanted to cancel the khata. These respondents are carried away with misguidance of the panchayat members.
But there must be some reason, isn't it?
No reason has been mentioned, my lord. Simply say that it is unlawful. In turn, respondent 3 also has issued inquiry notice at annexure Q for production of documents, and for his presence, he has produced documents. He has been continuously present. In spite of it, no inquiry has been conducted.
They have encroached Gramatana land. That is their
No,
observation.
annexure Q is a notice to participate.
Sorry.
Annexure Q.
Annexure Q has been issued by respondent number 3,
Correct.
R3, for production of documents and for his presence. He has produced documents. He has been continuously present.
Annexure Q is an
Yes.
appellate proceedings.
So,
Then participate in the.
Annexure Q is an appellate proceedings in which you are given a notice to present yourself at 3 PM on that, on 25/1/23.
He was present, sir. He was present. He has produced documents also as instructed.
Now that proceeding has not yet come to.
Not yet come, not yet come. And these people are simply threatening the petitioner that they would cancel Khata without conducting an inquiry, without due process,
You find out.
without due process of law.
Earlier date, my lord.
Earlier
This
date.
Annexure P is of the year 22. Annexure Q is of the year 23.
23, Form 23 till
You
today.
find out, now you find out.
Yes, Manoj.
What has happened to that appeal proceeding, whether it's disposed of or still pending?
I will verify, Manoj.
It is still pending.
Let us see. Then we'll see, if it is pending, we can give a direction to expedite it. You find out.
Yes, sir.
This is the matter in the preliminary hearing list on.
10 days.
If the same is not stayed, they may cancel the Khatas, my lord.
No, that will,
Proceedings under queue.
the respondent take a stand as to whether the proceedings at annexure Q are still pending or orders have been passed.
Yes.
Relist the matter in the preliminary hearing list on 2nd of April. ಅದ್ರಲ್ಲಿ notice ಬಂತಲ್ಲ?
20, why can arrange Sharma?
Office
Appear for the
objections to be
petitioner.
complied with in the interim.
2 weeks time may be granted. Manoj.
2 weeks time granted for necessary compliance. If office objections are complied, list the matter in preliminary hearing list.
21 attend 22. Anand Krishnamurthy, 22.
They represent the
December
petition,
22.
I'll comply with the office objection. The short question is, there is an old tree, Burga tree, nearly 70-year-old tree, that is likely to come down and harm my property. Annexure G is without notice to me, an inspection is made.
What is that? Honge Mara or what is that?
Burga tree, Burga tree which is hollow.
Burugad mara remove ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ because old tree. But the forest department says that it is healthy tree and if owner makes a request, we will do the action.
ಬಿದ್ರೆ ನನ್ನ
They are the neighbors.
No, correct. Now that you place it on record.
It is,
without
they have
notice to
themselves
me,
annexure G.
G
Page
is the
60.
order. Without notice to me, spot is inspected.
Page 60.
ಫೋಟೋ ಹಾಕಿಂತಾವ್ ನೋಡ್ಬೋದು.
ಅಲ್ಲ ಆಯ್ತು, ಆರೋಗ್ಯಕರವಾಗಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಷ್ಟೇ.
And if owner makes
Without notice
request,
to me, ತಾವ್ ನೋಡ್ಬೋದು. Annex photos are there. Annexure E and even. E, page 55. 55. Photos.
Now this is situated in whose house?
My property. They say adjacent. Adjacent property ಇದ್ರು ಬಿದ್ರೆ ನನ್ನ ಮರದ ಮನೆ ಮೇಲೆ ಬೀಳುತ್ತೆ. Your lordship can see the photographs, 55, page 55.
Now this is in your property or in the neighbor's property?
It is in my property, but they say it is neighbor's property. Spot inspection ಆದಾಗ ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
So then now you re-examine.
Notice ಆದ್ರೆ ಹೋಗ್ಲಿ.
It can be re-examined with notice to him. And then you take a decision. Now, this is BBMP, is it?
BBMP.
Which is that provision for dangerous trees, removal of dangerous trees?
Yes.
266 or something.
Threat to property. 260?
266 or something. Yes. Uh, 257, Manoj.
250?
256 and 257. 257 on. Precautions in case of
Read.
dangerous tree.
Read.
Precautions in case of dangerous tree. If subsection 1, if any tree or any branch of a tree or the fruit of any tree be deemed by the chief commissioner to be likely to fall and thereby to endanger any person or any structure, the chief commissioner may by notice require the owner of the said tree to secure, lope or cut down the said tree or remove the fruit so as to prevent any danger therefrom. Subsection, it says owner. Subsection 2, if immediate action is necessary, the chief commissioner may himself, before giving such notice or before the period of notice expires, secure or lock or cut down the said tree or remove the fruit thereof or fence of a part of any street or to take such
We'll direct the concerned to hold an inquiry under 257 with notice to you. Now, if it is under the BBMP Act, it must constitute a danger to property. If you're under the BBMP Act, otherwise, procedure under the Preservation of Trees Act, suppose it's in the owner's property and it is not dangerous, but they want to remove it, then under the provisions of Preservation of Trees Act. Correct. So I'll say under 257 applies to anybody that you take. Huh? No, 257, direction is given to the owner. Property, the tree may be anywhere. So you hold an inquiry under 257. And if you find it's constituting a danger, then you can take action. The petitioner. And you are required to ensure, actually in the plan, I think, no, 2 trees. No, in every plan, you have a condition of 2 trees. Huh? No. In every plan, I think there's a rule now, fresh plan. You have to make 2 trees. Where you're not enforcing. You do 248 in 1 or 2 cases. You ask, we'll pass direction. That's why we'll have so let there be an inquiry. The petitioners have sought for setting aside of the endorsement at annexure G passed by the respondent BBMP by the tree officer BBMP. In terms of the endorsement at annexure G, it is submitted that the removal of tree sought for is in a healthy condition and that the application would be considered if the owner makes an application for removal of the tree. Third counsel Sri H.R. Krishnamurthy, appearing on behalf of the petitioner, submits that the endorsement at annexure G is issued without notice to him, without notice to the petitioner, and that the tree constitutes a danger to life and property, and in terms of section 257 of the BBMP Act, if there is if there is apprehension of danger of the tree falling, necessary action may be taken by the authority. Full stop. Section 257 of the BBMP Act 2020 reads as follows. Next. In light of the submission that annexure G is passed without notice to the petitioner, order at annexure G set aside, respondent BBMP to inquire into the matter in terms of the power conferred under 257 and pass appropriate order after affording an opportunity of hearing to the petitioner. Accordingly, petition is disposed of. Land Counsel Pawan Kumar is directed to accept notice for respondent 1 and 2 for 3, AGA for 1 and 2. During the process of inquiry, the respondent BBMP may also ascertain may issue notice to the owner as well.
23, Sarvana, yes.
Notes appear for the petitioner. Page 37, my lords. Page 37 is the, my lords, the sketch of the building plan. Office is insisting, my lords, to produce the enlarged copy. My lords, I am not relying on this document, my lords.
In light of the undertaking that petitioner is not relying
On the sketch.
on the document at annexure E at
Yes.
page 37.
Lords may say sketch, my lords, only on the sketch.
Sketch at page 37 and undertakes to produce enlarged copy of the same if relied upon. Office objection at C number 1 is kept in abeyance.
Lords, annexure G, my lords, page 51. Lords, on page 50.
No
page
page,
50.
no page numbers.
No, sorry, annexure G, my lords,
Annexure
G.
No, but I think the scrutiny is not complete only. Page numbers are not there after 55. You at least put the page number.
Yes, my lords, that.
You put the page numbers, I'll take it up. When do
Please,
you
my
want?
lords. My lords, may kindly pass it over, my lords.
Pass over. Our file could you? Yes.
25, orders 25. Keshav Bhatia.
We filed memo for withdrawal, my lord. One office objection, petitioner's signature is not forthcoming and it is not necessary, my lord.
ನಮ್ದು ಆರ್ಡರ್ ಒಂದ್ಸತಿ ನಮ್ಮ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ ತೋರ್ಸ ಅದನ್ನೇ ಹಾಕ್ತಾರೆ ಫ್ರೆಂಡ್ಸ್ ಮೆಮೋ ಫೈಲ್ office has raised an objection that signature of the party is not forthcoming. In light of the order passed in WP number so and so, the office cannot insist upon signature of the party. In light of the memo filed and submission made, petition is dismissed as withdrawn.
26.
Your lordships last time directed them, my lords, if there is any pending bills to clear that, my lords, they have filed in objections now. Lords, in an objections, they agree, my lords, that the work has been done.
Let him come. I'll pass over.
Please,
Pass over.
230, my lords.
27.
Obliged, I'll wait.
27.
Read up in the previous matter.
26.
Objections have been filed in this.
Sanjeev.
Huh?
Objections have been filed in this matter, my lord.
Ah.
We have totally denied our claim, my lord, in this because
Read it.
we have denied the entire claim, my lord.
Read
Lords, page number 29 may be looked into, my lords. Their own
Lord, may I request-
job cards.
may make my submission, my lord. The contract over agreement was entered into between the petitioner. Later on, my lord, in the work order, my lord, they had to renovate these slum board houses for in a period of 1 year, in which they have not done. Suddenly in the year 2018 or 19, after 5 years, they come up, put up bills which have been signed by my engineers who have already been retired. So there's an entire conspiracy, my lord, which I'll have to argue.
Page
my
number
lord.
30, my lord says, my lord, since my lords, the beneficiaries did not give me the space to work, my lords, because all this, my lords, are the
No, correct, but they're saying no work was done.
Work, my lord.
earlier they said no work was done.
Work, my lord, I'm not sure if it's done or not, my lord.
Their own
But
report says,
What
my lord.
happens is, my lord, in the work order, my lord, they had to complete the modification in 1 year, which they do not do, my lord. Admittedly, they do not do it in 1 year. My lord, then, my lord, my entire account gets freezed for that project, my lord. Only in the year 2009, after 5 or 6 years, they come up with the bills.
Lords,
Lord,
what-
then, my lord, that verification of those bills, my lord, is very difficult for us, my lord.
Lords,
That is
page
why-
number 28, my lords, their own document filed in objections, my lords. Page number 28,
Objections. Jina.
page number 28. Earlier to that, my lords, there are proceedings which they have not produced, but this particular document says, my lords, there is a recommendation, my lords, to defreeze the account.
My lord, that is from the engineers, my lord. Admittedly, there is a recommendation from the engineers to
Don't have a copy of the objection.
My lord, I'm sorry, I filed it on 18th March.
Page number 28, my lords, R5.
No, but disputed questions, how we can enter into?
My lords, their own report says, my lords, I will not go into my lords without their recommendation. They're only this thing to say that my lords, 8 years has done, defreezing is cannot be possible.
Recommendations cannot be an order. Recommendation cannot be an order.
Their own-
It's a
their own
recommendation
officers.
of an engineer, my lord. It cannot be placed as an order, my lord.
My lords, kindly,
Recommendation is from an engineer to put up the bills before the administrative officers.
Correct, now we are saying, okay, let us, for a minute, assume that the work is done, bills have not been raised. Then you'll have to at least consider it if work is done.
Lord, I am, that, my lord, that also we are not sure because we have visited the premises, my lord. Some people say it is done, but some people say it is not done. I'll have to see documents for that, my lord.
My lords,
We'll have- It is a disputed question of fact, my lord. It has to be gone before the civil court.
my lords, it's
My lord,
not a
If
disputed.
it is not 1 year, my lord, they admittedly say that it is not completed in 1 year. Why they could not complete in 1 year is also a question which they'll have to show it to us.
My lords, on the last date of hearing, your lordships has directed them, my lords, to produce the original records also.
I'll
They have
produce-
only produced the page.
That's all, my lord. If my lordship, I'll produce the original records.
My lords, last 2 times, my lords, they're with the documents here. The officers are present before this honorable court. My lords, page number 28 may be looked into, my lords. I'll not precipitate anything. Note 118, my lords,
Page,
28 of objections. Earlier into the, my lords, there is an entire proceedings which has been taken place. From note 96, my lords, there is a report stating that, yes, there are minor discrepancy where it has not been done in the timeline. But, my lords, the work to an extent of the representation is done is what they say. They don't produce that particular this thing. But this particular note, my lords, 118, gives the reference to that. Stating, my lords, note 2, my lords,
no, now you inspect, I'll permit you to inspect the records. You inspect the records and next week we'll have it. You make a.
my lords, already, my lords, I've inspected, my lords. If, my lords, page number 28. Yes, my lords, ಪ್ರಸ್ತಾವಿತ ಮನೆ ನಿರ್ಮಾಣದ 43 ಕಾಮಗಾರಿಗಳಿತ್ತಲ್ಲ 4,55,00,000 2012-13 ಸಾಲಿನ ಶೇಕಡ 24.10 ಅನುದಾನದ ಶೇಕಡಾವಾರು ಸೊ ಜಾಬ್ ಕಾರ್ಡ್ ನೀಡಿದೆ. ಜಾಬ್ ಕಾರ್ಡ್ ಪಡೆದ 1 ವರ್ಷದ ಒಳಗಡೆ ಟೆಂಡರ್ ಕರೆದು ತಾಂತ್ರಿಕ ಕಾರ್ಯವನ್ನು ನೀಡದೆ ಇರುವುದರಿಂದ ಜಾಬ್ ಕಾರ್ಡ್ ಅನ್ನು ಬ್ಲಾಕ್ ಮಾಡಲಾಗಿದೆ. ಈ ಸ್ಥಾನದಲ್ಲಿ P1878 ಅಡಿಯಲ್ಲಿ ಅನುದಾನಿತ ನಿರ್ಮಿಸಲಾಗಿರುತ್ತದೆ. ಕೆಳಕಂಡಂತೆ ಮಾನ್ಯ ಆಯುಕ್ತರು ಡಿಫ್ರೀಸ್ ಮಾಡಲು ಅನುಮೋದನೆ ನೀಡಿರುತ್ತಾರೆ. My lords, all the proceedings are done. My lords, to an extent of what work I have done. My lords, Manya Ayuktaru has, my lords, directed, my lords, to release the amount. My lords, only, my lords, the chief special commissioner for finance, my lords, says, my lords, after 8 years, I cannot do it. It's a joke is what they say. Till here, my lords, all the proceedings are in my favor. There is a report.
No, you look into that and you point out from the record.
My lords, if they produce, my lords, 2:30, I'll make a submission. The officers are before this court from the last 3 days. In the last roster also, my lords, they said no work is done at all. They said, my lords, there is no work done. Now, my lords, they're changing their
Let him inspect the file.
2:30, my lords.
We'll have it tomorrow. You have a look at
Please,
it.
my lords. Please, my lords.
Whatever copies he wants. Otherwise, at his cost, let him Xerox the entirety of it. And I'll fix a date on that.
Tomorrow only, my lords. I've seen the records, my lords, in the BBMP office.
They have seen the records, my lord. Admittedly, they've all seen the records. Very neatly, they've seen the records.
So what you do, you take a Xerox of all, whatever you want.
Please, my lord.
You file it. And then you make a submissions on the basis of that material. We'll see what is to be done.
Tomorrow, my lord.
No, let them file the entire thing, my lord, whatever it is. I will also inquire with my officers, my lord.
My lords,
Not tomorrow.
last 3 days they are before this court. In the last roster also, my lords, it was directed, my lords, whether they want to pay it or not. They said, my lords, we'll just go through the documents. It is the 2018 documents where we don't have a knowledge. That's the only submission what they've done. If the work is done, we will pay. But they said, my lords, there is no work done.
Now you Xerox whatever it is and you place it before the court.
Tomorrow, my lords. My lords, the urgency is this, my lords. My lords, I have sold my house, residing house, because of this particular project, which I have invested entire money which I have had. I have sold my own house, which was I was residing. I don't have anything to survive now, my lords. And they say, my lords, all their proceedings, they say, the work is done, release the money. Only, my lords, the commissioner, finance officer says, my lords, oh, it's a joke after 8 years to release the money is what he says. No other grounds. Tomorrow, my lords.
Not tomorrow, my lord. Only because, my lord, if he furnishes a copy, my lord, I'll have. Monday, man.
Meanwhile, you give him access to the
Yes.
file. You take whatever it is, you file a Xerox of that, which we will take it on record.
Oblige.
Yes.
Finally on Monday. Oblige.
27. Ajit E. Shetty.
Yes, my lord. Today morning we received, my lord, I served the, today morning received. He is seeking amendment of.
Is that, the petitioner contends, my lords, that a portion of his private property,
Copy of master plan filed by council for respond number 2 is taken on record. What is the issue?
my lords, the petitioner says, my lords, that a portion of his private property has been depicted as a public road, my lords, in the comprehensive development plan of Udupi town, without there being, my lords, a process of acquisition. My lords, may I put things in context, my lords, if my lords were pleased to take up the rejoinder statement that was filed on the 27th of November.
No, but it's only a proposal.
No, it's already there, my lords. It was not even a proposal. What they do, my lords, in 2008, they revised the CDP. There, my lords, my lords, for a moment, if my lords were to,
Now, what are the facts now?
my lords, fact is that, my lords, this is a property which is
may-
inherited by me.
He want to change the CDP, which was done 2008. That is the prayer, my lord. Now, in respect of the very same round mode, dispute is pending before the civil court, my lord.
Now, that is,
Injunction was granted in respect of the same road, my lord. In the appeal, my lord, it was reversed. In the high court, my lord, restore the injunction order and remand to the civil court, my lord. That matter is pending.
Now, did you go get that judgment?
Yes,
It's
last
there-
time you were.
There was one judgment of the apex court
please,
saying that you can't keep a classification perpetually.
that is, once a road is always a road is what my lord said there.
No, that says,
Yes,
I
my lord.
think it says, now here what happens under 69 of the Town and Country
Please,
Planning Act.
please, please.
Once it's notified as a road, let's assume, you can't divert it for any other purpose. is
Absolutely.
What it says.
True, true.
Now here what has happened?
Then there is no notification. There is no
The
notification.
master plan is the
Master
notification.
Master plan, my lords, may I just trouble my lords with a eye sketch, my lords, there's a bird's eye view of this plot. My lords, that is produced alongside my rejoinder filed on the 27th of November 2024. The very photograph would depict, my lords, the lack of logic in what the respondents are submitting.
No, but then you'll have to challenge the validity of the master plan.
My lords, which is what I have done. My lords, I have made my representations, my lords, for a moment, my lords, just to place things in context.
The appeal provision.
My lords, the
Consent.
rejoinder statement, my lords, has, there is a rejoinder, my lords, was filed on 27th, my lords, of November.
Yes.
For a moment, my lords, there is a photograph, my lords, secured from the Google Earth. My lords has it. My lords, there is a building marked with the word letter P
Yes.
on top. That is, my lords, the petitioner's building.
Yes.
Now, what they say, my lords, is the shadowed portion right beneath that, the narrow strip of land. They say, my lords, this is the public road as per the CDP. Their stance, my lords, in the written statement, in the objections, what they have filed, is, my lords, that the neighbor who lies to my south, which is marked as R, my lords, who is a private respondent in this petition, they say, my lords, that he had donated a portion of his land to widen what they say was an existing road. This is what they refer to as a road. My lords, I have put forth my calculations, my lords. If they say that there was an existing road which was widened using the property of the respondent, my lords, then that the road should have reflected in the CDP for the year 2008, which is what is produced today. And my lords, I have gone through that. This portion, there is no depiction of any road at all. Now, my learned friend, my lords, today has produced the CDP of the year 2008. If my lords were to peruse that portion, the broadened, my lords, photograph of the CDP of this particular stretch of land, this road is not at all appearing there, which is what is my contention. Now, if my lords were to see, there is one comprehensive sketch, my lords, which is the first annexure. Then, my lords, the highlighted portion of this area, which they have marked, my lords, Prashnita Shivalli Gramada survey number 59. My lords has it.
must be the second document. Now, if my lords were to juxtapose this sketch to my lords the photograph, there is no mention of a road. All the other arterial roads, if my lords were to see all the other arterial roads, it is clearly visible. There is no road visible in my land. So all that I have requested, my lords, is for them to revise the CDP to consider my representation. My lords, I do admit that there is a private dispute. My lords, there is a private dispute where my lords, a private response says that my lords, my father had.
No, correct. Now, the revision of a master plan can be done only for one or two reasons.
Please.
Some cartographical mistakes or what is
Yes.
that?
Yes.
Now, it will have to be done at the time whenever they're going to revise.
My lords, may I trouble my lords with this proposition? My lords, the Honorable Apex Court has recently reiterated that the right over property, my lords, is a right guaranteed under the Constitution. My lords, that cannot be taken away. My lords, I cannot come in their way if they want to acquire my land. But they cannot, my lords, unilaterally show that as a street. That is all my grievance.
No, correct. And now, if it has to be changed, what is the provision under the Town and Country Planning Act? Let's have a look.
Please.
We call the objection, they have not filed any objection, man, 2008 it was revised,
But
my
then
lord,
they-
if there
they'll
is any
have to-
filed any objection on that ground, man, he can file appeal, not in the
My lords,
petition.
in that event, they'll have to produce the notification, my lords, where this portion was notified as a street when they were revising the CDP.
No, the entirety of the master plan will be by virtue of a notification.
Please.
The entirety of the master plan will be by virtue of a notification.
Yes, ma'am. So if the notification is produced, my lords, then that would throw more light on this
But
issue.
once a master plan has come into force, the only provision is change in land use if it is permissible. The revision of the master plan will be done only whenever 10 years once or 20 years once.
That is true. That is, my lords, that is if the land,
It cannot be a case-to-case revision of
May
the master.
may I submit? My lords, if the land has already vested with the state, then my lords, yes, they'll have the right to revise it. But suppose if the state, my lords, has taken over a private property without due process of law.
No, they don't take it. What happens in a master plan, only the proposals are mentioned. In terms of section 69, Town and Country Plan. In terms of section 69,
Please,
there'll be whatever you have reserved it for some purposes.
that is true, my lords. My lords,
So now, in the master plan, they show it as park, for instance,
yes,
roads,
section
etc.
acquisition of land designated for certain
So
purposes.
now that has to be, that will either lapse in some cases.
Please.
And in case of road, it doesn't lapse.
My lords,
So if you are now saying that it has to be removed from a road, that's a decision that they'll have to take.
my lords, had they notified this portion in terms of section 69, my lords, I have no legs to stand. My specific case, my lords, is that no notification has been issued.
That's why there is a judgment.
Please.
Of the Apex Court which says you can't keep a place notified in perpetuity. Now,
Please.
they have notified it as a road. It does not lapse because under 26 and read with 69, that once you show it in the master plan as road, it never lapses. Now, till it is in force, they will not give you change in land use, permission for plan, etc. That is the position.
Please,
So
please.
you have a look at what the Apex Court
Very
has
well,
said,
very well.
saying that you can't in perpetuity keep it shown as road leather.
True, my lords.
See, this is Partiwala's judgment.
Yes,
So there it may come to Article 300A, some relief is given. Just check it.
Very well.
Have it next week, then we'll see.
Here, my lord, he is having 6 cents of land, entire 6 cents, he is having a building. There is no question of acquisition for his.
that is a question which they have
That's what
to,
my
my
information.
lords, decide.
He is having
by way of
constructed a full
notification.
building on his own.
No, he's
And-
saying you remove the classification shown in the master plan as road.
My lords, my specific submission to my lords would be that there is no mention of this portion of land in any notification.
No, not required. Once the
Master
master
plan.
plan, once the master plan shows, that is sufficient. That's how it is.
My lords, I'll place that ruling, my lords.
Let us see, examine it.
Very well.
And then you see what are the provision under which master plan can be
Revised. Revised.
And if there is a classification, does it lapse? That you address.
Very well.
Great to file a appeal, my lord. If you want to change the master plan, there is an appeal provision. That to 2008 master plan.
Let us see. Week after next date. We'll have it in B group. We'll hear it.
Very well.
This is the matter in B group date.
Great.
Yes.
28, Manjula T.
For the petition, my lord. My lord, in this case, I'll comply the office objections, my lord.
1 week time may be granted. ಇದರಲ್ಲಿ amendment cost title ಹಾಕಿದೆ. Writ petition ಅಲ್ಲಿ ಅದನ್ನ ಬರಿಬೇಕಿದೆ. Cost title, impleading application has been allowed in last date, my lord. The amendment cost title already filed. ಅದೊಂದು 1 week time may be granted.
The
Please, my lord.
difficulty is this, my lord. A certain land was reserved for rehabilitation in favor of the impleading applicants. They were dispossessed of that land for the purpose of Shimoga Airport. Another land was reserved for allotment rehabilitation. In the meanwhile, Housing Board, it was given to Housing Board for development. The Housing Board called for applications for making allotment. We challenged that. There is a specific order
So you appear for the impleading application.
impleading applicants. Page 101 ತಾವು ನೋಡಿದ್ರೆ impleading application ನಲ್ಲಿ
Yes.
page 101, kindly turn to page 104.
So this is page 101 of
101 of impleading application.
application. That is the writ petition order.
Writ petition ನಲ್ಲಿ entry order.
Ah.
104, Shri so and so, learned counsel for the petitioner to serve the copies of petition papers on learned counsel for respondents. In the meanwhile, though respondents 6 and 7 may proceed to hold the lottery as scheduled on 27/6/2014, no rights shall be created in favor of the person succeeding in drawing of the lots, nor shall the confirmation be made in any other manner without further orders from this court.
Now this relates to allotment of sites by the Housing Board.
Housing Board, well, I challenged it on the ground that this particular land is reserved for rehabilitation. Now,
What happened to the final order?
that my writ petition was allowed. Housing Board has handed over the entire land to the Deputy Commissioner for making allotment as per the rehabilitation scheme. Now, that is not being implemented on the ground. These persons have filed the present writ petition. They have filed the writ petition on the ground on 27/6/2014 lottery. The site provisionally a select list is made.
Correct. So what is the final order now?
Final order is the next, my lord, your lordships get at 105.
Yes.
Operative portion. Kindly go to page 144. Government filed a memo.
Yes.
143 ದಲ್ಲಿ last about 10 lines. However, the same.
Yes.
However, the same was not made available to this court for consideration. Respondent state has filed a memo dated so and so, along with a communication issued by the Office of Assistant Commissioner Shimoga Subdivision, Shimoga, addressed to the additional government advocate informing about the sanction of development charges and the instructions having been issued for handing over the layout to the district administration. Proceedings of the Housing Board held in the meeting dated so and so is also enclosed. The memo read as under. Respondent state humbly submit as follows. Petitioner are asserting the case on the basis of their filing application seeking regularization of their unauthorized cultivation in 120 of Sogane village in Idige Hobli, Shimoga district. It is relevant to state that the said land has been utilized for the purpose of construction of Shimoga Airport, and Karnataka Housing Board has formed a layout in the portion of that survey number measuring 34 acre 9 guntas. Government has taken a decision on the basis of board resolution of the Karnataka Housing Board, wherein it is resolved to allot sites to 343 Bagamukum cultivators in the layout formed by Karnataka Housing Board, and Karnataka Housing Board vide its communication dated so and so layout called Shimoga Sogane layout has been handed over to the district administration to take further steps to allow the sites to the 343 Bagamukum cultivators. Assistant Commissioner Shimoga Subdivision, vide his communication dated so and so has informed that Office of the Deputy Commissioner Shimoga is taking necessary steps to allot the sites to 343 Bagarukum cultivators.
This writ petition was by those who were to be rehabilitated.
Rehabilitated, in which I had sought for stay of that lottery and allotment to be made in favor of the present petitioners. Court said, all right, because it was on the previous day of the lottery. Therefore, court said lottery may proceed, but it shall not create any right. There shall be no confirmation.
Now, this extent is 34 acres, 9 guntas in survey 120.
Yes.
Now, what right do you have, madam, now?
Next week, my lord, I'll argue
No, I'll
this
give you
matter.
next
I'll,
week.
I'll take instructions
I'll
from
give
the
you
client
next-
house,
correct,
so my lord,
I'll give
please.
you next week.
Ah.
But now there is no land available. Housing board from whom you are claiming has given it to the government. There ends the
Well,
matter.
we are the bona fide purchaser, my lord. I don't know. Kindly,
Correct.
next
There
week,
is
my lord,
no, I'll give you a date.
please,
But you try to understand.
please.
Now that land is no more available with the housing board. So question of allotting sites to you doesn't arise.
The KHP is because of that KHP, Karnataka Housing Board fault because of that reason, we are sufferer, my lord. That's why.
So you'll have to now only work out a remedy in any other allotment that is next held by the KHB, which we can't comment on here. As of now, whatever you are seeking cannot be considered. There ends the matter. So when do you want? A
Next
date I'll
first,
give you. I'll give you
please,
date.
1-3, my lord.
Huh?
1-3.
No. Next week.
Illa, 1-3, my lord,
No, no.
because they are in Shivamogga.
No, that
Aga-
may be so, madam.
Oh,
There's nothing to consult because you have no right. I'll have it
28, my lord, please.
Huh?
28,
28.
please.
Relist the matter in the preliminary hearing list on. We'll have it on 27th.
Please, my lord.
27th in the preliminary hearing list.
Interim modern,
One page note, you just make a one
Please.
page.
my lord, interim
I'll give
modern.
the
Restraint.
note.
Yes. Interim order earlier granted is.
My lord,
extended
kindly
to
club
the-
along with this matter, the WP number 4945 of 24, my lord. You know that.
That
That is also connected matter, my lord.
Huh?
One more petition is there.
list along with WP numbers.
4945 of 2024, my lord.
49.
45.
But government should have put an end to this long back. Government should have stated about this long.
ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ರು ಆಮೇಲೆ ಪೊಸೆಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಇಲ್ಲ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇನ್ನೂ ಒಂದು ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತೇಳಿ ಹಾಗೆ ಇಟ್ರು. ದೆನ್ ಐ ಕೇಮ್ ಟು ನೋ ಅಬೌಟ್ ದಿ ಪೆಟಿಷನ್ ಬೀಯಿಂಗ್ ಪೆಂಡಿಂಗ್. ಐ ಮೇಡ್ ದಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
Mr. Patil is in this litigation since a long time. Yes.
29. Seal number 20.
Withdrawal petition, my lordship. Kindly liberty, my.
Memo for withdrawal has been filed by the petitioner. In light of the same, petition is dismissed as not pressed.
Liberty.
30. Sheshagiri.
Let's petitioner. In this matter, there is something which is very disturbing apart from,
Who is R4?
not she's a private respondent, not he's being put up construction, not in violation of the sanction plan. Sanction plan is G+2. He's already put up G+5 currently. Now, Minots, there's also a suit pending on the jurisdictional court, Minots, with a police protection, Minots, directing him not to put up construction. He has been served. He knows the currency of the current, this present writ petition, because it's a matter before the civil court also. Minots, the nerve of this gentleman, Minots, says,
Yes, Somaya ji. R3. Now he's saying that you have to take action. Huh? Annexure?
Annexure J is also there, Minots. Annexure J one there. Planning authority ko not here.
Planning authority is not a party here.
It has to be annexure A and J, Minots, I'm sorry.
Huh?
annexure A and J, because J is 68 minutes to the PDO there.
Page?
68. 68. Minutes, this respondent number 4 minutes has the nerve to file a police complaint against a lawyer minutes who is appearing before the trial court. He has also filed a bar council complaint minutes that photographs click madidare. He has conducted criminal trespass. Minutes, an offender is getting so offensive here.
No, what? There is a suit pending, is it?
No minutes. Annexure L for a moment. 71. Sanction minutes is G+2. By the time we filed this writ petition minutes, it was G+3. Minutes, then notice was issued here. He continued construction. Minutes, we also filed a civil suit. Civil suit minutes against the authorities as well as the gentleman. There is an order of injunction not to put up construction. Now it has become G+5. It has become G+5.
No, but how can you have two remedies now?
Minutes, civil suit with respect to easement and other things also is there, minutes. This one minutes because of the inaction of the authority.
But where do you state that in your, look at your representation? It's for some encroachment. Where have you made at least one?
Setback bidabekendu.
Yelli.
Minutes,
ಒತ್ತುವರಿ ಮಾಡಿ ಕಟ್ಟುತ್ತಿರುವ ಕಟ್ಟಡವನ್ನು. You have to at least make a averment that they're building against their plan in the representation. You make a fresh representation. I'll have it next week. You place it on record.
I'll do the need.
Let us.
I'll do the need.
And make an amendment to your.
I'll do the need, but I'll also include the planning of the minutes. In the meantime, minutes, may I also take?
No, your prayer is enforcement is to be done by R3.
Yes, minutes, that's enough. That's enough. If the
So you
authorities are notified,
Make
that's
one more representation
I'll do the need.
and place it on record specifically stating that he is constructing against the
Sanction
plan.
Yes,
I'll have it next week.
yes. 19, 26 is okay.
No, that you will see. You make an
26 minutes for that purpose. I will, by today's end, minutes, a
make
representation.
whatever amendment.
Yes,
application.
minutes, I'll do the need.
You'll have to change the annexure number also.
I'll do the need. Minutes. And possibly Anekal Planning Authority will have to be included.
Relist the matter on. And meanwhile, whatever he does, you have to ensure that the building is as per the plan. Somyaji. Huh? Annexure?
K, na? K.
Then you must take action. How you can? Huh? No, you must ask him to stop. At least have you done that? Have you at least issued a notice
Nothing.
that you place on record? Forget about him, but you do your duty also. Relist the matter. Otherwise, we'll have to take action against the concerned officials. No, there must be something. You can't say, I have building license, I can't stop it if it is done in violation of the building plan. Huh? That is your headache, how you are going to do. At least notice ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ವಾ ಮತ್ತೆ ಆಯ್ತು then what action? Ask the police help to stop. You can't just turn a blind eye. Relist the matter.
1st of April.
Yes.
31.
26 minutes.
No date.
26.
1st of April.
1st of April.
Please.
31.
I appear on behalf of petitioner, my lord. But if your lordship remember, my lord, our previous date of hearing, lordship, my lord, directed me to give a fresh representation, my lord, through, my lord, online, that we have done, my lord. But this is a case where, my lord,
I'm told that they have not filed any online application.
Mm,
If
we
they
have-
filed online application, we will consider as per law within 1 month.
I'll dispose it.
I take your lordship for a 2 minutes, my lord,
Ah.
bear with me. There are, my lord, continuous 5 orders passed by this honorable court, my lord. Every order has been violated, my lord. In a contempt petition, what they have submitted, my lord, we have complied the order.
Lord, the
What are the facts?
fact is that, Lord, we have asked for, Lord, the issuance of Khata, for which, Lord, the ADLR has to give a survey sketch report to the panchayat. The panchayat should, Lord, issue accordingly. Lord, now, Lord, they are putting, Lord, blame on each other.
No, the ADLR is given service sketch to the panchayat.
No, he has not given.
He has not.
He is not given. The panchayat says that, Lord, he has reported, Lord, there is somebody has filed an objection, therefore he cannot.
I have filed report last occasion, my lord.
ADLR report.
ADLR report had. And 2012-24.
No, Pradeep.
Pradeep? M. Pradeep?
He appears for the local authority.
Yes.
Pradeep appears for the local authority.
Yes.
Yes.
Huh? Huh? Wakalat Hakila. He has appeared previously, no?
Lord, my colleague was up here, I was not aware.
Surada Jakkana. Bangalore Urban Anekam.
They have appeared.
Huh?
They have appeared.
Pradeep or appear.
Avare appear.
Wakalat Hakilwala. If you have his phone number, you just call him.
Yes.
No, now ADLR has prepared the sketch.
Prepared the sketch,
Huh.
but he has not, given to them, Lord, the panchayat.
A report came to be filed, my lord, wherein I have mentioned it in detail.
Now the requirement of online was by the panchayat, is it?
No,
They
by the
wanted an
party.
online application.
By
Yes.
the party.
Huh?
By the party.
Correct. The
Petitioner
panchayat
has to
wanted
make one
online.
more fresh online application.
Huh.
Whatever the earlier application made, for that we have already done the work. Again, we cannot act upon the earlier application. Now they have to, any changes want, now they have to make a fresh application through online.
That he says he has done.
We have done,
That
Lord.
applications has been considered and I have filed the report, my lord.
No, the online, he has.
And
filed-
before your lordship, Lord, from 2013, Lord, your lordship, kindly come to, Lord, page number 20. How, Lord, the authorities, Lord, deliberately, Lord, harassing the petitioner. Kindly come to, Lord, annexure 20, Lord, annexure B. Where, Lord, this honorable court has directed to issue a, Lord, Khata.
When his lordship was High Court.
Yes,
judge,
Lord.
What is the direction?
Direction, Lord, to issue a Khata. To enable the said process, the petitioner shall now file a certified copy of this order and fourth respondent along with the supporting document within 2 weeks from the receipt of a copy of this order. And receipt of the same, the consideration of the manner as stated shall be made with fourth respondent. The result of the consideration, one way or other, in accordance with shall be intimated to the petitioner. So, Lord, it is directed authority to take a call on, Lord. Lord, this has been not considered. Then again, Lord, I am forced to file one more writ petition. Your lordship will get it, Lord, very next annexure. This court, Lord, called them, Lord, the authorities and reprimanded them, Lord, for a deliberate action, Lord, sitting over the orders passed by the deputy commissioner. Since, Lord, these sites are, Lord, granted sites. Lordship, I will take your lordship, Lord, consent paragraph, Lord. Para 7 of the, Lord, Justice, Honorable Justice Raman Reddy's judgment, Lord.
This is the second time.
Second writ petition. Para 7, Lord. It is high time that the state government and its officers take note of situation that they have let loose persons who are incompetent in the absence of training since no knowledge of law to decide the civil rights of the parties under the Karnataka Panchayat Raj Act. The state government must wake up to this clarion call, failing which the constitutional court will be flooded with the representation types of cases regarding being had to the finality of the order passed under section 269 of the act. In the result, Lord, the petition is being allowed, it has been directed. Lord, against which, Lord, still they don't do it, Lord. They file a writ appeal. Writ appeal, Lord, when the court, Lord, came on heavily, Lord, when it is supposed to be, Lord, imposing a heavy cost, it is dismissed the appeal. That time, Lord, they have withdrawn this. Thereafter, Lord, they have issued a Khata. Then, Lord, we made an application to, Lord, issue a e-Khata to the panchayat. It is a duty of the panchayat, Lord, to get that work, Lord, done from the ADLR by taking whatever, Lord, assistance. Now, Lord, we are making that to make that application again, Lord, they did not consider. We came before this honorable court But this honorable court not specifically directed both the authorities, not annexure K. Annexure K, 46, not it is para 48. The learned High Court government pleader appearing for the respondent number 1 and 2 submits that the survey can be conducted only after 11 documents are furnished by so and so Gram Panchayat, and unless and until the said document furnished, the survey subject property cannot be conducted. Therefore, it is expedient to dispose of the writ petition directing third respondent to furnish the relevant documents to the first respondent to conduct survey of the subject property within a period of 4 weeks from the date of receipt of certificate copy of this order. And upon receipt of the said document, the first respondent to conduct a survey, submit a survey sketch to the third respondent within 2 months thereafter. So there is a specific direction to both the ADLR and the Panchayat to do their work.
Now
Right.
that survey sketch has been submitted.
Survey sketch they prepare and they not put an full stop that not somebody has objected, so therefore we cannot issue it. Then I went and under the contempt law. In contempt, they have reported, see, this is the survey sketch we have prepared, but they have not uploaded it online so that the Panchayat cannot access it. They take shelter and somebody has filed a complaint. That I'll have produced annexure R.
Now let him come. I'll pass over.
Please.
Let him come. Now whatever you say, unless it's done in his presence,
Please, my lord.
we'll pass some direction. We'll not dispose it up. We'll keep it pending only. till
Please,
it's done. Pass over.
32. Dapat.
For the respondent.
Yes.
That's on the last occasion, my lords, there was.
What
a
happened to
tenta-
that settlement?
The fourth respondent had suggested that I'll consult my, this thing, don't know.
Waiting for fourth respondent. Kindly return next. Settle the matter.
Huh?
Matter settle ಆಗಿದೆ.
ಅಲ್ಲ ಆಯ್ತು ಎಷ್ಟು ಸತಿ ಹಾಗೆ ಆಗ್ತಾ ಇದೀವಿ ನಾಳೆ ಬಾ ಲಾಸ್ಟ್ ಟೈಮ್ 2 times you have taken time, isn't it?
ಅಷ್ಟೇ ಮಾತಾಡಿದಾರೆ.
ಅಲ್ಲ you must keep your party present, otherwise the seriousness of the court
Party
proceeding
is
will
present,
be.
my lords.
Huh?
Sorry, party is present.
Fourth respondent.
Oh.
Now you find out now what is the problem. Your party is present, you ask him.
He's the son of the fourth respondent.
No, you want some mediation or it can be settled or what?
But, in fact, we have myself, that is a petitioner. and
We
third
have settled, my lord.
Huh.
Only thing is that we should get the response from the fourth respondent, whether they are agreeable for the settlement or not. Now they have to tell us what it is.
Huh?
Kindly have 2:30.
What is-
Tomorrow, my lord.
Other-
Tomorrow.
Other date,
Huh?
otherwise any other date.
No, now nobody is forcing. You have to take a call. You want to settle, settle it. If you don't want to settle, don't settle it. Relist the matter next Tuesday. You ask and you find out. We'll have it on next Tuesday.
Please. Tuesday. Next.
33.
Kindly pass over, my lord. Senior.
May I respectfully submit, my lords. Annexure A, please, my lords, is only a show cause notice. There RMP 2015 road is there, please, my lord. That needs, my lords, an expansion at a later date. What we are telling them is do not go ahead with the construction without relinquishing a portion of it. In that regard, we issued a show cause notice to them. If they can reply to us, please, my lords, whatever is there, we'll
Correct. How
consider
you
it.
can insist on leaving of road
No,
without?
that is a requirement, my lords. When they come to us for without sanction, they're constructing. The first instance is without sanction, they are constructing. And the second aspect is that is an RMP 2015 declared road. So that is not always required for future expansion. So what we are respectfully submitting is, that is in that regard only we issued them a notice, my lords, at annexure A, show cause notice. Let them reply to that, please. If they construct, my lords, tomorrow we will get nothing. The public at large will is a very narrow road. And tomorrow if they construct and go, my lords, public at large will be the sufferers, not before the court.
Yes.
So therefore, my lord, let them give a reply to the show cause notice and thereafter we will take a call.
But not the question of reply to the show cause notice. But we have put up a construction there and it's a road. What is road called as peripheral ring road
via Gunjur Palia, Vartur. But that is near the Gare School. They must give us what should be the area under which we can put up construction. But we have given a representation also. I have placed that representation before this court with my amendment to the writ petition. I have given a representation and I also sought for amendment. It is said 45 meters road. What my learned friend said is not correct. If my construction is after 45 feet, but I can retain it.
So you demarcate it at the spot.
The reason why we have given them a show cause notice, please, my lords, we will have to do the necessary.
But the show
They-
cause
that
notice
stage
does
they have
not
rushed,
show.
my lords. My respectful submission is, let them give the reply to this, my lord. We will consider it, please, my lords, and thereafter, please, my lord, the matter could be disposed of one way or the other.
Correct. Now, if it's only the issue that there's a road,
No, the RMP road. It is an
Correct.
RMP road.
if that is so, let him be present at the site.
Please, my lord.
You point out, now suppose his land comes outside the road or he's ready to leave it, there ends the matter.
Please, my lords.
So he'll fix a date,
Please, my lord.
let him appear, be at the spot,
Please,
let your engineers be there.
please. my lord.
You show the location of the road, then
Please.
what is to be done, we can decide.
Like now, many a time, my lords, what happens is from the periphery, we start to mark and come. Until the other, we'll start to mark and come. So this place, please, my lord, they may not eventually have. I'll request my engineers-
Alongside the road, there are.
I will request my engineers, my lords, to do the needful, please.
The petitioner to be present before the
Let's say the assistant executive engineer,
assistant executive engineer.
executive engineer, my lords.
before
Road,
the-
this infrastructure and road development.
Before the fourth respondent.
Fourth response.
We'll fix a date, let him fix a time for spot inspection. Before the fourth respondent on date two. On 24th. The fourth respondent thereafter is to fix a time for his presence at the site and point out the alignment of the proposed road. Relist the matter on 7th,
The timing, my lords, in the morning he will present.
11:30.
11:30.
Yes.
Oblige.
34. Saravana, yes, 34.
Grateful.
Weeks accounted for. Number 34, for the petitioner in this case, my lord. Short accommodation.
Serial number 34, undertake to appear for respondent number 7. Last date of occasion.
So and so undertakes to appear for respondent number
7A to 7C,
7.
7A to C. Last date, application has been allowed, impeding application allowed. As per the order of the Supreme Court, they have amended the petition below.
Yeah. Amendment.
Number
8 to 10.
7A to C, my lord.
My lord, 7A to
8 to
7C.
C and the other.
Serial number 34, my lord.
No, correct.
34.1.
34.1, my lord.
Case number.
Case number
322.
35540.
3224.
322 for already entered appearance for respondent number 4, my lord. Let the last date will allow you. The petition.
No, who are you going to appear for?
My lord, in
Party's name, you tell me the party's.
in WP number 33540.
Yes.
Void order dated 20th/12/2024. The respondent number 7A to 7C were implemented.
Order dated
2012/2024. The Mayura groups.
No, order, where is the IA allowed? Source.
They already amended, they already carried out the amendment as.
Source.
They were served. Just 2 days back, you have received the summons from the Sango Court.
ಅಲ್ಲ ಆಯ್ತು ಯಾವ್ದು ಯಾವ್ದು
The order is there, madam. Shri Saravana S. The Learned Counsel for the petitioner reserved on the grant of ad interim order as also the application for implement in IA number 3 for 2024. The impute resolution is to issue trade license to the proposed respondent. The new of the IA number 3 for 2024 itself, the application has been allowed. They carried out the amendment also, we have received the summons also.
32245.
Order.
Impleading is filed in which writ-
IA number 3 of
IA number 3 for 2024.
2024.
which writ petition you
In
have
double
filed?
3350 of 24, my lord. That is serial number 34.34, my lord.
That is
34,
to-
34
that is to
itself.
be allowed.
Yes, my lord.
That has been allowed, madam.
Allowed, my lord. Amendment is also carried out.
Where is that order?
My lord, order dated 20/12/2024.
IA is allowed and
Yes, allowed.
Please, my lord.
So now you so and so, Learned Counsel appears for respondent
7,
7
8.
to 10. 7 to 10. ABC alla 7 to 10. In WP 33540 of 24. Now tell me. Yes, now tell what.
Summons also. But
ಹೇಳಿ.
in the summons, my lord, 7A to C. That's all.
ಆಯ್ತು, but ಇಲ್ಲಿ ಇರೋದು
Great.
7 to 10.
Yes, please.
Now what is the main matter now? What is the main matter?
And with respect to the writ petition number 32-245, my lord, the petition become infructuous in of the order passed by the
Put it.
34.1, my lord.
Yes.
The challenge the order dated 20th/11/2024 passed by the second respondent, my lord. That is the executive officer Nelmangla Taluk, Nelmangla. So thereafter, on 8/1/2025, the office of the Tahsildar has already passed an order against which the writ petition serial number 34.2 has been filed, my lord. So therefore, the writ petition number 32-245, which is serial number 34.1, become infructuous.
Yes. What about 34.2 and
34.2 and 34 are maintainable now. Except 34.1. That 34 are
now pleadings are complete?
Readings is not completed.
We have to file.
Your statement of
Yes.
Please,
objection.
please.
This is the matter. In B group, week after next, pleadings to be completed by the other side.
My lord, interim order may be extended, my lord.
Interim order in operation is extended till the next date. Yes.
35,
Please.
Somsekhar case.
I pay for the proposed respondent, my lords.
There are two writ petition.
Yes.
Your Lordship may kindly take up the first writ petition. 34028 of 2024. This is a no confidence motion made against the petitioner. Your Lordship may kindly see, my lord. The petitioner was the president of our third respondent, Panchayat. But a no confidence motion has been moved against the petitioner on 3/11/2024.
13.
Annexure blood A,
So 342
annexure B, my lord. 13/11/2024.
34028.
Wait.
Annexure.
Annexure B, page 13. This is the no confidence motion. A petition has given to the Assistant Commissioner for calling up no confidence motion. They have expressed their this one to the Assistant Commissioner. Your Lordship may kindly see annexure B for a moment. This is not filed under form 1. This is actually a complaint has been made against the petitioner. I can read, my lord. ಹಿರೇಕಾದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ವಿಶ್ವಾಸ ಸೂಚನೆ ಮೇಲ್ಕಂಡ ಸಂಬಂಧಿಸಿದ ಅಣಸೂರು ತಾಲೂಕು ಗ್ರಾಮದಲ್ಲಿ ಪಂಚಾಯತ್ ಒಟ್ಟು 10 ಸದಸ್ಯ ಸಂಖ್ಯಾಬಲವಿದ್ದು 16 ಸಂಖ್ಯಾಬಲವಿದ್ದು ಅದರ ಪೈಕಿ ಹಾಲಿ ಅಧ್ಯಕ್ಷರಾದ CH ರುಕ್ಮಿಣಿ ಅವರು ಅಧ್ಯಕ್ಷಸ್ಥಾನದಿಂದ ವಜಾಗೊಳಿಸಬೇಕೆಂದು ಸೂಚಿಸುವ ತಮ್ಮ ಉದ್ದೇಶ ಬಗ್ಗೆ 12 ಜನ ಸದಸ್ಯರ ನಾವುಗಳು ಕೆಳಕಂಡ ಕಾರಣದಿಂದ ಹಾಲಿ ಸದಸ್ಯರ ಕೂಡಲೇ ಹುದ್ದೆಯಿಂದ
ವಜಾಗೊಳಿಸುವುದು ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೋರ್ this is a request for dismissal of the petitioner from the post of ಅಧ್ಯಕ್ಷ, not for ಯಾವುದು ವಾಟ್ ಇಸ್ ದಿ ರೀಸನ್ಸ್, ಯಾವುದೇ ನಿರ್ಣಯಗಳನ್ನು ಕೈಗೊಳ್ಳುವ ಸಮಸ್ಯೆ ವಿಶ್ವಾಸಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಸೋಟೋ ಕಳೆದ 1 ವರ್ಷದಿಂದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಯಾವುದೇ ಸೋಟೋ these are all the allegations made against the petitioner. Therefore, not if they want to dismiss the petitioner, they go and file the petition under section 43A and 49, 48. This is one point. But this has been, after this notice has been issued by the second respondent on 29/11/2024, annexure A, fixing a date for no confirmation motion. This is on 29/11/2024. Number date was fixed on 17/12/2024. My respectful submission in this matter, there are 2 reasons, 3 grounds have been raised. One is the petition given to the Assistant Commissioner is a complaint, not for no confirmation, number 1. Number 2, the date fixed and the petition given is behind 30 days. Behind 30 days, violates the rule 33 of the rules.
No, prima
Based on that,
just prima facie it has allegation. How you can do? 49, it must be one simpliciter.
Clear, it was.
No, just one. 49 must be simpliciter without any allegation. Prima facie, this is 1, 2, 3, 4. On the face of it is with allegations.
Go to 43A.
Page 13. This one, madam. 4 is page 13.
This has become infructuous, my lords.
1 minute. You are no local stand to argue the matter. Your application not yet been allowed. Please wait.
I've
No,
just, officer of the court, I'm assisting the court. This writ petition has become infructuous in view of the second notice, which is impugned in the another connected matter writ petition.
First
No, just
Because
1 minute.
as per
There cannot be 2 notices simultaneously. That is the law.
That was not simultaneous, Kumars. After this was lapsed.
Blood,
Ah.
yes, blood.
As per the
A-
directions of this
Blood, his
court
application
only,
not yet been allowed.
as per the
He has
directions
no
of
voice
this
to argue
court,
the matter.
he
Please
has
wait, sir.
one more notice
It is
and
between the government and me.
concluded the procedure.
If the court curtails my right to argue, I'll keep quiet.
If application is
just
allowed,
wait.
you are right.
When the court is allowing my submissions,
This
Because
are
the
not earlier
notice
petitions.
was premature notice, Adrida, open court.
You're
will-
correct.
Direction has been given to conduct prior to issue.
Where
such
is
notice.
that notice? Direction?
Yes, ma'am.
direction is at 1/2/2002, orders of this court at 1st February 2025.
First of,
1st of February 2025.
No, my lord, what on that day, what has happened? The requested issue notice, the court has given, left to you to take whatever action you want. That is the court has,
where is that order of 1?
no such order.
Let us see.
I produce my lord. It may
No, no.
first store.
1/2/25, read the order. Let us see.
It is noticed that though the requisition for moving of
The
no
requisition
confidence
for moving a no confidence motion was submitted to the Assistant Commissioner on 13/11/24. He has taken 16 days to issue notice and he has thereafter fixed the meeting on 17/12/2024. Beyond the period of 30 days, and as a consequence contravened the rules which can contemplate that the meeting is required to be called within 30 days of the requisition being made. The Assistant Commissioner to file an affidavit explaining the reasons
Yes.
as to why he did not convene a meeting within a month, and he shall also personally present before the court on the next date of hearing.
So where is the
After
permission?
this, my lord,
Where is the permission?
after this, my lord,
7/2 was appeared.
7/2,
Here is there.
I,
7/2/25 is the next order.
yes, my lord, Assistant Commissioner has filed an affidavit stating that due to administrative exigencies, he was not able to convene the meeting within 30 days. So the reasons given by him are not justified. Learned counsel for the proposed respondent seeks for a week's time. So and so, so and so. my lord.
There
After
ends,
that, my lord,
there ends the matter. After that, there is no order.
indeed. On 7/2, we have submitted a fresh
No, no,
notice.
There's
First
no,
up-
there is no, just one. There's no order in the order sheet for issuance of second.
orally it has been instructed.
How you can?
Okay.
That is what.
Now anyhow, orally I can't take notice. Now, this writ petition will have to go on the only ground that 49, it is what to say, it is issued with the allegations. Annexure B, we don't have to enter into anything else.
I file all the.
No, just 1 minute. We'll see what the issue is so that then you can reply. Now, what is the second matter? Let us have.
Your Lordship, in the first matter, while the interim order was granted, there is a specific order by interim order, Your Lordship.
In
There is
which,
an interim order.
in which matter?
In the first matter,
Yes, I've seen.
Your Lordship, is the interim order, my lord.
Ah.
Interim order on 16/12/2024. Until further orders. This is until further orders. Your Lordship, for a moment, that is very important. Oral order. The second parameter. Sri K. Somshekar submits that the court must intervene on 2 grounds. Number 1, that the no confidence motion is based on the set of complaints and the president or the vice president of a Gram Panchayat can only be.
I've seen that.
Then this is the order until further orders.
Now go to the second.
Second matter. Second. But after this, my lord, when the interim order is pending, when there is no order passed by the honorable court, Your Lordship, the notice has been issued by the second respondent, Annexure B, my lord. Annexure C, my lord.
Annexure A.
One minute. Annexure A, my lord. Annexure A, this has been received based on the, it has been issued based on the complaints, petition made by the members. They have not given even a petition also to the second respondent. I'll read, my lord. It's 10 to 25. Annexure A.
In WP number?
WP number 5589.
Now, 5589 is the second.
Second petition. First is 28.
No, but in the, now you read out the complaint given by the members.
That is first matter.
No, in 34028.
Yes, madam.
That is the complaint is at page?
Page, not
13.
Page is not 13, madam. Annexure B, page 13. This is the complaint, the petition given by the members of the Gram Panchayat. Annexure B, page 13.
Yes. So now in the second round.
Second.
Now the first matter was still pending.
Still pending. Interim order is still existence.
So in the second petition.
Second petition, Annexure A, my lord, page 12. This is the notice issued by the Assistant Commissioner. Alleging that the members has given a complaint. So also. Somshekar,
just one. In the second writ petition 55989.
Yes, madam.
Where is the complaint of the members?
No, there's no complaint, madam. There is no complaint at all. Notice has been issued by the Assistant Commissioner. No complaint at all. There is no, on the same day, whenever the matter came up with the honorable court, same day this notice has been issued.
7-2, there is a reference number 2, my lords. We have moved a fresh no confidence motion on 7/2/2025.
Same day. How the members have given a complaint?
Now, just one. Now, which is the rule which says when one is pending, you can't take up next?
Due to effects of time, first no confidence motion had lapsed.
No, that I'll see. I'm saying there is a provision which says you can't have 2 simultaneously. Which is that provision?
Rule 3 governs the motion of no confidence motion, my lords.
There is a provision which says that when one is pending, you can't do the second. Which is that provision I'm asking? Huh?
3 subclass 2. Motion no confidence, so on.
It says only after the stay is under the rules. Rules could. Huh? No, that's not a question.
That is not.
Whether it's permissible,
My right
whether
is
it's
affected.
permissible or not, that's all.
My right is affected.
Rule 3.2.
3.2, madam.
Read rule 3.2. proviso.
No confidence motion against president. Notice intimating date meeting for the consideration, considering no confidence motion.
Reading, you're reading?
3-2, my lord. Rule 3-2.
The assistant commissioner shall thereafter convene a meeting.
The assistant commissioner shall thereafter convey a meeting for the consideration of the said motion at the office of Gram Panchayat on the date appointed by him, which shall not be later than 30 days from the date on which the notice under sub-rule 1 was delivered to him. He shall give to the members a notice of not less than 15 days, 15 days clear notice. Such meeting in Form 11, Form 2, sorry, Form 2.
Is there no provision which says within 6 months you
No
can't?
problem.
That is, my lord, if he fails, meeting fails, within
Rule
6 months,
three
you
to
cannot call the
11.
meeting. That is different aspect of the matter.
Okay, go to the proviso.
Provided that where the holding of such meeting is stayed by any order of the court, the assistant commissioner shall adjourn the said meeting and shall hold the adjourned meeting on a date not later than 30 days from the date on which they receives the intimation about the vacation of the stay. After giving the members a notice of not less than 15 days, 15 clear days, such adjourning meeting. This is my lord. Once the interim order grant, unless it has been vacated, the question of issuing notice by the second respondent does not arise. In our matter, there is an interim order pending.
49.
No, but how did the AC issue? Huh? No, correct. Here it's not yet failed. How? Correct. How can,
This is different.
how can, no, just one. How can second notice be issued when the first one is still under consideration?
Upon the directions, oral.
Meanwhile, kindly pay annexure A in 5589, Lordship, page number 12. The respondent number 2 has clearly stated that. Kindly, meanwhile, Lordship, kindly permit me to read that. ಹುಣಸೂರು ತಾಲೂಕು ಹಿರಿಕ್ಯಾತನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ 12 ಜನ ಸದಸ್ಯರುಗಳು ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣದ ಸಂಖ್ಯೆ 34028 of 24 ಅಲ್ಲಿ in page number 12 in 5589 annexure A.
This is wrong. I said in my petition.
Permit me to read that, Lordship. ಹುಣಸೂರು ತಾಲೂಕು ಹಿರಿಕ್ಯಾತನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ 12 ಜನ ಸದಸ್ಯರುಗಳು ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣದ ಸಂಖ್ಯೆ WP 34028/24 ಅಲ್ಲಿ ದಿನಾಂಕ 7/2/24 ವಿಚಾರಣೆಯಂದು ನೀಡಿರುವ ನಿರ್ದೇಶನದಂತೆ ದಿನಾಂಕ 7/2/25 ನಿಯಮ 3(1) ಅಡಿ ಸಲ್ಲಿಸಿರುವ ಅವಿಶ್ವಾಸ ಸೂಚನಾ ಮಂಡನೆ ನೋಟಿಸ್ ಅನ್ನು ಪರ್ಯಾಲೋಚಿಸಲು ಹುಣಸೂರು ವಿಭಾಗಾಧಿಕಾರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ದಿನಾಂಕ 28/2/25 ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ಹಿರಿಕ್ಯಾತನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಕಚೇರಿಯಲ್ಲಿ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆ ನಡೆಸಲಾಗುವುದು.
Now, where is that 7/2/25?
7/2/25 is Lordship.
They have not produced it. Petitioner has not produced it.
Petitioner has not produced it. We
I
given
mean,
that requisition. Based on that requisition
No,
only,
they must have produced. I am not producing. The 7-2 ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವರು. Notice.
ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅವ್ರ ನೋಟಿಸ್ ನಮಗೆ
Show me.
ಮಾಡಿರೋದು Lordship.
Show-
We
Show to the court.
How can you have two now?
May I make a submission on this point, my lordships? How can we have two notices?
Yes.
It was the grievance of the petitioner that discussion on no confidence motion cannot be held beyond the period of 30 days from the date of submission of form number 1. It would be in violation of rule 3 sub rule 2. This was their ground and this was their argument in securing the interim order. If we take the recourse of the proviso, again the discussion will be only after 30 days. They could not even take the benefit of the proviso because even if this date is fixed or if the no confidence motion is continued, it will be beyond 30 days, which will contravene rule 3 clause 2. And second question which my lordship had raised, there is no bar for submitting a successive no confidence motion.
That I'll consider.
One aspect is the very ground that,
According to me, there's a bar.
my lordships, if the first notice has by the effects of time has lost 17/12, the meeting fixed was on 17/12, that will be beyond 30 days from the date of submission of form number 1.
Once there is an order of stay, in terms of rule 3(2) proviso, after the stay is lifted, proceedings continue. Till that is decided, second one cannot be initiated. Simple as that.
Even if the stay is lifted, the meeting will be held beyond 30 days.
There is no bar for that. That's
There is
what
a, that is what rule 3, sub-rule 2 reads.
No, that has been interpreted. That has been interpreted. There is no such bar. It says, according to the proviso to rule 3(2), it says, provided where such meeting is stayed by order of the court, Assistant Commissioner shall adjourn the meeting and shall hold the adjourned meeting on a date not later than 30 days from the date on which he receives intimation about the vacation.
That is the.
Indeed, if the first notice itself is fixed, if the notice of first meeting itself is fixed beyond 30 days, what will be the position of law, my lords?
That
Again, it will be hit by rule 3(2).
No, that I'll consider. That I'll consider. Second one, according to me, is impermissible. You can withdraw, you can initiate afresh. Otherwise, I'll pass orders. Yes.
Yes, seek for a week's accommodation, my lords. I'll take instructions, I'll make submissions.
No, that doesn't operate. Provisor doesn't operate. Provisor doesn't operate. 49 provisor doesn't operate because it was not put to vote. That time aware. Correct. But that is why this is the only restriction. No. You can't have double. It's up to you. When do you want?
Next week, my lords. Oh, 4th.
List the matter only on that point.
And on that part, I'll make submissions.
There is a notice issued, my lord, to call a meeting for selecting the president post also. Just now I received the meeting notice, my lord. It's called issued on 12/3, calling on 21/3. 21 is the election for the president.
Is it the
That has to be
558
stayed.
order sheet code 558?
Already there is an interim order making all proceedings subject to the result of this writ petition.
Now you'll have to stay. You can't have election. Where is that? You file that with a memo. When is the election?
21, sir. 21/3. Day of tomorrow.
I'll have it tomorrow. Otherwise, I'll pass over. You file I'll have it tomorrow. You file an application for stay.
I'll file.
Relist tomorrow in the
Much
preliminary hearing list. Now, if you have instruction, you can make a
I'll
submission.
make submission tomorrow, my lords. Grateful, my lords.
Anand K.
Appear for the petitioner's.
Petitions are very worship. I file it. So on the paper miss agiyadu idagide just 2 days your worship. Within 2 days I furnish it.
Relist the matter. Short date.
26th.
26th.
Ah.
37.
The orders.
My lords, appear for the petitioner, my
Same
lords.
state.
For the petitioner, my lords, in 37.
37.1 ಅಲ್ಲಿ.
My lords, 37, my lords, first 37, I had filed an IA for modification of interim order, my lords. In that, my lords, I challenged the demand for payment of property tax within the panchayat limits, my lords. This honorable court had granted a stay. However, my lords, the modification I sought was that demand notice was issued for 10 years, my lords, from 2013 to 2023-24. However, my lords, until 2021, there was 100% exemption. So, my lords, requiring me to pay 30%, even though that amount would be a little burdening financially, my lords. I only sought for payment of 30% from 2021 onwards, my lords. Kindly see page 44, my lords.
Aship Tirama 37 is consent. 37 ಅಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದು ಚಿತ್ರದುರ್ಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅಪೇರ್.
In 2270.
Yes. 37.1 ಅಲ್ಲಿ I have appeared ಕಂಡು.
In 2270.
New first one,
Who appears for Nagaram Gere Gram Panchayat, Chalikere Taluk?
Praveen Kumar.
Praveen Kumar.
My lords, one submission, I had informed Mr. Praveen Kumar, he told there is no such instruction from the concerned PDO.
But once.
The notice has been served to them,
In seal number 30.
and now they are issuing notice to the petitioner school.
No, where's the notice?
My lords,
Notice
emergent
is-
notice has been served to the respond number 2.
Records don't show that. Office to put up report regarding notice issued to R2. Petitioners at liberty to take out notice by way of hand summons to the second respondent. Now, what was the interim order passed now in 2270?
My lords, the interim order was that the petitioner was required to pay 30% of the amount demanded by the panchayat, my lords.
Yes.
My lords, at page 44, Annexure J, kindly see, my lords, the demanded amount is from 2012.
No modification. It will have to be placed before the same.
My lords, yes, my lords, but it's a simple issue, my lords. It's just that
No, no,
until
that-
21, my lords.
No,
we had
that I
understood
can't.
the intention.
No, according to procedure, it has
Yes,
to
ma'am.
be placed and direct the office to place it. Then let it come back after it, this modification IA is considered.
Please, my lords,
Hmm.
please, my lords. Yes,
IA 1 of 25 to be placed before the same bench.
D-link 37.1.
Huh?
37.1 D-link, my lords.
37.1
D-link.
is to be delinked and listed.
They pertain to the same issue, my lords. We have challenged the.
That's okay, let it be separate. 37.1 is delinked. Now in 37.1, we'll
Ma-
have it next week. You move that matter and get the
Yes.
modification done and we'll have it.
Yes, my lords. Yes.
37.1 list the matter week after next. After you get the modification, immediately you move this. I'll take
Great.
it up on a memo.
Grateful.
38, Mahesh BJ. Pavan Kumar. 38.
Phone number 5 is the neighbor, my lord, who has put up construction in violation. And also using the property for commercial purpose, that is the allegation, my lord. Since no action was taken, the writ petition was.
Provisional order is issued, my lordship.
Huh?
Provisional order is issued.
Ah.
They have constructed 1 floor extra and there is some setback violation and usage is also.
In the provisional order, is there any direction to stop construction?
Which construction is completed.
Huh?
Construction is.
Was already completed.
So you place it on
I will
record.
produce it on, place it on.
Place it on record. Let us see.
Yes, I will file along with that.
The counsel for respondent BBMP submits 248
1 mile.
Huh?
248-1
One order.
along with the deviation is mentioned.
Order has been passed. Same is placed on record. For
is-
further steps pursuant to the 248-2 order, relist the matter. We'll have it after 10 days.
Yes, sir. Because by that time they will also file a reply.
3rd of April.
3rd of.
Office to put up report regarding notice issued to R5.
39. Bachan GA. Somaya ji.
Appeal
Right.
for the petitioner, my lords. The petitioner is leaseholder of fishing rights for.
Huh?
Service is not complete. Matter has to be disposed of. Service is not complete.
Who's the answering respondent?
Contesting.
Huh?
Contesting.
Who's the contesting respondent?
Yes.
Before the trial, court, the fifth respondent has filed an appeal before the Tashildar, my lords.
What has happened to that appeal?
The appeal is not yet decided, my lords. So it's going on like orders, my lords, due to the political pressure of.
Yeah. He gave me a copy of the writ petition yesterday. This may can you take next week?
No, my lords, I have been trying.
Relist the matter. Date put.
2nd of April.
Yes.
Next week,
40.
my lords, any date next week.
Second, let us see. Let him complete. Yes.
40. Gaurav, yes.
Petitioner to serve copies of petition on counsel for the respondent. List week after next.
41 again, 42. Pradeep C. Yadav.
42, we have conducted an inspection, your lordships. We have found a violation and issued notice under 248, 1 and 2. Nothing may survive in the petition anymore.
No, you complete, you carry it further on.
Yes,
Let it reach its logical end.
yes. 13.3, we have issued the notice. We have given them 15 days time to rectify the violation. Starts from page number 3, your lordship.
So now there's a condition here not to carry on further construction.
Yes, there is a condition. Page number 4, last sentence, your lordship.
So then we'll stay for the construction, let us.
I believe there's already a stay there.
No, your lordship, there's no stay. Let there be an interim order passed by this honorable court, your lordship.
Learned
Because even as of
counsel
today,
appearing for the respondent BBMP has filed a statement of objections and submits that order under provisional order under 248(1) has been passed. Full stop. Perusal of the same would indicate there has been deviations. Full stop. It is also noticed that in terms of the provisional order, there is a restraint on further construction. Full stop. 248(3) order is still to be passed.
Yes.
Accordingly, the respondent number
3.
3 is restrained from putting up any further construction.
Yes.
The respondent number 3 is restrained from making any further, any construction. The petitioner to file photographs depicting the stage of construction within 3 days in the registry. Respondent BBMP to proceed further. This is the matter after 10 days.
10 days.
43.
please.
Wait for it, after 10 days.
10 days.
We'll have
That's
it
going
after,
to- Yes,
huh?
my lords, 10 days would be too short.
after 2
Because
weeks.
15 days would end on 28th or 29th. Be first week of
First week of
April.
Let there be a date.
3rd of April.
Great for me.
43.
Let it be carried till the logical end. Let us see.
My lord,
43 appear for petition.
43.
I pray for 2 weeks' time in this case, my lord, to take.
What is it, my lord?
43.
43.
43.
It's already an interim order, ma'am. That may be continued.
Interim order earlier granting is extended till the next date. This is the matter. After 2 weeks, date good.
Second. 44. 44.
I was supposed to give 25% of the amount, but they are not taking the DDs, madam. We have the DD with us, but they are in the office, they are not taking.
Instruct them to take it, ma'am.
Now the still time is there, or we have to extend the time?
Madam, the 3 days time was granted, but that is, that will be expired.
Ah.
Let him take and give it to them.
He has his own
His-
difficulties.
But office will not take, madam.
Counsel for the petitioner submits that demand draft dated
Madam, it was 20th/1/2025, revalidated. Original date is.
demand draft was not accepted by the respondent BBMP office. Full stop. Petitioners, the respondent is directed to accept the demand draft.
Yes, ma'am. I will instruct them to.
Madam,
He
and-
list online or what demand draft? What
Malad,
So we
the
have
what,
to-
Malad, there is a problem. They say that it has to be taken online and entire dues has to be paid. It cannot be given in piecemeal. These are the two objections which they take when we go and pay piecemeal. For now, I am saying that this should be adjusted towards 2021, 21-22. Other things, Malad.
Manually, we can take ma'am. Online, because it's a software generated challan will be generated. So in that, it will show the full amount on. So manually, I will ask them to take it.
Relist the matter on. Now, what is the next stage now?
My lord, now this,
Auction,
You have to complete it.
complete instruction.
Relist on
Week after next time.
week after next.
45? Adinda?
my lord, the time may be extended till, I will give,
Previous matter only, in light of the submission made, time for making payment is extended for a further period of 1 week.
my lord.
45?
Interim audit is extended. Yes,
This case, my lord, last occasion, as per the direction, I already deposited the amount.
Deposited.
I filed it also, my lord. Acknowledgement is before this honorable court.
the
Today morning, I filed the acknowledgement. Payment is done 1 week back itself, my lord.
memo file along with receipt, having deposited tax due of rupees 18,750.
That is around 18,700.
750.
Yes.
Full stop. Now what is the matter now?
The objection in this, my lord, that they are asking us to produce the original notices. I have never been served with original notice by the department. They just came and showed me in the mobile and they went, my lord. I could only take a screenshot of that I produced. I filed an IA for dispensation also, my lord. I don't have the originals at all, my lord, of annexure.
That is insofar as the office objection.
Office objection is concerned, my lord. So far as the matter is concerned, my lord.
Order sheet. Order sheet. Office objection. So far as office objection serial number 1 is concerned, counsel for the petitioner submits that a certified copy was not handed over to the
No.
petitioner.
Both the annexures, my lord.
Accordingly, said office objection is kept in abeyance for the present. Then the others, you are still to comply.
Other objections have complied.
Full copy of annexure B to be filed.
That is also not given. Only what has been given, I produced it. And everything they are given me in mobile only, ma'am.
The office objection at serial number 3 is kept in abeyance in light of the submission that petitioner was not served with a full copy
Copies.
of annexure B.
A, B, C, all the three, my lord. All the full copy of all the three annexures, my lord. I filed the dispensation for that reason only, my lord.
Yes, Pawan, what are the instructions?
I need to complete my instruction. Its amount is just 36,000.
Huh?
The amount which is due is 36,000. I will just.
My lord,
complete my
your lordship,
instruction.
I submitted in last occasion.
Yes.
The condition of the house, your lordship may kindly see, and the condition of a watchman who's living there. He
Okay,
needs
now-
time.
Now
He
we
needs-
stated, now we have stated.
Yes,
Let's see, let them complete the instruction.
please, my lord. Only one submission is like, with lot of difficulty, this 50% itself, they have deposited as per the direction of this honorable court.
List after 2 weeks.
Interim order may be continued, ma'am.
Interim order in operation is extended till the next date.
46,
Obliged.
Shiv Prakash.
I appear for petitioner, my lord. Paper respond number 4, my lord. My lord, the respondent, fourth respondent has filed application for vacating stay. My lord, matter may be disposed of in B group.
This is the matter in B group.
Hello, one submission, my lord. This property belongs to my self-acquired property, my lord. The petitioner no way concern of my property. They can see the annexure A, my lord. Annexure shows that it is a
My lord,
partition deed, my lord.
My lord,
Annexure A.
in this rate petition, my
Here
lord,
it is.
I have challenged the.
And submitting, my lord. Annex A is laying upon is laying upon the annex A, my lord. A, it is a incomplete partition deed, my lord. Incomplete on all members are not signed. It is my contention is that it is a fabricated one, my lord.
and it's my own property.
No, now, is there
The
any,
site was granted by the government of Karnataka, my lord.
is there
In
any,
Hakkupatra.
is there any civil suit pending?
No, my lord.
No, my lord.
They not approach any civil court, my lord. My, and the construction, my house was on the lying on. Even though I produced some a photograph, my lord, I produced a photograph also. My house is under the construction. The petition not permitted to construct it for the construction, my lord. ಇದರಲ್ಲಿ ಬಿ ಗ್ರೂಪ್ ಮೇಲೆ ಹಿಯರಿಂಗ್ ಮಾಡಲಿ ಏನು ನೋ ಪ್ರಾಬ್ಲಮ್ ಬಟ್ ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಟ್ ದಿಸ್ ಕೇಸ್ ಯುವರ್ ಆನರ್ ದಿ ಮೋಟಿವೇಶನ್ ಆಫ್ ದ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಲೆಟ್ ಮೀ ಕಂಪ್ಲೀಟ್ ದಿ ಹೌಸ್ ಮೈ ಲಾರ್ಡ್.
No, my lord. My lord.
ಹಾಫ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದೆ. It is under construction. It was half construction, my lord. It is only Shubham district.
Kindly
Only
see
rainy season, my lord. At least I will able to construct my house and I can stay in the house, my lord. Now I am staying in the some other house, my lord, along with my only wife, my lord. I'm age of 99. The petitioner is giving me a lot of problems, my lord. I given the a complaint to the,
Let them complete the construction. What
yes,
is-
my lord.
No, my lord. Your lordship kindly
No,
see.
go
the-
to page R2. Go to R2, page 27. Can we remove, can it,
Your lordship kindly see the.
go to annexure R2. Look at the photograph.
Yes,
Now
my
you
lord.
tell me, let him complete it, no further
ಇಲ್ಲ
construction.
ನನಗೇನು ಇಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಕಾಪಿ ಏನಿಲ್ಲ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್
Demise that
ನನಗೇನು
Page
ಕಾಪಿ
28.
Page number 28, my lord.
They've demolished the house and
Yes, my lord.
my lord,
they're putting
It
up.
was old, my lord.
Huh?
my respectful submission, my lord. My lord, the, as per the partition deed, my lord, the Khata mutated in my name. After lapse of 11 years, my lord, he filed appeal without filing the application for condonation of delay. Your lordship kindly see annexure K. Annexure K, my lord, he claimed his ownership on the basis of the concocted Jubani, sir. Your lordship kindly come to annexure
A.
Annexure. Your lordship kindly annexure K.
No, which is the impugned order?
Annexure K at page number 77.
A has been eaten up. You replace it by another copy. Read the, so what are the facts now?
My lord,
What are the facts?
there was a, my lord, Jubani say in the year 1988, 15/5/1988. My lord, as per the Jubani say, my lord, the property in question, site number 9, my lord, is fallen to my share. Your lordship kindly see annexure A.
A itself shows, my lord.
Just wait. Yes. No, but
Thereafter, my lord, I have filed application before the third respondent Gram Panchayat to mutate the site in my name. My lord, accordingly, my lord, the third respondent has passed an order in my favor and mutated the site number in my name.
annexure A,
Please,
take me to the typed copy.
my lord, thereafter, my lord,
Point out in the.
please, annexure A,
Point out in that oral
Please.
part.
page 31.
Page.
31.
ಹಾ.
ನಾಲ್ಕನೇ ಎಸೆದಾರ ನಾಗರಾಜ್ ಬಿನ್ ಶೇಷ್ಗಿರಿ ಶೇಟ್ ಇವರ ಹೆಸರಿಗೆ ಬಂದ ಸೊತ್ತುಗಳು.
Petitioner is the fourth.
ಫೋರ್ತ್
ಹಾ.
ಇವರಿಗೆ ಬಂದ ಸೊತ್ತುಗಳು. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೆಲಡ್ ಮಿಡ್ಲ್ ಆಫ್ ದಿ ದಟ್ ಪೋರ್ಷನ್ ಮೆಲಡ್ ಫಸ್ಟ್ ಇಂದಾನೆ ತೋರಣಕೊಪ್ಪದ ಸರ್ವೆ ನಂಬರ್ 17ರಲ್ಲಿ 37 ಗುಂಟೆ ತರಿ ಜಮೀನು, ಪೂರ್ವಕ್ಕೆ ಹಳೆ ಮರೂರು ರಸ್ತೆ, ಪಶ್ಚಿಮಕ್ಕೆ ಗಂಗಾಧರ ಗೌಡರ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಗಂಗಾಧರ ಗೌಡರ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ಇದೇ ಸರ್ವೆ ನಂಬರ್ ಉಳಿದ ಜಮೀನು ಹಾಗೂ ತೋರಣಗೊಂಡನಕೊಪ್ಪ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ಕಾರ ಸೈಟು ಮಾಡಿ ಶೇಷ್ಗಿರಿ ಶೇಟ್ ಬಿನ್ ವೆಂಕಟರಮಣ ಶೇಟ್ ಇವರ ಹೆಸರಿನಲ್ಲಿರುವ 9ನೇ ನಂಬರ್ ಸೈಟಿನಲ್ಲಿ ಕಟ್ಟಿರುವ ಮಂಗಳೂರು ಹಂಚು ಹೊದಿಸಿದ ಪೂರ್ಣ ಮನೆ ಮತ್ತು ಮನೆಯ ಜಾಗ ಮತ್ತು ಮನೆಯ ಮುಂದಿನ ಜಾಗ, ಹಿಂದಿನ ಜಾಗ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ ಒತ್ತುವರಿ ಮಾಡಿ ಹಾಕಿದ ಅನಾನಸ್ ಹಾಗೂ ಇವರ ಹೆಸರಿಗೆ ಬಂದ ಮನೆಯಲ್ಲಿ
ತಂದೆ ತಾಯಿಯವರ ಸ್ವಇಚ್ಛೆಯಿಂದ ಜೀವನ ವಾಸವಾಗಲು ಅನುಮತಿ ಇರುತ್ತದೆ. This site fallen to the share of this petitioner herein. Thereafter, my lord, he applied
Survey number 17.
survey number not 37, 17, my lord. Site number 9.
Situated in survey number 17.
ಅದು ಬೇರೆ ಸೈಟ್ ನಂಬರ್ 9 ಸಪರೇಟ್ ಇನ್ನೊಂದು ಸೈಟ್ ಇದೆ. ದಟ್ ಇಸ್
Where is that number, site number?
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಗ್ರಾಮದಲ್ಲಿ 4th ಲೈನ್
ಇರುವ 9ನೇ ನಂಬರ್.
9ನೇ ನಂಬರ್ ಸೈಟ್
9.
ಸೈಟ್ ನಂಬರ್ 9
Yes.
fallen to my chair. Thereafter, my lord, I applied for change of Khata in my name. Thereafter, my lord, the third respondent granted passed a resolution in my favor, and also, my lord, the Khata mutated in my favor. Exhibit annexure B,
Annexure
page number 34, typed copy.
Yes.
34. ಚಂದ್ರಮುಕ್ತಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ತೋರಂಗಡನಕೊಪ್ಪ ಗ್ರಾಮದ ಡಿಮಾಂಡ್ ರಿಜಿಸ್ಟರ್ ಕ್ರಮ ಸಂಖ್ಯೆ 9 ಸೈಟ್ ನಂಬರ್ 9ರಲ್ಲಿರುವ ಮಂಗಳೂರು ಹಂಚಿನ ವಾಸದ ಮನೆಯ ಖಾತೆಯು ಶೇಷಗಿರಿ ಶೇಟ್ ಬಿನ್ ವೆಂಕಟರಮಣ ಶೇಟ್ ರವರ ಸ್ವತ್ತಾಗಿದ್ದು, ಉಳಿದ ಖಾಲಿ ಜಾಗದ ಸ್ವತ್ತು ಸದರಿಯವರದ್ದಾಗಿರುತ್ತದೆ. ಸದರಿಯವರಿಗೆ 4 ಜನ ಗಂಡು ಮಕ್ಕಳಿದ್ದು, ಸದರಿಯವರು ಜುಬಾನಿ ಇಸೆಯನ್ನು ದಿನಾಂಕ 15/5/1988ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. 4ನೇ ಇಸೆದಾರನಾದ ನಾಗರಾಜ ಸನ್ ಆಫ್ ಶೇಷಗಿರಿ ಶೇಟ್ ಪಂಚಾಯತಿಗೆ ಕೊಟ್ಟ ಅರ್ಜಿ ವಿಚಾರವನ್ನು ದಿನಾಂಕ 17/8/2009ರಲ್ಲಿ ನಡೆದ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ತೆಗೆದುಕೊಂಡಿದ್ದು, ಖಾತೆ ಬದಲಾವಣೆಗೆ ಕೊಟ್ಟ ಅರ್ಜಿ ಹಾಗೂ ಜುಬಾನಿ ಹಿಸಾಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಿ ಮೂಲ ದಾಖಲೆಗಳೊಂದಿಗೆ ತಾಳೆ ಇರುವುದರಿಂದ ಹಿಸಾಪತ್ರದ ಪ್ರಕಾರ ನಾಗರಾಜ ಸನ್ ಆಫ್ ಶೇಷಗಿರಿ ಶೇಟ್ ರವರಿಗೆ ತಂದೆ ವಾಸವಾಗಿರುವ ಮಂಗಳೂರು ಹಂಚಿನ ಮನೆ ಹಾಗೂ ಇದಕ್ಕೆ ಹಿಂಭಾಗ ಮತ್ತು ಮುಂಭಾಗದಲ್ಲಿರುವ ಖಾಲಿ ಜಾಗ ಪೂರ್ವ ಪಶ್ಚಿಮ 60 ಅಡಿ ಉದ್ದ, ಉತ್ತರ ದಕ್ಷಿಣ 40 ಅಡಿ ಜಾಗವನ್ನು ಸದರಿ ಅರ್ಜಿದಾರರಾದ ನಾಗರಾಜ್ ಶೇಟ್ ಬಿನ್ ಶೇಷಗಿರಿ ಶೇಟ್ ರವರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಲು ನಿಗದಿತ ಸಮಯದಲ್ಲಿ ಆಕ್ಷೇಪಣೆ ಬಾರದೇ ಇರುವುದರಿಂದ ಖಾತೆ ಮಾಡಲು ಆದೇಶಿಸಿದೆ. My lord, thereafter, my lord, they have passed before that, my lord, they have passed resolution also. Your lordship kindly annexure C.
Now this was challenged.
My lord, in the year 2020,
On
my lord,
On what ground?
my lord,
Then on what ground it was challenged?
my lord, before that, my lord, he concocted one Jubani say. I have produced said Jubani say also. Your lordship kindly come to.
So that is not a registered document.
Not a registered document.
Where is that? Now you have to settle it in the civil court. It
Your
can't be
lordship
done-
kindly come to
can't
annexure
be
J.
done in these proceedings.
No other go, my lord. Israel ಏನಾಗಿದೆ, it is my completely, it is my self property.
No, we
He is
can't-
depending upon the annex A, my lord.
No, I'm-
A shows that I got 6 children, Your Honor.
No, I'm not on the merits. I'm saying you have to settle it in the civil court, not in the revenue.
Yes,
court.
madam.
Your lordship kindly see annexure J.
I can't vacate it. You go to the civil court and get appropriate order.
Dispose the,
Huh?
dispose the matter, my lord.
I'm saying I can dispose the matter.
Yes, my lord.
But you will have to go before the civil court.
Yes. He's claiming the,
That
through the petition, he has to go, my lord.
No, you have to go.
I-
You have to go. Revenue entry is in his favor. The Khata was done in terms of annexure A in 2009.
And
Now you are filed an appeal stating that there is a oral sale in your favor. So you have to go to the civil court.
yes, my lord. I'll go. In this case, my lord, at the time of the change the Khata, there's no notice has been issued to me. This is behind the back. I do not know the annexure A also, my lord. I do not know the partition date. This fabricated one.
Correct, that we can't decide here.
Yes, my lord.
So you go to the civil court.
Hmm.
Khata is in his name. So if you are saying that Khata has to be cancelled, you have to go to the civil court.
Yes, my lord. Until I'll construct my house, my lord.
My lord.
I can't. I'm not going to give, how can I give permission like that? That's a matter to be decided before the civil court.
My lord, one more submission is, my lord,
When-
annexure J.
When
your-
is the sale in your favor?
No, this is granted by the government, my lord. It's in Hakapatra in the year 72-73, my lord. In the year 72-73, from that day, I'm in possession, my lord.
No, but why you didn't get your Hakupatra entered in the revenue record?
ಆಗಿದೆ ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ ಆಗಿದೆ
ಎಲ್ಲಿ?
ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ ಆಗಿದೆ ಅದು
ಕಂಪ್ಲೀಟ್ ಅವಾಗಿಂದ ಟ್ಯಾಕ್ಸ್ ಕೊಟ್ಕೊಂಡ್ ಬಂದಿದ್ದೇನೆ. I apply for the plan sanction, my lord. Plan sanction also is sanctioned by the local authority.
No,
At
no,
the time of the,
when is the mutation affected in your name?
I get from long back, ಆಗಿದೆ after ಹಕ್ಕುಪತ್ರ, my lord.
My lord, thereafter, my
I
lord,
got all the document, my lord.
my lord, as
Revenue
per the,
records,
as
it
per
shows
the partition,
stand
my lord,
Revenue records stand my name only. He is as per Annex A, fabricated the partition deed. He has changed the name from my name to his name, my lord. He has changed the name, respondent number 4 to petitioner, my lord. Without asking anything, without the authority has not issued any notice to the,
my lord, he obtained the
Respondent
order
number 4, my
annexure
it
K.
is behind the back.
We'll
The
have to
petitioner
dis-
being my son, my lord,
it
he
has
is
to-
not, he is only the behind the property. He is not looking after me also. I given the a complaint also.
Petitioner is your son.
Son,
Yes, he's my son, my lord.
What is this?
His son, my lord. I'm age of 98, my lord. I'm
partition,
suffering from
the
everything.
partition deed. Your lordship kindly
I'm
see annexure
sufferer.
J. Your lordship kindly come to annexure J for a moment.
Father,
Suffer, my lord.
no, just, father is 98, he's not going to live for 200 years. What is this? He wants to build house, who it will come to? It will come to you only.
No, my lord, there
Who
are,
it will go to?
Other children,
sir,
sir.
so much.
ಆಯ್ತು,
six
ಹೋಗ್ಲಿ,
children,
ಮಕ್ಳಿಗೆ
sir.
ತಾನೇ ಹೋಗೋದು.
My lord, as per the partition deed, my lord,
Partition is between whom?
my lord, all the members, sir.
No.
Your lordship kindly see the
6 children are
annexure
there, my
A.
lord.
No, in his last, he has brought you up, 98, he's building a house. After that, you fight over it.
My lord, your
Let him
lordship,
at least die peacefully after having built a
Yes, my lord.
house.
He's my son, my lord.
No, it's not, it's not a legal, it's not a legal issue. I'm saying at 98, he wants to build a house, no? Respect that sentiment.
your lordship kindly for a moment annexure J, my lord. J, based on that concocted partition deed, my lord, he obtained annexure K. The stamp paper is obtained, your lordship kindly come to page 73. Stamp paper is obtained on 17/12/1988.
No, now the property belong to whom?
My lord,
It belong to whom?
belong to my lord, the father of the petitioner.
The rest-
Granted, my lord, enough to the benefit of the family members.
No, that will decide. That's a different matter. In who, the Hakkupatra was in whose name?
Hakkupatra, my lord, earlier, my lord, the fourth respondent.
So
Father
let-
name.
then you created, then partition deed is created is what he says.
Yes, created one.
No, my lord, your lordship kindly see the another partition deed. So his contention, my lord, his,
Finally, it's his.
my lord,
Seal court, my lord.
11 years, my lord, up to 11 years, my lord, he did not,
Forget it.
the-
Forget it. I'm saying property belonged to him, isn't it? Property belonged to him originally. You go to the civil court and sort it out on the basis of your oral partition. Let him build a house and die peacefully. I'm saying die. Let him die peacefully. It's not fair. It. Hakkupatra is in his name.
my lord, kindly have it next week, my lord.
No,
I
no,
will-
no.
I
You
will get,
argue. Whatever you want, you argue. Equity is not in your favor. You forget about everything. Property is his name. Let him die after building a house. Then you partition it in terms of your oral partition.
I'm runningly 98 years, my lord.
Huh?
98 years.
Not fair.
98,
your lordship
still I'm,
kindly-
well, one more
my lord,
submission, my lord.
the annexure
given
K is
the-
obtained, my lord, without filing a condonation of.
Forget about everything, sir. Don't argue on technicalities. I can find a way to get over those technicalities. Hakkupatra is in his name. Let him enjoy it. You go to the civil court and establish the oral partition.
Moreover, I given the complaint to the ಹಿರಿಯ ನಾಗರಿಕ ಸಂರಕ್ಷಣೆ ಮತ್ತು ಜೀವನ
ಅಲ್ಲ,
ಕಾಯ್ದೆ
ಇವಾಗ ಹಾಕಿರೋ,
I
my
given
lord,
the
at
complaint.
the instigation of one Uday, my
Yeah,
lord, he has,
Whatever it may be, forget whatever it may be.
ಹಿರಿಯ ನಾಗರಿಕ ಸಂರಕ್ಷಣೆಗೆ ಅಧಿಕಾರಿಗಳಿಗೆ I given the letter, Your Honor. That much is harassing my man. Petition that much harassing to me.
kindly
my
have
lord.
it day after tomorrow, my lord, I will get the.
No, I don't want you to get instruction. That we can decide from record. You allow him to construct the house, subsequent to which let the,
My lord, kindly have it tomorrow, my lord,
for what? For what?
ಅಲ್ಲ ಮನೆ
Not-
ಕಟ್ಟಕ್ಕೆ
not-
ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಅದು ಏನೋ
You try to settle it, let the house be built. After
Please,
which
my lord, kindly, that's why, my lord, kindly inform the petitioner, my lord, kindly have it day after tomorrow.
deal is the matter. Hmm?
20,
21st.
my lord, interim order may kindly be extended till.
Interim order, earlier grant is extended till the next date. You see what arrangement
Please,
can be.
please, my lord, please.
given complaint, ಹಿರಿಯ ನಾಗರಿಕ ಸಂರಕ್ಷಣೆ, I given complaint to them.
Noted.
Much obliged.
My lord, I appear for petitioner in this case. My lord, the petitioner have constructed the building in the year 2022. Photographs, your lordship may kindly see it, annexure E and E1.
End of.
Now, my lord, I have executed the last sale deed on 26th July 2022. ಪವನ್ ಇಲ್ಲೇ ಇದ್ರು 21 ಅಲ್ಲಿ ಕೂಗಿದ್ರು ಅಂತ ಓಡ್ಬಿಟ್ರು. I served him, my lord. I served Pawan Kumar also. Now, my lord, on 5/3/2025, I have been served with a notice calling upon all the occupants therein to vacate. My lord, the confirmation order is of the year 2023.
What is the nature of deviation?
My lord, they allege that setback deviation and also 2 extra floors, my lord. The lordship may kindly come to the page number 84, where 85, my lord, deviations are mentioned. Building is construct.
What about the extra floors now? What is their stand on the extra floor?
But in this, they don't state extra floors, my lord. Only they say it.
Fourth and fifth are unauthorizedly constructed. Remaining we can stay. What about fourth and fifth?
Well, now in view of the new law, my lord,
No,
I may
what
be
law?
permitted.
No law. What law? What does it say?
my lord, premium FAR is available as on today, my lord.
That you buy it. I'm not going to stay it for till you buy. You buy it. It's up to
My
you.
lord, to buy that also I require time, my lord. They give a notice. My lord, if they have served upon me earlier,
Forget it. No notice is required for unauthorized construction. Remaining I'll stay. This one you do work it out however you want. Till third floor I will protect it. Let us see.
my lord, even then, my lord, order is passed by the ADTP, my lord. Zonal commissioner I have not passed. Kavita Jain judgment I have produced at annexure J, my lord.
After Supreme Court judgment, I am not following the coordinate bench. Supreme Court judgment you have seen, isn't it?
Kavita Jain judgment.
No, Supreme Court judgment have you not seen?
Yes, my lord. Yes, my lord. That
Ah.
one I have seen, my lord. That
Then-
one I have
then
seen.
That says no, in case of no plan, no discretion. I can't rent. Up to third, I'll stay it. Remaining, I'll keep quiet. Whatever you want, you do it.
My lord, subject to that, my lord, premium FIR, to avail the premium FIR, I should make an application.
That-
In the meantime, if they demolish, my lord, everything gets,
What?
my lord, I have already sold it also in the year 2022.
That is not the court's concern. That I will keep quiet. You do whatever you want.
My lord, if that is expressly stated, they will not oblige, my lord.
What I can do, premium FAR, it's up to you. I can't stay till you buy premium FAR. I
My
don't.
lord, let there be a stay for 15 days, my lord. In the meantime, I will exercise, in the meantime, I will do that.
230. You just see he's saying premium FAR. I don't know.
I will take
That you
this.
say. There are 2 extra floors. So you make a submission at 230. He's saying prima facie, he said, I'll give a stay till the 3rd floor. Beyond 2 floors, I'll keep quiet. I can't say anything on that. He's saying he wants to buy premium FAR. You make a submission on that. I said, I'm not going to wait till you buy it. I don't know what that scheme is.
My lord, one submission, my lord.
I didn't know.
That's-
My lords, may I make a mentioning, my lords? My lords, in list 2, my lords, item number 11, I'm seeking for an adjournment, my lords. And for the counsel for petitioner, my lords.
Inform the other side. Inform the other side.
I'll inform the other side, my lords.
Request. Release the matter week after next.
Your lordship,
Judge
cause
Thomas.
list 2, serial number 3, your lordship. For the respondent, I ask for short accommodation, your lordship. Opponent party is informed.
You have informed.
Yes.
Lordship. The interim order earlier granted is extended to the next date. Relist the matter week after next. Yes.
List 2, madam, my lordship, serial number 7. Pray for short accommodation, my lordship.
You appear for
Petitioner, madam. 7. List 2, yes, ma'am.
For the respondent. Short points next week.
Shall,
It is not maintainable also. Next
Huh?
week, it is not maintainable. Next week account. Sumne avara hogta ide.
intimator may be extended, my lordship.
list the matter. What is the point?
Only they are questioning the Pauti Khata. Pauti Khata has been issued to the Panchayat PDO. That was questioned. This is no locus standi version.
Huh?
It's a third party also.
Huh?
And also he has not made a party to the executive officer munde party illa ivaru.
List the matter in the preliminary hearing list on 26th.
Intimator may be extended, my lordship.
Order earlier granted is extended till the next.
List 2, my lords, 12 and 12.1. I am appearing in 12.1 for the petitioner.
Lordship, I am
He is also present, my lord. I have informed the other side, he is also present. Next week, any date may be
any
fixed.
date may be fixed, my lord.
Request to relist the matter.
24th.
4th of it.
But interim order may be extended in 12 point.
Modern operation extended till the next day.
Serial 6 ಅಲ್ಲಿ list 2 ನಲ್ಲಿ.
Huh?
List 2 serial 6 objection ಹಾಕ್ಬೇಕು.
I'm appearing for the petitioners.
Huh.
My lords, it is a case where the deputy commissioner has passed an order without hearing me. He has already filed his objections.
Respondent first petition objection not at file. Objection ready ಇದೆ.
When do you want it?
My lords, there is an urgency in this matter because the parties involved in the litigation are creating third-party rights, my lords. Then it will increase to litigation, multiplicity of litigation. So a short date may be given, my lords.
In this case, I filed application for pleading, was defined as defined respond number 7, my lord. That application is considered, my lord.
Correct, he wants time, short date.
No, my lords, 24th, my lords, kindly.
28 ಯಾಕಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಸೈನ್ ಆಗಿ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
No, ಸೈನ್ ಹಾಕ್ಸಕ್ಕೆ ಎಷ್ಟೊತ್ತು ಸ್ವಾಮಿ? ಒಂದ್ 2 ದಿವಸ ಸಾಕು.
2 ನಿಮಿಷಕ್ಕೆ ಹಾಕಲ್ಲ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್.
2 ದಿವಸ.
26th.
My lords, there is already a stay operating. Till then, let there be a status quo, my lords. Stay is already operating in the matter. Let there be a status quo, my lords, because the impleading applicant might create third-party rights.
Right, that I have to hear, I can't pass like this. On the next date, we'll consider whatever interim orders there, I'll extend.
Please. On 26th preliminary hearing, my lords,
I'll
kindly.
extend it till the next date. Let us see. In the, now it's there in,
B group.
what is the point?
My lords, the point is the deputy commissioner has cancelled my conversion after the lapse of 20 years, my lords. That too
This is the
without hearing
matter-
me.
This is the matter in the orders list.
Please. I'm grateful, man.
Pleading is not yet completed.
Huh?
Pleading is not yet completed. That's all.
Deputy commissioner objections ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಹಾಕಿ ನೋಡೋಣ. Now the DC is the answering response.
Please.
They have filed. They have filed.
They are fine.
Lord, I prefer.
What is this premium FAR scheme? Has it come into force?
It is coming to
Notified.
force.
And notified.
The procedure,
It is coming to force, my lordship. They have to make separate application for that, my lordship. In the writ petition, they have not mentioned anything about premium FAR. As far as the notices which are challenged is confirmation provisional order. For that, there is an alternative remedy of appeal. They can approach Chief Commissioner BB, whatever the contention they are raising here, that notice is not served or served to some person. They can
not filed appeal, is it?
No, my
appeal
lord.
is not filed. They
My
can
lord,
file an
my
appeal.
contention is, my lord, Annexure G is the notice, my lord, 5/3/2025, which I have produced original.
No, sir,
Except this, nothing was served upon me, my lord.
Then we'll give them protection for some time. Let him go and file an appeal.
Yes.
Meanwhile, whatever he wants to do on that unauthorized, let him do.
Premium FAR, if they want, they have to apply to the town planning department. my lordship. If it can, because in that you have to see the road width also. So if it's more than 12.
Road
meters,
width is,
criteria is there.
according to my clients, my lord, road width is more than 40 feet. Premium FAR will apply in this case.
Let
The
them make
previous round, in the another case, it was not applicable. This case, it is applicable, my lord. I can apply.
But it should be so costly that it must be
Yeah,
more.
But it is equivalent to the land value, my lord.
Is
Premium
equivalent.
FAR is equivalent to land value, actually.
And for some percentage, they have to obtain some TDR also and FAR also. Some combination is there. That is my instruction.
Let them do whatever.
For that, they have to make separate application.
Let them do whatever they want. I'll send it back. I'll give you protection till they consider the interim relief,
Yes,
provided you were to file the appeal within 10 days.
yes, much.
Ashte
Why we came here, my lord, why we came here? Because, my lord, there is no provision for him to condone the delay in filing the appeal before the chief commissioner. That was never served upon me. If the commissioner, my lord, therefore I am before this honorable court.
the petitioners. Have called in question the validity of the order passed under 248(3) of the BBMP Act 2020 at Annexure H1. Full stop. It is the case of the petitioners that they did not have notice of the said order.
Yes. We came to know only on 5/3/2025 when the Annexure G was served upon us.
And where
Annexure G, page 82, my lord.
and came to know about the order only when the order at Annexure G came to be served. Came to be served, which notice which order was an order for demolition under section 356.
Yes, my lord.
It is a notice that as against the order under 248(3), a substantive right of appeal under
253.
253 lies to the Chief Commissioner. Accordingly, it would be appropriate, considering the consequences flowing from the order under 248(3) and 356, to relegate the petitioner to avail of the substantive remedy. Next. Accordingly, the petition is disposed of. Petitioner is at liberty to file appeal in terms of section 253. And if the appeal is filed within 10 days from date of receipt of certified copy of the order, the Chief Commissioner to take note of the same without raising any objection on ground of limitation. There would be an interim order of stay of the 248(3) and 356 order till the appellate authority considers application for stay in the appeal which the petitioner undertakes to file. Needless to state that the benefit would, as granted above, would inure to the petitioner only if appeal is filed within 10 days as stipulated above. Pawan Kumar accepts notice for the respondent.
May I seek the operative portion, my lord, because they may come tomorrow. If my learned friend informs operative portion are kotra, I'll be able to convince.
You have been staying happily there for many years, isn't it?
Yes, my lord, but for past 2 days, they are, let my learned friend, at least he communicates.
Yes,
I will.
yes.
Bye.
No? Continue.
Still has to be paid. Appearing for petitions.
She has the statistics.
My lord, we are withholding 2 lakhs. As per your directions, we are collecting the partial refund that they are paying now. In respect of the government category students, they are only paying 60,000 as of now. And in respect of the private category students, they are paying to each petitioner 2,06,000. From all the petitioners, they are withholding 2 lakhs. So 2 lakhs is still in balance from each petitioner. So far, they are paid for 50.
Now, on what ground they are withholding that amount?
They have no grounds, my lord. They're legally liable to pay, but they're not paying.
My lords, as of my instructions, sir, we are paying almost 70 to 80 students. We are already paid, my lords.
Just. Yeah.
My lords, my instructions, sir, we are already paid, my lords. If any, so let them give details of the particular.
Now you file a memo of calculation.
Yes.
How much they are required to pay,
Yes, ma'am.
how much they have paid, how much
It's already there.
page, filed on which day?
Dated, my lord, as a memo of
Filed
calculation.
on which day?
On 29/5 of 2024, my lord.
29?
5/2020.
29/1/25.
29/5.
My lord.
5.
2024, my lord.
Just give your office copy.
Ma'am.
ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ, ನಿಮ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ. No, you file your memo saying how much they have paid.
Okay.
This is your entitlement you have written. So out of this, you file a separate memo.
Yes, ma'am.
What is your entitlement on what date, how much they have paid, and what is remaining. Then we'll ask them to respond.
Yes, please. Yes, please.
Learned counsel for the petitioner to file a memo, listing the entitlement of the petitioner, amount of refund and outstanding, if any, within a week's time.
Yes.
Advance copy to be served on the other side.
Yes.
Relist the matter week after next date.
Yes.
You serve it to them immediately.
Yes.
Grateful.
This could. I appear for petition. But the petitioners and respondent number 3 and 4 are brothers, blood. The contesting respondents, blood, respondent number 3 and 4 are served, but placed unrepresented, blood. But the petitioner, what is challenge, blood, the incorporating of names of blood, the respondent number 3 and 4 along with the petitioners is blood by the panchayat is under challenge, blood. Not as per annexure A, blood, unregistered panchayat palu parikatva, blood, the property, family properties are divided. Blood, the property, blood, the Khane Shumari number 15/12, blood, fall into the share of not the petitioners and as well as some portion in respect of respondent number 3 and 4 jointly. Blood, subsequently, blood, the Khata was entered in all the 4 persons' names, blood, as per annexure B. But subsequently, blood, in the year 1999, blood, the respondent number 3 and 4.
No, it was entered in which year? Jointly.
On 25/3/1999, blood.
25/3.
1999. Then, blood, the Khata against all them, blood, the 4 persons' name has been entered. Blood, on 12/7/1999. The respondent number 3 and 4 relinquishment their share, blood, in favor of the petitioner's brothers.
In favor of the petitioner
Petitioners.
by a registered instrument.
No, not unregistered deed. That is not, these 2 documents are part of not the panchayat records which I have produced. That is not in dispute, blood. Subsequently, blood, until 2022, since from 1990 to 2022, the Khata was standing in my favor.
Now,
I was
after-
paying a taxes,
After relinquishment, it was changed in the
change in favor of the petitioners.
petitioner.
In division.
Annexure
Annexures, blood, D.
D.
Yes, blood. Sorry, C1, C1, C series, blood.
Yes.
C1 to C.
Yes.
But subsequently, Lord, from 1999 to 2022, it was there in my name. I was paying a taxes. Lord, 2018, my father passes away, Lord. It's petitioner father and respondent's father. Lord, there is some, Lord, not a cordial relation between, Lord, the petitioner and respondents. Lord, in the year 2022, 9/11/2022, after 23 years, my brothers gives a representation to the panchayat without referring to them, Lord, annexure C. They give a representation, Lord, at your Lordship will get it, Lord, page number. Annexure F, Lord,
Page.
page 52. Typed copy I produced at page number 53. Soraba Taluku, Lordship got it, Lord. Soraba Taluku, Belavani Gram Panchayati, Kumshi Grama Vilasavada, YS Murugendraya, Basurajaya, Manavi, Namma Khate, Tapi Hoda Vishaya, Melkanda Panchayati Kadigi, ಈ ಹಿಂದೆ ಕುಂಶಿ ಗ್ರಾಮ ನಮ್ಮ ಹೆಸರಿಗೆ ಖಾನೆ ಶುಮಾರಿ 12ರಲ್ಲಿ ನಮ್ಮ ಖಾತೆ ಇದ್ದು ಅದು ನಮ್ಮ ಗಮನಕ್ಕೆ ಬರದೆ 12 ಖಾತೆಯನ್ನು ಹೆಸರನ್ನು ತಪ್ಪಿದೆ ಬಗ್ಗೆ ನಿಮ್ಮ ಗಮನಕ್ಕೆ ನಮ್ಮ ಹೆಸರುಗಳನ್ನು ಸೇರಿಸಬೇಕೆಂದು ತಮ್ಮ ಕೇಳಬಹುದು.
Yes.
But this representation is given. But the panchayat, not without notice to me, after lapse of 23 years, based on this representation, but incorporated the respondent number 3 and 4 names, but in a khata.
This was without notice.
Without notice to me.
And they don't refer that, my lord, the annexure C is an concocted, it is a part of the panchayat record, my lord. Lordship will kindly see, my lord, annexure C. It's a part of panchayat record. Annexure A also part of panchayat record. My brothers don't refer to these documents. Instead, they say that, my lord, kai tappininda bittogide nam hesaru haki anta. And the panchayat don't make me, my lord, issue a notice. And without giving an opportunity, without hearing, my lord, changes the khata.
Yes.
That is now, my lord, under challenge.
No, but then, didn't you challenge it in appeal?
No, I have not filed an appeal because, my lord, it is without application, my lord, without notice to me, my lord, in violation of principle of natural justice.
Yes, what do you say?
Prayer is against the resolution, yes, why? Against the resolution of the Gram Panchayat, yes, why?
Resolution?
Prayer may like kind of look into.
No, so what is your stand now?
Yes.
He says
No,
he has, he
against
says
this-
he has not been heard.
Earlier, it was in the name of all the 4 persons.
Correct.
Without notice to them, they are deleted. His name is included. That is also without notice. That is why they say in the representation. ನಮ್ಮ ಗಮನಕ್ಕೆ ಬಾರದೆ ನಾವು ಮಾಡಿದ್ವಿ.
Correct. From 99 to 20.
ಹೌದು ಅವ್ರ ಗಮನಕ್ಕೆ ಬಾರದೆ ಇವ್ರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ನಂತರ ವಿದೌಟ್ ನೋಟಿಸ್ ಈಗ ಅವ್ರು ಅದು ವಿದೌಟ್ ನೋಟಿಸ್ ಇದು ವಿದೌಟ್ ನೋಟಿಸ್.
So let them hear it.
ಎಸ್ ಮಾಡಿ
Send it
ಇದು ಈ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾವುದು ಅನೆಕ್ಷರ್ this representation annexure F, it may be considered after hearing all the parties.
Annexure
F. ಮೊದಲು ಕೂಡ ಇವರ ಹೆಸರು ಸೇರಿಸು ಕೂಡ ಅವರ ಗಮನಕ್ಕೆ ಬಾರದೆ ಮಾಡಿದ್ದು ವಿದೌಟ್ ನೋಟಿಸ್. ಮೊದಲು 4 ಜನರ ಹೆಸರಲ್ಲಿ ಇತ್ತು, ಅವರ ಗಮನಕ್ಕೆ ಬಾರದೆ ಇವ್ರು ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರ ಗಮನಕ್ಕೆ ಬರಲಿಲ್ಲ.
So let annexure F be heard with notice to all.
ಹೌದು ಮಾಡ್ಬೋದು, ಹಾಗೆ ಮಾಡ್ಬೋದು.
But your lordship may say, my lord, the panchayat must take to consideration annexure A and C, my lord.
No, that they will, whatever it is, you place before them.
No, it is
they cannot go
already
into
a
the-
part of record of a panchayat, my lord.
That you place before them. Why should we say anything?
No, it
All
is a
that-
part of record of panchayat, my lord.
Correct. So you,
Then again, my lord, if they, my lord, ignoring that, my lord, they pay some, my lord, pass cyclostal orders.
all
unregistered document. ಅವ್ರು ಇಲ್ಲ ಹೌದು
Maybe you can dispute it if it is.
Now
unregistered.
the Khata in the joint names.
Yes,
is that
all the persons.
Is that annexure?
Earlier to
Annexure,
earlier
Lord, B,
Annexure,
B,
page,
annexure C, my lord. C is a letter, annexure C, one page number 33, my lord.
serial number,
Lord, page number 27, my lord. Page number 27. Khata was, my lord, in favor of all the
Page-
4 persons.
serial number
Serial number 15, my lord, the second,
15.
1-5.
So Murigendrappa,
This is, my lord, based on annexure A partition deed, my lord.
so 3 names are there.
4 names, my lord.
Murigendrappa,
Murugendraya, then Basurajaya, Janti, YC Halaswami,
no, Murigendraya, son of Basurajaya.
Janti, YC Halaswami,
Mallikarjun.
YC Mallikarjun.
So
That is
this,
earlier to 99.
this joint was made in which year?
Earlier to 99.
Not
Because
this-
there in
this-
that
this
date
is
is
19
not coming.
1999,
Earlier to 99. It was
99, 2000.
2000.
earlier to that.
Then when was it made in your name?
Lord, kindly come to Lord annex. Annexure C1,
Page,
page 33. 2002, 2003, Lord. YC Halaswami. The second one,
Halaswami and Mallikarjun.
Mallikarjun.
So this is in which year?
This is in the year 2002, 2003,
So from then till
2022
it continued.
continued.
The petitioner has called in question the correctness of the resolution passed by the second respondent, Gram Panchayat at annexure H, and the mutation entry number 57 of 2324, whereby names of the petitioners were deleted.
No, third and fourth respondents' names are incorporated along with.
Wherein the names of names of respondent,
names were there.
names of respondent
No,
three and-
it is restored to the old.
understood. The names of respondent 3 and 4 came to be included.
Included.
Full stop. It is the case of the petitioner that initially the names were jointly in the name of all brothers, and subsequently, in light of the relinquishment stated to have been made by the petitioner's brothers, names in the mutation came to be recorded and continued only in the names of the petitioners in terms of the entry at annexure
C1.
C1 in the year 2002-2003. It submitted that the said entry has continued for about 10 years
23 years, bro. 2002
till
2023.
Till 2023, when the petitioners till 2023, full stop. It is submitted that the entry in the name of the petitioners exclusively came to be altered by order dated 11/12/2023. The said alteration, it is submitted, is pursuant to representation of respondent 3 and 4 on 9/11/22. Next is the case of the petitioner that he was not heard when such order was passed pursuant to resolution of the Gram Panchayat. Next, respondent number 3 and 4, those served have remained absent. The assertion of the petitioner that mutation standing in the name of the petitioners since 2002 till 19/11/23 came to be altered, including the name of respondent 3 and 4 by order dated 11/12/2023 without notice to the petitioner is not controverted by the authority. Next. Taking note that the civil rights of the petitioner have been effected without notice to them insofar as the exclusive name of the petitioners in the mutation came to be altered with inclusion of the name of respondent 3 and 4, would be appropriate to set aside the order at annexure annexure H1.
HHN.
Resolution, we can only set aside H1 entry,
H and H1.
H resolution, decision.
H and H1, and remit the matter back for consideration of the representation of at annexure F with the notice to all. Notice to all.
You can say, my lord, at least to consider the case of the petition, lord, as per the Panchayat records. As per Panchayat records,
Notice
whether it is registered, unregistered, let them agitate, my lord.
It is the case of the petitioner that all records are already with the
Petition.
Panchayat, which may be taken note of. Full stop. Petitioners at liberty.
If they want to file an objection or material.
Petitioners at liberty to produce other documents and pleadings as may be necessary, and the respondent 3 and 4 may also be issued notice and provided an opportunity to put forth their case. All
Right.
contentions are kept to.
appear for the second respondent.
Yes.
My lord, there is an interim order in favor of the petitioner, my lord. Unless, my lord, a plan is sanctioned or a building license is issued, there was a restraint order, my lord, from against me, my constructing it. My lord, what had happened was that, my lord, I made an application for a building license and a sanction of plan. My lord, I made on 3 occasions. Every time, my lord, the petitioner used to object it for the municipality. My lord, previously, my lord, now the plan has been sanctioned and building license also has been issued. My lord, your lordship may kindly see, my lord, my statement of objections.
No, now who appears for the
I represent petitioner.
authority?
And I appear for the municipality.
Yes. Yes. Yes, must. Yes, Narayan.
My lord, your lordship may kindly turn to page 73 of my objections, my lord.
No, on what ground they have been rejecting your plan?
My plan now has been sanctioned, my lord.
Ah.
He was objecting it, 2 applications, my lord, because of his objections. There is a civil suit pending, my lord, against me, between me and him. My lord, your lordship may kindly see the plan, not the local sketch, my lord, of the site, page 73, my lord.
Yes.
My lord, first is M.B. Chinnappa. Second is T.N. Anand, my lord, the petitioner. My lord, third is, my lord, G.V. Rupa is myself. On the other side, my lord, is my vendor. My lord, I purchased half site of that. My lord, on the eastern side, my lord, there is a passage. There is an injunction, my lord, operating against the petitioner in the earlier suit between my vendor's vendor. Despite that, my lord, immediately after purchase, I had to initiate a litigation against my learned friend's client, since he was objecting my entry through that passage.
Where is the passage?
Passage is, my lord, East Road, your lordship sees that. That is the passage. That is the only access, my lord, to me to access to the road.
Now they claim it's the property belonging to them.
Client,
No,
correct.
the passage belongs to him is his contention. My lord, there is an injunction operating against him, my lord, which I have produced. Your lordship may kindly see, my lord.
No, correct.
Get,
The suit for declaration.
suit for injunction, my lord, because already he has suffered a permanent injunction, my lord, in a proceedings initiated by my vendor's vendor.
No, correct, but suppose you were to lose the suit.
My lord, I cannot, because already, my lord, he has suffered an order against the very same passage. There are several plaintiffs that, my lord, I have produced. Your lordship may kindly see, my lord, page 58. My lord, is the operative portion. The order starts, my lord, from page 42.
What is the width of the passage?
My lord, it is about 20 feet or so, my lord.
8 by 50 feet.
8 by
50 feet. It is exclusively belongs to the petitioner.
My lord, that is a factually incorrect statement. Your lordship may kindly turn to page 58. My lord, I am only reading, my lord, the injunction part. A spot inspection was made only to ascertain whether the commissioner has recorded the facts. Your lordship got it, my lord. Page 58 nalli somewhere, my lord, issue number 5 ಗಿಂತಲೂ ಒಂದು 4 line ಮೇಲ್ಗಡೆ.
No, what is the stage of the proceedings?
That is an independent new suit, my lord. Earlier suit is decreed. RSA filed my learned friend has been dismissed. That judgment, my lord, I have produced. It is at page 60 with respect to the very same passage. 60, my lord.
Same parties.
Same, my vendor's vendor, my lord. Property is the same.
Now the present suit is filed by?
By me, my lord. After I purchased, my lord, though he has suffered an injunction, he started objecting my movement. Then, my lord, I had to approach the civil court and I obtained an injunction. It is at page 82, my lord.
No, now on what pretext are they denying you permission now?
My lord, they have granted.
Then
Municipality has granted now.
Ah.
My lord, my learned friend's client was objecting a grant of license to me.
They have challenged that.
But they did not challenge. Now it is granted. I have produced that building license, my lord, at page 90.
Then what is the present petition filed?
My lord, it was filed earlier to issue of this, my lord. What had happened was I applied for a building license and sanction of plan. My lord, my learned friend's client objected. Once again, I made an application that also was objected. finally, my lord, now it is granted.
No, then now what we can do, it's already
My
granted.
submission, as on the date of the filing of the petition, whether he has obtained a plan and license for putting up a construction. He has obtained a plan and license after filing of the writ petition, after completion of the construction.
Not, it is not completed.
Yes, it is complete, my lord, kindly see. Now, in the earlier, the advocate who represented on 31/8/24, he admitted that his client has not obtained plan or
That is
license.
true, my
That's
lord,
why
I
this
found that.
honorable court was pleased to grant interim order of stay not to put up further construction. He has obtained, lordship kindly see the annexer, now my learned friend produced.
No, now, correct, now in the suit, he says you have suffered an order of.
Lordship, I'm not above regarding the suit or something. Whether he has obtained a plan and license for putting up a construction. Your lordship kindly see the annexer R2, page number 90.
My lord, that is not in dispute. I don't dispute it. I
Whether
had
it-
applied, they did not sanction. I constructed. There was no sanction plan.
Yes. if there was
Subsequently, I have obtained.
There was no sanction plan for putting up a construction. He has put up construction. When I have objected, I filed a writ petition after interim grant of interim order on 31/8. He applied for license on 14/12. Your lordship kindly see.
Yes, VK, but
Yes,
Batre ಹೇಳ್ಬೇಕು ಈಗ.
what is your stand?
Lord, page 87, my lord, of the statement of objections. But initial application was made on 36/2023. Application for building permit.
Yes,
It was much earlier. And the applications were pending consideration. And there were some objections by the petitioner. Lord, we considered for the applications and the objections. And now we have granted the license. In the meanwhile, it appears that the respondent has commenced construction, but for which there was an interim order of stay. So application was earlier, and kindly see the prayer in the writ petition, my lord.
now what is the stage of construction now?
My lord, it is not complete. My lord, the structure is put up. My lord, after the interim order, my lord, I did not proceed.
Now what is to be done?
Now, only thing, according to my lord, we have to ensure that the construction is as per the plan. Not any private dispute of any lane or passage. It's purely, my lord, has to be resolved in the civil court. Yes.
So, yes, what do we say?
My humble submission is that as on the date of the particular construction, either he has obtained a plan and license. That's my ambition. He obtained a plan and license after putting up a construction. That too after interim order granted with this court.
No, now we can ask them to inspect and see if what has been done is in accordance with the plan and get an undertaking that whatever he does will be strictly in terms of the plan and subject to the outcome of the civil suit.
That's correct, but as on the date of the filing of the writ petition, whether he has obtained a plan and license. Admittedly, as per the annexer R2, he has not obtained plan. He applied for plan on.
Now, how much construction you put up?
My lord,
Almost
this
ಎಲ್ಲ
structure
ಮುಗ್ದೋಗಿದೆ.
is put, my lord. Finishing is not done.
Finishing ಅಷ್ಟೇ. 14,
The first floor, my lord, I understand it has been stopped. First floor has been put. Sanction, my lord, is for the ground floor and the first floor.
Let them inspect and see. No doubt that there is a lapse on their
Yes, there is a lapse on the part of the second respondent, including the first respondent.
My lord, my learned friend's case is, my lord, his representations are required to be considered. Let them consider and pass appropriate orders.
But we have put up construction already without plan.
So what is the penalty we can impose?
ಈಗ ಎಲ್ಲರೂ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಪ್ಲಾನ್ ತಗೊಂಡ್ರೆ ಏನು? ವಾಟ್ ಇಸ್ ದಿ ಫೇಟ್? ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ಮೇಲೆ ಪ್ಲಾನ್ ತಗೊಂಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ
Your lordship may kindly see, my lord, we borrow money.
No,
My
no,
lord.
that's it. Now, Mr. Bhatt, what is the There admittedly, there's a lapse on your part. You should have verified.
But the application was during June 2023, madam.
But you should not have allowed him to put up any construction without till sanction was.
It was brought to our notice, and not we started inquiry. In the meanwhile, it appears he has raised some structures.
Now you must pay some cost.
Lords, I leave it to your lords, my lord. She is a lower middle class employee, my lord. She borrowed money from the bank and my lord put up. Because of all these litigations, my lord, the moment I purchased, my learned friend's client started litigation. I had to approach the civil court.
The petitioner has sought for an order to direct the first respondent to initiate action against the second respondent in pursuance of the complaints at annexure E and F. In terms of the said representations at annexure E and F, the petitioner has represented to the municipal authority that the respondent has been putting up construction without any license. It appears that this court had passed an interim order on 31/8/24 restraining second respondent from proceeding with further construction. Such order, by virtue of such order, it is submitted that the second respondent was restrained and did not put up any further construction. Statement of objections have been filed by respondent number 2, who has produced along with the statement of objections the sanction of the building license issued on 30th December 2024. It is the case of learned counsel appearing for the second respondent. It is a case of counsel appearing on behalf of the first respondent that application for building license was filed on 30th June 2023. Earlier to filing of the present writ petition on 3rd July 24, and same had been granted by the first respondent 30th December 24. Next. Undisputedly, the second respondent had put up partial construction even prior to obtaining of the building license. Next. The first respondent, before issuing building license, ought to have ascertained construction, if any, put up by the second respondent even before obtaining the building license. Next. Admittedly, there is a lapse in so far as the first respondent has not verified construction partially put up even prior to obtaining of the building license, and had not taken any steps to restrain the second respondent to put up construction without building license until this court, by order dated 31/8/2024, had passed an order of restraint. To such extent, the first respondent committed lapse. And the second respondent has also put up construction, though partial, in violation of the requirement of putting up construction only with building license. Next. In light of the above, the taking note of the peculiar facts of the case, it would be appropriate to put the respondent number 2 on terms. The respondent number 2 is to pay costs of 25,000 to the petitioner. It's made clear that the officials of the first respondent are to be warned suitably to ensure that such lapses do not occur. Accordingly, petition is disposed of.
I'll pay it through the demand draft, my lord, your lordship may observe, because we are not in talking terms. My lord, I'll pay through the demand draft. I'll, my lord, hand it over to my learned friend.
Learned counsel for the respondent number 2 submits that the costs would be paid within a period of 10 days, 2 weeks.
1 month release one.
1 month by way of a demand draft.
Demand draft. I'll hand it over to my learned friend, my lord.
By remitting the same to the counsel for the other side.
Please,
Petition. Yes.
50.
much obliged.
Mahesh Chandra BN. Mahesh Chandra BN.
Not subject to appear for respondent BBMP, my lords.
Yes.
Petition seeking quashing of the trade license issued by the BBMP my lords. For the reason, the license issued to open a liquor shop is in a residential area. Lord sir, filed an IA.
Pleadings are complete.
Well, we're filing an application seeking vacation of the interim order and
Copy has not been served.
Survey copy, pleadings are complete.
I'll have to file the objections, my lords. But if my lordships were pleased, I'm ready to argue, my lords.
No, you put it in writing, whatever you want to put it in writing there.
Please.
The respondent 1 to 3 to file the statement of objections by the next date. Relist the matter, date good. 3rd of April. We'll take
Great.
it up.
the lordship could have it at an earlier occasion, my lord. I have secured a CL7 license where I've invested heavily. And because of the trade license being stayed, I am unable, I have put up interior.
So we'll hear.
If
On
your lordship could have it on Monday next week, my lord, kindly.
On third, we'll take it up. Let the BBMP put it in writing, we'll take it up.
Please.
3rd of April.
Obliged.
Passover matters, serial number 7. Shashi Kumar.
For the petitioner, this is a status matter, my lord. The no confidence motion issued against the Adhyaksha, my lord. My lord,
Did you examine the legal position?
yes, my lord. One more ground is there, my lord.
Huh?
One more ground, my lord. Rule 3, sub-rule 3 says, my lord, the notice shall be given clear 15 days earlier to the issuance of meeting conveyed by the petitioner, my lord, second respondent, my lord. The notice dated 6/3/2025. Served on the petitioner, my lord, on 11/3/2025, my lord. The meeting was held to be on 24th, my lord. There is no 15 days, clear 15 days in between the notice and the meeting, my lord.
No, my lord. Even he has not, notice will be sent on the same day, my lord. That is not the.
The notice is sent
He has
through the
not made
registered
the-
post, my lord. It
It is
reaches
not-
only after
lord.
5 days, my lord.
It is not the ground before this honorable court. He has stated that as per section 49B, that B is no more, no, my lord. That has been excluded. And regarding notice it is in order, and even 49B does not survive, my lord. Then the petition has to be dismissed.
My lord, the notice issued in contravention to the rule 3, sub-rule 2, my lord. May I read, my lord?
No, that will, now you just verify, you ask the assistant commissioner the records, when they have served notice, I'll have it tomorrow.
Yes.
You just find out when
One
they've
more,
dispatched.
ground, my lord, the signatures of the applicants before the assistant commissioner is not verified by.
Those
Nobody
are-
is verified the signatures, my lord. Even, my lord, there is no endorsement on the said application, my lord, when the application was received, my lord. Who has received that application? There is no endorsement on the said notification, my lord. Even, my lord, in the said representation, my lord, some of the signatures of the members were obtained by misrepresentation, my lord. That effect I can keep the present some of the petitioners, my lord.
No. The signatures of whom? Signatures
Of the applicant petitioners, sorry, my lord, respondents, my lord. Some of the respondents claims that they have not the signatures obtained by misrepresentation, my lord.
that has to be verified.
Even they are not before this honorable court.
Nobody has come before this court. We'll issue notice and make it subject to the outcome. Meanwhile, you get your records. The AG accepts notice for the respond 1 and 2, emergent notice to respondents 3 to 16. The proceedings, if any, pursuant to Annexure A would be subject to outcome of the petition. The state to produce necessary records relating to dispatch of notice, etc., and dispatch of notice.
The service of notice, my lord,
Let
when
us
it was
see.
served.
Let us see, that we'll see. Relist the matter.
My lord, the 22nd.
22nd. Relist the matter. 22nd.
Serial number 13, Tharayappa.
You produce, get the entirety of the records.
Yes.
And go through the records and you make submission.
Morning, I was pointing out that the BBMP and BDA had jointly inspected the property and they only came to the conclusion that there is no road. That can be seen at page number 27 minutes. This honorable court in a PIL had ordered them to inspect the property and give the report. If my lords comes to page number 27, there is an order sheet attached to this.
No, that I've seen.
In that, it is already recorded that it's a property belonging to the HMT. There is no encroachment or there is no road in the property. BBMP sitting in their office, now they are issuing a notice saying that we have constructed in the, on the road. In fact, I have not even constructed anything in the property. It's a vacant site. My only contention is this, my lords. Let them allow us to construct because I am not constructing a building. I'm only putting up the canopy. Subject to the outcome of the writ petition, if suppose they come up tomorrow saying that, okay, you have constructed on the road, I'll take down the building, I'll take down the canopy. Until then, let me do the business. It's for the public benefit.
in fact, my lord,
private.
No, just one, Pawan Kumar.
in fact, my lord, the petitioner company is a Sikh company, my lord.
No, just 1 minute. Let Pawan Kumar
I'll call him.
pass over. Let him come.
Please, I'll call him.
Yeah.
23. Sarvana is for the petition.
So Annexure G, page 51. This case also Pawan appears.
Pass over. Pass over.
It's my request for day after tomorrow, Lords. In the preliminary hearing, Lords.
Relist. Relist. Read.
21st.
It's in preliminary hearing or orders, Lords.
Same stage. Let's.
With orders ke bandito. Today it was listed in orders.
31. 31, Parmeshwara DC.
Appear for petition.
Pradeep.
Even I also telephonically informed him, Lord, he's deliberately is not coming.
What's the thing about?
ನಾನು ಫೋನ್ ಮಾಡಿ ಇನ್ಫಾರ್ಮ್
ಫ್ರೆಂಡ್ ಎಲ್ಲಿ ಹೋದ್ ಸತಿನೂ ಬಂದಿರ್ಲಿಲ್ಲ.
ಹೌದು.
In his case only. ಆಮೇಲೆ ನೀವ್ ಕರ್ದ ಮೇಲೆ he came, isn't it? Last time.
ಎಸ್ ಎಸ್
Huh? ಅಲ್ಲ ಹೇಗಾಗುತ್ತೆ?
even I also called Lord.
ಹಾ.
But I take your lordship Lord for a moment. They have filed a false compliance report Lord. After the order passed by annexure K, where there is a specific direction to the Lord ADLR to conduct a survey and give a survey report to the
Okay,
panchayat.
so now what is left to be done according to you? What should be?
Lord, after this annexure K order, they did not comply it. I filed a contempt. Lord, in a contempt, the ADLR filed a Lord, the compliance affidavit stating that the survey has been done and contempt has been closed. May I read that Lord 11 portion? At page number 16, Lord.
Now, who is the PDO has to do it, is it?
PDO has to issue a e-Khata.
Now, he has to do the next action.
What the next action he has to do, he has issued an endorsement, Lord, instead of issuing e-Khata. That last annexure V, Lord. Annexure V.
Yes.
Lord, he says that ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಿಡಿ ಹೊಸಕೋಟೆ ಗ್ರಾಮದ ಸೊತ್ತಿನ ಸಂಖ್ಯೆ 58 ಮತ್ತು 59 ಈ ಸೊತ್ತು ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋ ಅಳತೆಗಳ ಸಂಬಂಧಪಟ್ಟಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಸ್ಕೆಚ್ ಸಂಖ್ಯೆ ಸೋ ಅನ್ನು ನೀಡಿರುವುದು ಸರಿಯಷ್ಟೇ. ಮುಂದುವರೆದು ವಿಸ್ತೀರ್ಣವನ್ನು ಸ್ಕೆಚ್ ನಲ್ಲಿ ದಾಖಲೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಚೆಕ್ಕುಬಂದಿ ಕಾಲಂನಲ್ಲಿ ಕೂಡ ವಿವರನ್ನು ದಾಖಲಿಸಿರುವುದಿಲ್ಲ. ಉಲ್ಲೇಖ 1 ಪತ್ರದಲ್ಲಿ ವಿವಾದಿತ ಸೊತ್ತಿನ ನಕ್ಷೆ ಮತ್ತು ವರದಿಯನ್ನು ಮೋಜಣಿ ತಂತ್ರಾಂಶದಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿರುವುದಿಲ್ಲ ಈ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ವಿವಾದಿತ ಮತ್ತು ವಿಸ್ತೀರ್ಣ ಹಾಗೂ ಚೆಕ್ಕುಬಂದಿ ಇರದಿರುವ ಸೊತ್ತನ್ನು ಈ ಖಾತಾ ಕೊಡಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ.
So this has to be done by the ADLR.
ADLR given a report and filed a compliance report without doing this exercise. So therefore the contempt is being dropped. Now PDO says that when the survey has been done, the PDO was present. In his presence, the survey is conducted.
So now what do you say regarding this?
Yes, my lord. The survey manager is present here. What he is saying that at the time of uploading the application itself, boundaries should be mentioned, my lord.
No. How did you give an undertaking in the contempt?
Contempt we have done for the entire.
But no, boundary is not there.
Yes, my lord, whatever the given
No, it's a.
available materials on the available.
No, why did you give that? You shouldn't have given that.
PDO has failed to furnish all the necessary documents, my lord, in spite of repeated requests.
That is between you and the.
PDO has failed to give the
No,
necessary
that's
information.
between you and him. Why are you now harassing this fellow? How many times? 5 times he has come up and down.
That's why I made in the morning itself made submission. Even now, if he files fresh application along with
He
the
has filed that.
necessary.
No,
No.
no.
After this, he has not filed. Even now, if he makes an application with all the necessary particulars, we will do within 1 month, my lord. Because of flagging of particulars, we are unable to conduct the survey, my lord.
No, correct.
PDO is also failed to
No,
furnish all the details.
You should
Even
have
the
solved.
parties also not given the
You should have
details.
solved it in the contempt state. You shouldn't have filed an undertaking in the contempt saying we have complied and we have given the sketch.
We have complied as per the available materials.
That is wrong. You should not
Because
have. You should have
without
told.
they paying any material particulars, we are unable to do the survey, my lord. It is the duty of the PDO to furnish all the necessary required, either PDO or the parties. Without there being any necessary information.
No, so I'm saying 5 writ petitions he has filed. How many more writ petitions you have to file?
Yes, this is
It
the
won't
license on
happen.
the part of the PDO, my lord.
That I don't know. That's between you and.
Even today, that's why my initially itself, I have made submission saying that even today, if he makes an application through online, furnishing all the details.
You have
required
filed,
documents.
Since from 2013, one after another
13 ಅಲ್ಲ,
applications
ಈಗ
we have made.
ಆದ್ಮೇಲೆ
Not this
CCC ಆದ್ಮೇಲೆ.
compliance,
Can do whatever you want.
compliance affidavit filed by the ADLR before Lord in a contempt court. Lord, without respect to them, Lord, even.
Even contempt ಕೊಟ್ಟಲು ನಾವು ಅದನ್ನ
Show the undertaking before the contempt.
Yes, Lord.
I'll refer it.
Page number 16.
Let it be sorted out there.
Page number 60.
60.
Yes, Lord. In response to the notice issued by this court, respondent number 1, though additional government advocate, so compliance affidavit dated 3/8/2024. Copy of the affidavit is served on the council. It is stated that compliance affidavit referring from paragraph 3 thereof, e-Khata applications were received from the office of the Assistant Director of Land Records, Anekal Taluk, Bangalore Urban District from Surajkanahalli Gram Panchayat by way of online application, 2 dated. Thereafter, the file was
Para 4,
submitted to-
last line is a false statement.
Yes,
You read para 4.
the statement of affidavit shows that during the process of survey, the complainant himself was present and has signed the statement. The survey prepared by sketch and submitted to the office of the Panchayat Development Officer, and all the documents which are submitted have been uploaded online as per the requirement.
That is a false statement.
Yes. Now they are claiming not, have not
Now,
sufficiently.
the surveyor
submitted
has filed an affidavit, is it?
Yes.
You have a copy of it?
Home brother.
Let the surveyor and the PDO now be present.
Pardon.
What affidavit filed in the contempt, you place it on record.
Yes, it is for the PDO, my lord. Yes, please.
No, let the survey, I want to see the surveyor's affidavit because the,
Last occasion I have filed the memo, my lord.
let us have a look at the affidavit. Because the contempt court has recorded,
Filed the report on 16/12/2024.
the contempt court has recorded,
Yes, ma'am.
surveyor prepared the sketch and submitted to PDO,
Yes,
and
ma'am.
all documents which were submitted have been uploaded online as per the requirement.
Yes,
Now,
we have.
no, now the requirement is boundary is not there. That's what the PDO.
They have failed to furnish the boundaries.
That you shouldn't have said.
The
you should have
outlets
said-
which we have mentioned, my lord.
Let the surveyor and the PDO, I'll send them to the portal 1, let them go and sort it out.
No, this is the report I have furnished, my lord. Along with that report, I have
So-
furnished.
So
the
you
sketch.
sort it out with the PDO. Why you are harassing him? You sort it out with the PDO.
The ADLRS even today is ready to do his job, my lord,
Right.
provided they have to furnish all the materials.
You
without
exercise
being-
what, you exercise whatever power you have to issue notice to the.
We have issued notices to PDO, but he is unable to furnish, he has failed to produce any of the documents, my lord. That's why I request the court, let the petitioner may file an online application with
No,
all
I'm
the
not-
material.
With whatever
In
is,
time-bound manner,
no,
my lord,
whatever it is there, you have to do it. If you don't do it, I will refer it straight away to portal.
without generating the online application,
I-
now ADLR cannot do
Not
anything,
after
my
4-5 times. You can't get, from past 10 years, from 2013, he's been filing. You can do whatever you want. I don't know. It is noticed that the
My
endorsement.
request is this, my lord. Even today, even now, if he files an application,
I do
keeping
sort-
pending this
You
file,
sort it out with him. I am not going to pass any order.
they are also not giving the particulars, my lord.
On 30th of August 2024, there is an endorsement issued by the Gram Panchayat to the effect that the survey report of the ADLR does not have boundaries. Full stop. It is noticed that in contempt 6333 of 2023, while affidavit was filed by the accused, the contempt petition was disposed of in terms of the observation at para 4, which reads as follows. Next. It is to be seen that the petitioner has been seeking registration of Khata and has followed it up with several writ petitions in WP 20951 of 2012, comma 10832 of 2022, comma and followed it up with the CCC 633 of 2023. Full stop. Despite several rounds of litigation, the petitioner still is at the doorstep of the authorities with ADLR and the Gram Panchayat, assigning reasons and blaming each other. Full stop. It is clear that the Gram Panchayat has taken a stand that without boundaries in the survey report of the ADLR, no action can be taken. Full stop. The learned government advocate submits that the PDO has failed to furnish the boundaries, and accordingly, the report of the ADLR had been submitted without boundaries in the contempt proceedings. Full stop. Nevertheless, it is noticed that the contempt proceedings having been disposed of has recorded that the ADLR has submitted the survey report. It now comes out that admittedly the survey report is not complete insofar as boundaries are not given. Accordingly, the surveyor who has filed the affidavit in the contempt proceedings.
First respondent number 1, Lord, in ADLR, Assistant Director of Land Records.
Accordingly, the Assistant Director of Land Records and the PDO to show cause as to why court may not recommend for suo motu contempt proceedings on the ground of aggravated contempt. In light of contempt proceedings earlier having been dropped on the representation that the survey report was given as per requirement. While now it is noticed that survey report did not have boundaries. Full stop. Notice to be communicated to the erring officials. The details of the officials by name to be filed in the registry within 2 days. Relist the matter on date code next week.
My submissions may kindly be recorded, my lord. In the absence of PDO furnishing the boundaries,
I have recorded.
either by the parties or by the PDO,
I have recorded.
ADLR is unable to conduct the sketch, my lord.
Whatever you do,
My submission may kindly be recorded.
work must be done. If work is not done,
My lord, in the absence of particulars, ADLR
that is
cannot
sort
do,
of-
my lord.
correct. You have the power, isn't it? Now you call the
We
PDO.
have written n number of
Now
notices.
don't you have the power to summon the PDO?
Yes, we have
You ask
written,
your advocate general and get him there.
we have written n number of letters.
No,
to
you ask
someone.
your advocate general
My lord, my
through the
submissions may kindly
no,
be recorded.
urban development department, you have power, isn't it? You ask your urban development secretary to summon the PDO. Don't tell me government is
My lord,
helpless.
I'm not telling that. Let my
So you
request.
summon. Now let them,
I'll
let
do
them
the
show
job.
cause. Let them show cause. I will take a call. If I find your explanation sufficient, I
Yes.
will drop it.
But till such time, my submissions may kindly be recorded.
That
in
means
the order.
that you put it in writing.
No, my lord,
Third,
my submissions may.
AGA has taken the stand that the PDO has not uploaded the boundaries of the property, and accordingly, in the contempt proceedings, what was submitted before the court was a sketch without boundaries, and that only if boundaries are furnished by the PDO, the sketch could have contained the boundaries.
Yes.
However, these are aspects to be sorted out between both state authorities, that is, an official of the Gram Panchayat and an official of the government. The petitioner cannot be caught in the said crossfire.
Public.
However, it is, you sort it out.
Is it-
Call the,
I'll do
call the PDO
Yes,
to come and you sort it out. You ask
I'll do that.
ask the urban development secretary to summon it.
Yes.
Yearly filed an affidavit in a contempt that we have complied the order, survey has been done and it has been uploaded online in the Panchayat website. Now, Lord, after that, Lord, I made an application to issue a Khata accordingly. Then the Panchayat Development Officer issues an endorsement that the survey sketch doesn't contain anything.
Let us see.
13, Rayappa Y, Mohan Kumar.
One sentence. Varkulu. Despite matter having been passed over, counsel for the Gram Panchayat remains absent. You just tell Pradeep, I'm not, this is the second time and I normally don't, but I'm going to make written observation that he's not there. That's his headache, what arrangement he makes. Yes,
In the morning, they took a password that they will produce some documents.
yes.
I'm only making this submission, my lords. That road, what they are claiming, we leave that road part. The rest of the property, we will make we put up the canopy. If the BBMP later come to the conclusion that that is also on the road itself, that also we will take it off. Because this is a gale gas.
There are two parts. One, insofar as the road. Two, insofar as the plan, by the appropriate authority planning. Now, insofar as road, we'll ask him to be present. You demarcate the road, and then he will take a call, whether he leaves it out and then asks you to give plan for the remaining or not. One. Two, you inform him who is the authority who has to give after you demarcate the road. He will give it, and then we'll see what is to be done. We'll have it next week. I'll make such observation. We'll have it next week.
My lord, actually, there is no such road, my lord.
Let us see.
My lord,
No, we'll see.
Then
No,
let
now-
them come up with their
Our
report.
revised master plan also.
No, let them.
Lord.
No, now we can, let us see, we'll put a full stop to the dispute at the spot in the presence of the second respondent. Let them show if there's a road. Let that report be placed before the court next week. We'll see what is to be done.
In fact, my lord,
If he is also saying that in case there is a road, he will leave that portion and get a plan for the remaining. And that remaining portion will be decided at a later point of time.
Well, it's one submission, minutes. Already one survey was conducted by the BBMP and BDA. Let them also take it into consideration, because now I don't want them to give this one.
Where is
survey.
that report? Report is
That is filed
What is
in
filed in
the
the
PAL minutes.
contempt proceeding.
No.
in the
it's
PIL
PAL.
matter.
PI.
Petition.
I'll refer to that.
Please,
My lord, in fact, my lord, in the earlier orders passed under section 248, there is no whisper about the road, my lord. They only wanted the license is not obtained. There's no whisper about the road.
but
They know that there is no road.
second notice.
Now
say
they
that-
simply want to create some problem and say that there is a road. And only in the notice issued now, my lord, for demolition, there is no such structure also. Demolition, they are saying that we will demolish the structure and the cost will be recovered from HMT.
that
There
is
is an
no-
order passed against Gale. There is no such.
But what is their interest now?
My lord,
It's not their
there is some
Huh?
anti-elements. Public
The person who had filed the public interest litigation, it's his interest, because his land was acquired. So he fought with the government, he couldn't get the land. In fact, he filed the PIL, and the PIL has been dismissed only on one ground, that it's his land which was acquired by the KDP, then given to the HMT. So he has his personal interest, that's why the public interest litigation was dismissed. Once the dismissal is done, he goes to the BBMP and makes them to issue all kinds of notices. Let them come, inspect the property. By the next date of hearing, let them say that whether there is a road or
It is noticed that.
that will solve the problem.
It is noticed that two of the main objections on behalf of the BBMP is as regards purported road stated to have been encroached by the second respondent.
Please, Minister.
Full stop. The other objection is that the plan
That is not there in the.
has not been approved by,
Competent authority,
who is the competent authority?
town planning, assistant director of town.
By the assistant director of town
Town.
plan. Full stop. In order to ascertain the dispute regarding the road, the second respondent as well as representative of the petitioner to be present at the site on
Any date next week.
27th at 11:30. Full stop. The respondent BPMP to point out the purported road stated to have been encroached by the petitioner. While pointing out the said road, needless to state, reference requires to be made to the joint survey sketch.
Please, submitted in WP number 22633 of 2021. If my laws come to page number 27, order dated 6/4/2022 minutes. It is submitted by the learned counsel for the respond number 3 and 4, that the pursuant to the order dated 15/3/2022 passed by this court, respondent.
Just hold, ಏನ್ ಬರ್ತಿದೆ? ಅಲ್ಲ, to the inquiry stated to have been conducted by the BBMP and BDA as referred to in the order dated 6/4/2022 in WP 22633 of 2021. Full stop. The respondent BBMP also to intimate the competent authority to approve the plan as is stated by them before this court.
And in fact, my lord,
Relist the matter on 8th of April.
if there is a, in fact, a road, let them demarcate and give it to us. So then in the rest of the property, we will.
In the event that the
later.
BBMP necessarily has to demarcate the extent of the road running through the site as is covered before this court.
Seek for the
Date.
next day's date in the start.
Which day you want?
That's 4th,
7th ಗಿಂತ ಮುಂಚೆ ಕೊಡು ಅಷ್ಟೇ.
ಸ್ವಲ್ಪ ಯಾವತ್ತು?
3rd of April.
please.
Copy of the
GL
order.
has already invested 3 crores.
Let us see, let us see. Copy of the order to be furnished to the council for the BBM.
Interim order. Interim order maybe.
Interim order and operations extended till the
My lord. In fact, my lord, let it be in the second week of April, my lord.
ಅವ್ರಿಗೇನೋ urgent. Let us see.
Last week of this month, my lord.
No, he has some urgent. Let us see. Let us see. Even if you are not there, we'll see what happens and then we'll take.
My lords. My lord, serial number 31, my lords. Previous matter. Right, I was in CJ's court. What has happened is, my lord, one sub.
No, whatever it is, I've passed an order.
My lord, I request.
Your
my lordship-
absence, I'll remove. Adonda.
My lord, I request your lordship, my lord. My lord, FIR has been registered against the PDO. PDO was not functioning regular. Today, one PDO has assumed charge, my lord. I have informed them, my lord. Just now, I have received an intimation.
We'll see. I fixed a date. By then, whatever you do, you do.
My lord, I beg.
And,
My lord,
your
I-
absence, I've struck off.
My lord, I request my lordship. I'll comply with the order, my lord. Within 2 days, I'll make
Whatever it is, you finish it by the next day. Your absence, I've removed that observation.
I apologize for the inconvenience, my lord. I was held up in court on one, my lord.
That's okay. Yes. Okay. 10 ನಿಮಿಷ ತಗೊಳ್ಳೋಣ. ಹಾ.
Two, serial number 2, B promote.
Covered by judgment. Covered by judgment already regarding the.
Huh?
This is covered by judgment, my lord, the lordship.
Which order?
The writ petition number 4601 of 2020, where it was squashed regarding the levy of ground rent, other things were squashed.
ಪವನ್ ಕುಮಾರ್ ಇದ್ದಾರೆ, ಯಾರಿದ್ದಾರೆ?
Sanjeev. Real Sanjeev.
This is the first set of order.
First set of.
Ah.
Thereafter amendment. This is a no demand note prior to the amendment. my lord.
Prior.
The amendment.
Demand is at pay annexure.
And demand 46, page number 46. Forty-six is the demand,
This is dated 13 June 2019.
19. The act came into amendment because in 2029, subsequent
2000,
amendment came in 2020, subsequent to this demand.
by virtue of which they have the right to raise such
That
demand.
is also under challenge.
Now-
Again, it is posted for, reserved for judgment.
What is the observation in this at page?
The. But at
Bylaws
last, page
are-
number 47. And the
bylaws
bylaws
are-
under which the ground rent, license fees, building license fees, scrutiny deposit, all held ultra vires of the act and the resultantly rendered unenforceable.
These demands were raised by virtue of the bylaws,
Not by virtue of a circular.
circular. That 4/9/2015.
Hello?
Circular 4/9/2015.
Yes, madam. There are many circulars.
And those other one, 17. The petitioner has called in question the validity of the circular dated 4/9/2015 issued by third respondent, comma, government order dated 18/1/2007 and corrigendum order dated 28/2/2007 issued by respondent number 2 mandating collection of labor welfare cess, comma, issue of the validity of the demand notice dated 6/1/2020 issued by respondent number 4. Third counsel for the petitioner, the G.V. Sudhakar submits that the order of this court in WP 4601 of 2020 and connected matter has set aside the circulars on the basis of which the impugned demand notice has been raised. The operative portion in WP 4601 of 2020 reads as follows. Next, in light of the said submission, which is not controverted, petition is allowed. The demand notice at annexure D is set aside. Is set aside. That's all. Then what they have again issued now?
Yes, again issued, madam. Again, it is under challenge.
You just tell Sanjeev.
Yes.
That we have allowed it in terms of.
Serial number 4, Sudhakar Pai. Ravi Shankar Shastri.
Beg to appear for the petitioner, my lord. A direction is sought to the first respondent, my lord. To consider the representation and lawyer's notice, my lord, to take action against respondents 3 and 4 for their illegal construction, my lord, without license. My lord, survey number 61/2, my lord, is our Kumki land. My lord,
The respondent number,
3 and 4.
but they are not made parties, is it?
3 and 4 are parties. My learned friend is appearing. Respondent 1 is the PDO, my lord. Direction is sought to him.
But 3 and 4 is not shown in the cause list.
No,
I
but
have-
learned
I am
friend
appearing
appears.
for R3 and 4, my lord.
Ravi Shankar Shastri.
Yav matter is
Serial number 4, my lord.
4.
Please.
3 and 8.
3 adjourned, my lord.
Yeah.
ಅವರಿಗೆ ಟೈಮ್ ಕೇಳಿದ್ರು 2:30.
Yes.
My lord, survey number 61/2 in Pazir village, my lord, is our Kumki lands of the petitioners.
So is the PDO necessary party?
Yes, is a direction is sought to him, my lord.
Is there no standing counsel?
My lord, actually, for some PDOs, our Sharanji Shetty appears, but he is not the standing counsel for all the PDOs. He only told me, my lord. Wherever, my lord,
The government, now you must see how to serve this person.
PDO.
Huh?
PDO is served and unrepresented.
No, correct, but now we have to get somebody to represent him. Let the government inform through somebody.
Is Panchayat Development Officer, Pazir village, Pazir, Withdrawal Tal.
We have to issue any direction, it should be enforceable. So you get in touch and see that he engages the council. I'll have it next week, just find out. Relist the matter on 3rd of April.
My lord, 1 to 4, I have some personal inconvenience, my lord. May I seek after 7th April, my lord?
8th,
Please. Interim order 2.
interim order in operation is extended till the next day.
Yes. Let my learned friend, my lord, inform. Government advocate.
Yes. Just find out who represents that PDO. You can telephonically inform. Yes.
I will also, because there is a telephone number melody in the letterhead, annexure D. May, how call ಮಾಡಿ side annexure D ಅಲ್ಲಿ ಇದೆ number.
5678 urgent. Serial number 9, Umesh PN.
Petitioner, my lord. The petitioner has been allotted the site as per annexure B. And
Pushpakan 9.
for petitioner,
Yes.
page number 11, man. Annexure B, provisional site has been allotted and he has paid.
No, but the counsel for respondent apparently has stated that you have not served copies on him.
Well, serve my,
Huh? Copy serve ಮಾಡ್ತೀರಾ?
ಕೊಡ್ತೀನಿ sir. Statement.
Relist the matter.
3rd of April. 10, serial number 10. 10 number sub SN.
Correspondent. 3 to 7.
My lord, for the petitioner in this case, my lord, kindly have it on Monday, my lord. There is a,
At
my lord,
request, at request, relist the matter.
3rd of April.
Yes.
grateful, my lord.
11, 12 urgent. 13.
Lord, challenging the annexure R issued by the respondent. I have already served the copy to Regita Devi. Yes. After filing the petition. Lord, I am challenging the annexure R. my
There
lord.
is some confusion. We don't have the writ petition copy. They say it is served. We say it is not served. We'll inquire. We'll take the another copy and appear, my lords.
You give them one more set.
Like, even though, my lord, in the last 2 occasions, they are not never represented before the court, my lord.
We didn't have the petition copy and we assume that it is not served to us.
ಆಯ್ತು ಇವಾಗ ಒಂದು ಕೊಟ್ಬಿಡಿ ಇವಾಗ.
Yeah, in-
Not the short question is, my lord, under your lordship judgment is there. They covered by the judgment, my lord. The transfer of Khata, there is a registered sale deed in favor of us. Lord, in spite of a direction issued by this honorable court, they have given this annexure R, stating that the existence of the property is itself is not existed. My lord, kindly annexure. Annexure J. Lord, earlier to the,
No, now you give a copy,
Please.
you'll have it in the orders list. Meanwhile, you get instruction.
Indeed, my lords, I'll get instructions submitted.
Relist the matter in the orders list on
28.
28th.
much obliged.
Much
14.
obliged.
Umesh PN. Umesh MN.
Appearing for the petitioner, my lords. My lords, I purchased the said property on 21/2004. Thereafter, I have received Khata in my name, my lords. Subsequently, on 21/0/2023, I had applied for e-Khata. Even after given the said representation, the Davangere Mahanagara Palika is not issuing an e-Khata on my name, my lords, and direction may be issued, my lords.
Relist the matter in the orders list on. Now your regular Khata is on the basis of a register.
Register, yes, my lords.
They have not given any endorsement.
No, my lords.
Relist the matter.
First of it. 15. Manian KBS.
Lords, I beg to appear for the respondent corporation, my lords.
My lord, appearing for the fourth respondent, my lord. Kind of
And
wondering,
final
time may
statement.
be given to file objections.
Yes.
Lords, even I will have to file my statement of objections, my lords.
Very simple matter, my lord. There was a application for bifurcation of Khata. 3 brothers had partitioned their property. And I represent the 2 shareholders. And they've constructed buildings in their respective shares. Now, because of the common Khata, the taxes are being paid by us, including for his portion. Now, my lord, as soon as we started construction in 2015, he filed a suit disclaiming the partition there was no written partition, it was an oral partition. He filed a suit for a restraining order and for a partition of the property, which he did not prosecute and was dismissed in 2009. And after 2009, we have enjoyed our respective portions from 2009 onwards, but we've been paying taxes because of the common Khata for all 3 portions.
And my lord, then we applied for bifurcation of Khata, and an endorsement, they obviously sought for objections from the other co-owner, that is the private respondent. He wrote back saying that the suit pending in 2023, when the suit was dismissed in 2009, a representation which is not true. And the corporation, possibly the assistant executive or the ARO, relying upon the reply and the pendency of some suit, rejected our application. So therefore, my lord, there is nothing, everybody has acted on the partition, acquiesced from 2009. There is no, it seems to be a discord in the family and one taking on the other. And therefore, my lord, there's nothing coming in the way of ordering. I kindly see page
So
15.
then what is the difficulty now?
He is opposing.
My lord, without partitioning this property, they have constructed the building. Illegally, they have constructed and filed the suit for partition. The case was posted for evidence of the plaintiff. He was admitted last week. He was unable to appear. Hence, it was dismissed. Taking advantage of that, they completed the construction without giving him a share. It is a commercial come residential. They have taken commercial portion, allotted the residential portion to me.
Now
In spite of my objection, they are telling there was a partition. There is no partition at all.
No, we are not into the merits of it. It's only for the BBMP to respond. We will hear you, but it's for the BBMP to respond.
Yes, yes, I will file my objection, my lord. 1 week time maybe.
No, your inter se rights is a matter that you fight it out in the civil courts. Yes, BBMP, you will have to take your stand.
Please, on 27th or 28th, if I may request, my lords, I'll file it by then, my lords.
Relist the matter on 1st of April.
Great.
16.
For the petitioner, my
What has happened now?
Yes.
Annexure A may kindly be seen. It's a very simple. What has happened is the petitioner owned about 1 acre, 21 guntas. Deputy Commissioner under wide Annexure A granted conversion. ಅದೇನಾಗಿದೆ ಎರಡನೇ ಲೈನ್ ಅಲ್ಲಿ ವಿಷಯದಲ್ಲಿ ಮನೆ ಮತ್ತು ಡೈರಿ ಪೇಜ್ 10 Annexure A. What the Deputy Commissioner has done is granted alienation. That's the Assistant Commissioner. ಅಲ್ಲಿ ವಿಷಯ ಅದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 1 ಎಕರೆ 21 ಪ್ರದೇಶ ಮನೆ ಮತ್ತೆ ಡೈರಿ ಮಾಡಲು ಅಂತ ಕೊಟ್ಟರು. Bifurcation ಮಾಡಲಿಲ್ಲ. So this honorable court passed an order at an earlier point in time at Inc. page 26 Annexure H. They came in appeal. So there was a direction. Inc. page 31 para 6. Writs petition stands disfavored. Liberty to the petition approach Chikmagalur Urban Development Authority seeking permission to use 32 guntas of 69 for residential purpose in terms of the user marked in the master plan. So there was a direction issued to me. In terms of this direction, I have given this Annexure K, Inc. page 35 endorsement, which now before my lords under challenge. Annexure K, Inc. page 35. This is the endorsement. Currently, my endorsement is not the correct as a answer, but other way, Deputy Commissioner should have bifurcated 1 acre 32 guntas. How much is residential, how much is dairy and taman. So we are not the persons who can sit over the Deputy Commissioner's order and say that this area will fall into. I don't have rights under 95, he has the right. So if my lord were to direct me, because 95 I have no power, only under KTCP Act we can take.
Now, what is the endorsement issued now?
Inc. page 35 it starts.
They have sought for a plan.
They have sought for a plan. So what I'm saying is it is 1 acre 21 guntas that you initially had for both that is residential and dairy. You have already sold some extents of land. To this, I cannot do a residential layout plan. To the remaining land, I cannot do a residential. Because if you get the change of land use from the Deputy Commissioner, I will do it, is my stand in Annexure K, which is before my lords.
No, but he has given residential and dairy.
Other residential dairy, yes residential, yes dairy, adanna avaru distinguish ಮಾಡಲಿಲ್ಲ.
So that conversion permits for both residential. Let's assume residential and dairy.
ಮನೆ ಮತ್ತು dairy.
Maybe. Now he's asking for residential only. So there's no demarcation in that order.
ಮಾಡಲಿಲ್ಲ.
So now you give for, if it's permissible for residential, you give it in terms of your master plan. If it's permissible, you give it.
ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಇದೆ.
Then you give
ಮಾಸ್ಟರ್
it.
ಪ್ಲಾನ್ ಅಲ್ಲಿ there is no conflicts of the master plan and the zonal regulation. There is no,
No, then you give it for what he asks.
ನಮ್ಗೇನ್ ಇದಿಲ್ಲ ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್.
So in terms of that, we say and
ನನ್ನ ಅನೆಕ್ಷರ್ ನ ಸ್ಕ್ವಾಶ್ ಮಾಡು, ಅನೆಕ್ಷರ್ ಕೆ ಮಾಡಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ನಾವು ಮಾಡಿ. ನಾಟ್ ದಟ್ ವಿ ಆರ್ ಇನ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್, ಬಟ್ ಇದು ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಬಂತಲ್ಲ, ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮೇಲೆ ಸಿಟ್ ಓವರ್ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಮತ್ತೆ ಅವ್ರ ಮುಂದೆನೆ ಹೋಗ್ಬೇಕಲ್ಲ, ಕಷ್ಟ.
yes. Common man is made to run from pillar to
I understand. ಅದಕ್ಕೆ ನಾನೇ ಸಬ್ಮಿಟ್ ಮಾಡಿದೆ. ನನಗೆ ಅನ್ನಿಸ್ತು ದಿಸ್ ಕೈಂಡ್ ಆಫ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಸೇಯಿಂಗ್ ದಟ್ ನೀವು ಮುಂಚೆ ಉಪಯೋಗಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಸ್ವಲ್ಪ ಅದನ್ನ ಪೇಜ್ 36 ಅಲ್ಲಿ ಲೈನ್ 3
Just read that endorsement.
ಯಾವ್ದು ಸರ್?
Endorsement.
ಅದೇ ಪೇಜ್ 36 3 ಪ್ಯಾರಾ ಲೈನ್ 3 ನಲ್ಲಿ ನನ್ನ ಐ ಪರ್ಸನಲಿ ಫೀಲ್ ದಟ್ ಮೇ ನಾಟ್ ಹ್ಯಾವ್ ಬೀನ್ ಕರೆಕ್ಟ್. ಒಟ್ಟು 1 ಎಕರೆ 21 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಪ್ರದೇಶಕ್ಕೆ ವಿನ್ಯಾಸ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಮಾಲೀಕರು ಅನಧಿಕೃತವಾಗಿ ವಿಂಗಡಿಸಿ ನಿವೇಶನಗೆ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯಿಂದ ಖಾತೆಗಳನ್ನು
You're reading at paragraph.
ಪ್ಯಾರಾ ಇಲ್ಲ, ಪೇಜ್ 36 ಅದೇ ಇಂಪ್ಯೂನ್ಡ್.
Yes, 36.
ಲೈನ್ 2 ಇಂದ ಓದ್. ಮಾಲೀಕರು ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನ್ಯ ಮಂಜೂರಿ ಪಡೆದಿರುವ ಒಟ್ಟು 1 ಎಕರೆ 21 ವಿಸ್ತೀರ್ಣ ಪ್ರದೇಶ ವಿನ್ಯಾಸ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಮಾಲೀಕರು ಅನಧಿಕೃತವಾಗಿ ವಿಂಗಡಿಸಿ ನಿವೇಶನಗೆ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯಿಂದ ಖಾತೆಗಳನ್ನು ತೆರೆದು ಮಾರಾಟ. ಹಾಗಾಗಿ ಅರ್ಜಿದಾರರು ಬಾಕಿ ಉಳಿದಿರುವ 32 ಗುಂಟೆ ಪ್ರದೇಶಕ್ಕೆ ಮಾತ್ರ ವಸತಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ನೀಡುವಂತೆ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಲಗತ್ತಿಸಿ ಕೋರುವುದು ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲ. ಈ ಕಚೇರಿಯಿಂದ ಭೂ ಅನ್ಯಕ್ರಾಂತ ಮಂಜೂರಾತಿ ಪಡೆದಿರುವ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಮಾತ್ರ ವಿನ್ಯಾಸ ಅನುಮತಿ ನೀಡುವುದು ಕ್ರಮವಾಗಿರುತ್ತದೆ. ಸದರಿ ಪ್ರಕರಣದ ಸಂಬಂಧ ಈಗಾಗಲೇ ಈ ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಪ್ರಶ್ನಿತ ಪ್ರದೇಶವು ಮಹಾಯೋಜನೆಯಂತೆ ವಸತಿ ವಲಯದಲ್ಲಿ ಇರುವುದರಿಂದ 1 ಎಕರೆ 21 ಗುಂಟೆ ಪ್ರದೇಶಕ್ಕೆ 32 ಗುಂಟೆ ಪ್ರದೇಶಕ್ಕೆ ಪ್ರತ್ಯೇಕ ಆದೇಶವನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಬದಲಾವಣೆ ಮಾಡಿ ಆದೇಶಿಸಿದಲ್ಲಿ ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಈ ಕಚೇರಿಯಿಂದ ವಸತಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ನೀಡಲು ಕ್ರಮ ವಹಿಸಲಾಗಿದ್ದು ವರದಿ ನೀಡಿದೆ. This may not be correct so far as I am concerned. Okay, I felt.
Yes, the petitioner has petitioner without argument has got relief. Petitioner has sought for setting aside of endorsement at Annexure K 1624, whereby the Chikmagalur Development Authority, respondent number 45
Yes.
has rejected the petitioner's application for residential layout plan with respect to 32 guntas in survey number 69 of Basavanahalli village, Kasba Hobli, Chikmagalur. The endorsement is to the effect that the petitioner had obtained conversion from the deputy commissioner. That order is at page
10 minute. Page 10 annexure A.
Had obtained an order of
Alienation from third respondent assistant commissioner.
had obtained a conversion of agriculture land for non-agriculture purpose, that is dairy and residential purpose, in survey number 69 for an extent of 1 acre 21 guntas, and the deputy commissioner had not demarcated the extent of residential use
request my lords to kindly consider page number 121, my lord, where the issue for determination has been called out. Page number 121, my lord. I will just read it, my lord, because those questions are required to be considered in this case also, my lord. In the bottom, my lords would find the in hanging paragraph issues, my lord. The issue for determination before the Supreme Court were whether a breach of planning authority of its obligation to ensure compliance with building regulation is not actionable at the instance of residents whose rights are infringed by violation of law. I am also in the same position, my lord. Whether sanction for the construction of Tower 16 and Tower 17 by Noida is in violation of distance requirement under applicable building regulation. Third, my lord, whether there was violation of NBR, my lord, Noida building regulation, my lord, that is similar to that of the zonal regulation of BDA, and NBR 2010 in construction of tower in question T16 and T17. Fourth question, my lord, whether there was violation of National Building Code 2005 in construction of T16 and T17. My lord, National Building Code is in the form of a guidelines, my lord, but it has a statutory force because all the zonal authorities have adopted it, my lord. Then, my lord, fifth one, whether the liability of intending promoter to sell apartments of making a full and true disclosure in writing to intending purchaser